All right, good morning, everyone. We are officially online. I apologize for the delay. You tell your family and friends and members of the community they can log on to the computer or log on to the website and start watching the live stream. We are officially there. Um, so to begin with, I wanted to introduce myself. I'm Adam Thorpe. I am the co-chair, the St. Thomas St. John Water Island District co-chair for this competition. Rob, do you want to take a moment to say hi to everyone this morning? You will quickly disappear while dealing with scores all day, so I want to let them meet you at least.
Good morning, everybody. Good luck. I'm sure everybody will do well. And please relax. You've already done so much, so have fun.
Very true, very true. Before we start, I did want to reiterate what the program goals are. We get so wrapped up in this every year. I thought it was worth saying them out loud and reminding everyone.
No, not double-sided tape. Oh,
Jesus. The Moot Court Planning Committee of the Virgin Islands Bar Association runs this competition for the youth of the Virgin Islands on St. Croix, St. Thomas, St. John, and Water Island in grades 9 through 12, and creates the fact pattern and law library from which the students work. The program's learning objectives are pretty straightforward. By hosting this competition, we hope to increase the community understanding of the judicial process and governmental operation, increase citizens' awareness of the roles of the lawyer and a judge, promote the community's awareness of current issues in the law, promote the study of the law, provide the opportunity to develop and advance public speaking and advocacy skills, improve community perceptions of the legal profession and lawyers, and to provide the opportunity to earn scholarships through an academic endeavor. With that, I want to invite the representative of the Virgin Islands Bar Association, Attorney Nisha Christian Hendrickson. She is currently the treasurer of the Bar Association, and she is a past president of the Bar Association. And also, she has a special connection with this program because along with Judge Morris, she constituted pretty much 100% of the Moot Court Planning Committee for the better part of a decade. And so she and Judge Morris were Rob and I's immediate predecessors who ran this program, and it's wonderful to have her back. So Nisha, do you have some comments for the students?
Sure. Good morning, everyone. Thank you, Adam, for that introduction. I'm going to introduce myself a little bit more. As Adam mentioned, my name is Nisha Christian Hendrickson. I'm a past president of the Virgin Islands Bar Association, and currently I serve as the treasurer. I participate in several other boards, two that I wish to highlight today, one being the National Association of State Workforce Agencies, and as a board member of the Board of Trustees at the Good Hope Country Day School. In my day job as the Assistant Commissioner and Legal Counsel of the Virgin Islands Department of Labor, I supervise OSHA, labor relations, hearings and appeals, and workers' compensation. I also work on contracts for legal sufficiency and interpret laws and duties as assigned by the department. Today, I'm going to talk about one thing that if you manage this well, in whatever area of the career or career path that you choose, and of course, we hope you all become attorneys, but in whatever path that you choose, this will help you dramatically. And that thing is stress. I'm sure many of you today worried about your performance and how the competition would affect your future. We all have worries in life. And I'm going to show a very short video. It's going to help to drive home that point. Give me 1 second to bring it up. And we're going to have a few other comments right after that. So give me 1 second. Can you see it? So thank you for watching that short video with me. I'm going to continue my brief remarks. In general, when we have stresses in life, if we continue to hold them and not find a way to put them down, we are not able to be our best selves. And I show you this because stress, anxiety, and depression can cut short your career and even your life. Learning healthy ways like exercise, reading a good book, swimming at one of our beautiful beaches, talking to a good friend, all of those can help you manage your stress. And I know that I can speak for every one who's an adult in the Zoom room that we are here to help you. We want nothing more than to see you succeed. Lean on us, call us, and if we don't have the answer, we'll be able to get you to someone who does. A little worry, as the video mentioned, and holding it for a little while can be healthy, but we must know when to put the weight down. And in closing, I want to thank each of you for taking the time to invest in yourselves. I know there was times, I'm sure, in the preparation for the competition that it was a little stressful and you wanted maybe to stop at some points, but I want to congratulate you for getting to this point. And really, each time you do something like a competition and you invest in yourself, you're going to always be miles ahead of others. So I'm excited to hear who wins this competition. And ultimately, I'm excited to hear who of you are the future leaders of our territory. So I just want to close by saying thank you again to Adam and Rob for the work on this, and of course the guest judges. And I wish you guys a very successful competition today. Thank you so much.
Thank you so much, Nisha. That's a wonderful start. It reminds me of a video I watched. There was a psychologist speaking, and entirely unrelated to law. I didn't expect to learn anything about being a lawyer out of this. She was talking about ambivalent friendships and explains that human beings' mental energy is just like our physical energy. We have a finite amount that we can expend every day. And if we expend it making decisions about who we want to spend time with, because, well, they're nice, but we don't really, and is it really, do I have the, we drain our mental energy. And so the same is true for everything we do. That scene in A Bug's Life always comes back to me when the Hopper's brother goes up to Hopper in the grasshopper bar and says, oh, we should stay here. And Hopper throws one nut at him and it doesn't hurt. And then two of them in succession, it doesn't bother him. And then he buries them and basically kills his brother in all the little nuts that were there that individually weren't a big deal. That's how our brains work. And so it is good to be aware of that and put the glass of water down, as Nisha said. So thank you very much. With that, I would like to turn to my favorite part of the program every year. Judge Lewis is probably our biggest supporter and most enthusiastic, and is always there for the program and ensures that whatever resources we need on St. Croix are provided. And she is always our loudest cheerleader, and she always has wonderful things to say to the students. And so I welcome Judge Wilma Lewis of the District Court of the Virgin Islands.
Thank you. Thank you very much, Attorney Thorpe, and good morning to everyone. It's my great pleasure to welcome you to this championship round of the VI Bar Association High School Moot Court competition, which is now in its 29th year. And it's also a pleasure as well to provide some brief opening remarks. Indeed, I always consider it a special privilege to have the opportunity to lend my voice and lend my support to this event. I say a special thank you to Attorney Rob Kaczynski for his very kind and gracious invitation year after year for me to participate in this manner. My words of welcome come with enthusiasm and excitement. As Attorney Thorpe said, I am a very strong supporter of this event because this moot court competition presents, in my view, such an incredible opportunity for our high school students here in the Virgin Islands to showcase their talent and their abilities. Talent and abilities that are in great abundance in each and every one of our students. And even more importantly, I think that the moot court competition allows our students to benefit immeasurably, both personally and educationally, from this eminently worthwhile experience. So I therefore congratulate and I salute each and every student who has participated in this competition for having taken advantage of this opportunity, even in the face of all of the extra work, the very hard work that we know that you have devoted to this effort. Remember, there's a saying that great opportunities are often disguised as hard work. And you have taken advantage of this great opportunity with all of its hard work. But in so doing, you have broadened your horizons, you have increased your knowledge, you have enhanced your skills, and you have continued climbing that ladder toward your full potential. Those are incredible benefits that you have derived from your participation in this moot court competition. They're incredible benefits that no one can ever take away from you. So having already benefited from this moot court experience in untold ways, and with the additional experience that you will undoubtedly gain from your presentations today, you should take to heart the fact that you are all already winners, regardless of what the actual results may be at the end of the day. So when the end of the day comes, don't hang your heads. Don't hang your heads regardless of the results. Hold your heads high, because we are all very, very proud of this accomplishment by each of you. Now, let me leave you with this final thought. Mary McLeod Bethune was a 20th century educator and civil rights activist. And there's a quote that's attributed to her in which she spoke about having a strong belief in yourselves and in your possibilities. I believe that it is in participating in activities just like this moot court competition that students like all of you start developing what I will refer to as that sense of self, that knowledge of the person who you are, with the talent, with the skills, and with the abilities that you possess. It is that sense of self that will help you to believe in yourselves and in the limitless possibilities that await you. Indeed, I hope this is just one of many such beneficial opportunities that you will avail yourselves of as you continue your educational pursuits. So as I close, I again congratulate and extend best wishes to all of our students. I congratulate as well and thank all who have supported the students in this activity, the teachers, the coaches, the parents, and all others who have lent their support in one way or another. I thank as well our guest judges who will have the very difficult task, I am sure, having previously served in that capacity, to rank and to rate all of the wonderful students who will appear before them today. And finally, I congratulate and I thank the Virgin Islands Bar Association, and particularly attorneys Rob Kaczynski and Adam Thorpe, for their exemplary efforts year after year that make this moot court competition a rousing success. Have a great day, everyone, and thank you all.
Wow, thank you, Judge Lewis. I don't think you could. Did you watch my competition yesterday? Because you really, one of my focuses was that sense of self and building yourself through taking hard work opportunities. And you just, St. Thomas District has to be wondering if we coordinated our notes on this. So, and also, you got off easy. You can ask the judges this year. We redid the score sheets and they're much more detailed and much more involved. And they're scoring out of 100 this year with a lot more to consider. And so wait until your next turn on the bench. You'll have a whole different round of it.
Well, two things, Adam. I guess we're thinking alike then in our thoughts to the group. And secondly, judges, I don't envy you because I know you have a tough task ahead. But all of you will do an extraordinary job, I am sure. So thank you all.
And our keynote speaker is Professor Daryl D. Jackson, and he asked me to say hi to you and that he regrets missing you, but he is on the West Coast while we are in the Virgin Islands, and the timing this morning didn't work.
Well, convey my thoughts to Daryl as well. Thank you very much. It's good to hear from him.
Thank you so much. With that, I want to take an opportunity to talk about something Rob and I, and particularly me, have been avoiding for several years, and that's the reality of succession planning. This is our 5th year. Rob and I are committed for staying on for another year. That will be our 6th. We'll have taken the competition from year 25 through year 30. We'll have grown the competition from having a maximum of 20 people per year to having 50 to 65 a year. We've expanded it to have more schools than we ever had participate annually, and we've now taken in St. John and expanded regular participation on St. Croix. And so Rob has for years wanted to return to coaching. That's always been his passion. Running this program has been second in his priorities. And he just has done it because he felt that giving this opportunity was important. And so we are trying to figure out how to keep the program going without us being the ones in charge, or at least without both of us being in charge. And so with that, we do want to promote the opportunity to serve as a coach. We have a ton of coaches and we always need more, especially on St. Croix. All of the schools on St. Croix every year have students willing to participate, and we never have 100% participation because we lack coaches. There are also members of the committee who we call the executive support branch. They are the ones that keep time and help us compile a law library and serve as moot justices and do any of that. And if you don't have the time commitment for a coaching job, we would gladly take you in there. And we are now looking to expand with assistant co-chairs. There's so much work. We're looking to get 1 to 3 co-chairs in each district, with 3 to 6 total to sort of help with this and potentially allow Rob a successful exit from the program so that he can go on and teach young Virgin Islanders all the skills that all the rest of the coaches teach in here. So if you know a lawyer or a paralegal who would be interested in volunteering, please have them reach out. This has to really try and be our transition year where we bring new people in to that. With that, I would like to turn to what everyone is here for, the introduction of the judges and then the commencement of the competition. So on this year's panel, we have the Honorable Ariana J. Freeman. Judge Freeman is a judge of the United States Court of Appeals for the Third Circuit and was appointed in October of 2022. Before serving on the Third Circuit, Judge Freeman worked as at the Federal Community Defender's Office, ultimately serving as the managing attorney for several years. Judge Freeman is a graduate of Swarthmore College and received her JD from Yale Law School in 2007. Judge Freeman, do you have any comments for the students before we start?
Good morning. Yes, thank you all for being here and participating in this remarkable program. Until I heard of the Virgin Islands High School Moot Court competition, I did not realize that this was something that high school students did. You have done a tremendous amount of work already, and I praise your willingness to do this, and I look forward to hearing everything that your hard work has produced this morning.
Thank you, Judge Freeman. Our next Associate Moot Justice of the morning is the Honorable Kent A. Jordan. Judge Jordan is also a judge of the Third Circuit and has served on that court since his appointment in 2006. Prior to serving on the Court of Appeals, Judge Jordan served as a federal district judge in the District of Delaware. Judge Jordan received his Bachelor of Arts in 1981 and his Juris Doctorate from Georgetown University Law Center in 1984. Prior to being appointed as a federal judge, Judge Jordan served as an assistant United States attorney for 5 years, from 1987 to Judge Jordan, do you have any comments that you wish to share with the students?
Yeah, very briefly. Good luck. I look forward to hearing from you all. This is going to be great.
Thank you. And finally, our Moot Chief Justice, the Honorable Douglas A. Brady. Judge Brady is a judge of the Superior Court of the Virgin Islands, having first been appointed in 2016 and reappointed to a second term. Prior to serving as a judge, Judge Brady maintained a private practice for over 30 years. Judge Brady received his Bachelor of Arts, majoring in sociology. Again, as I pointed out, not a political science major like a lot of us lawyers and judges. He chose something very different than you generally see in our background. And from Wheaton College, he received his Bachelor of Arts, and he received his JD from Columbus Law School in DC in 1976. Judge Brady, do you have any comments for the students before we get started?
Sure. Thanks very much. It's a pleasure to be here. And of course, the last thing you need to hear is from the judges. We're ready to get this thing going. But let me just say, first of all, it's a pleasure and a distinct privilege for me to participate. I'd like to thank the Bar Association for the invitation, but also just for the diligence and putting this on year after year. Past President Christian Hendrickson, thank you. Of course, the present coordinators, attorneys Thorpe and Kuczynski, thank you very much. And the champion of moot court over so many years, Judge Wilma Lewis, thank you so much. It's a pleasure to also thank and welcome Judges Freeman and Jordan, and what a privilege I have and we all have to have these judges of the United States Court of Appeals for the Third Circuit to participate in this event with us. Thanks to the teachers, the school coaches, the attorney coaches who've given up time, to all of the parents and to the schools. I know all of this is an endeavor of the heart and hard work. Especially thank you to the students. Congratulations to all of you who are participating today and who have participated in the sessions before today. You are already all winners. You've already engaged in a lot of hard work. And I hope you have learned and will learn from this experience that there's absolutely nothing that you cannot achieve or accomplish with good purpose and preparation and hard work. Students, the court is proud of you, each one of you, and the community is proud of you. And personally, and I expect to hear great things from you, students, and I hope to see some of you arguing cases in the Superior Court of the Virgin Islands before too long. Today, relax, enjoy this experience. The hard work is behind you, and I wish you all the best. Thank you.
Wow, thank you, Judge Brady. That is a wonderful commentary to open from our Chief Justice of the panel today. So I just want to put out there for all the people watching, The scoring today, the judges are provided a score sheet and they will be evaluating and scoring each student out of 100 points. There are 6 categories on which each student is evaluated. The first 4 categories are evaluated out of 20 points, and the last 2 being more general are each evaluated out of 10 points. The first category is organization and clarity of presentation. The second category is command of factual and legal issues. The third category is the ability to be responsive to the judge's questions. The fourth category is technical delivery of the arguments. The fifth category is an evaluation of the student's prepared arguments. And the sixth category is a general evaluation of the student's presentation. Obviously, that totals 100, and students are individually ranked based on the average of each score the judges get. Each squad is then ranked based on the combined total of the 2 moot litigators' scores. Each student is given 7 minutes to argue, and there is no rebuttal to the argument. The clock begins when the moot litigator begins speaking. It stops when the judge interrupts and asks a question. And the clock begins running immediately when the judge stops speaking. At this time, I would like to introduce Adam Marinelli. He is the timekeeper. Adam, can you say hi and move yourself to the upper screen, and please pin him to the top of the screen. He will be serving for 2 hours and he won't announce the countdown. So you have to have him visible in order to see when the warnings are. Adam?
Good morning, everyone. I don't know how to move myself, Adam. Are you sure I can do that?
No, when you speak, you come to the top and they pin you there.
Got it.
All right, so Adam will hold up. 5, 3, 1, 30 seconds, and time. And with that, I will mute him, and we will, we will turn to the first set of moot litigants from the law firm of St. Croix Central High School, PLLC, representing the appellant. Ms. Alexander and Burley, are you online?
Yes, we are.
All right. Please give your notice of appearance, and please be sure to spell your name so that I can verify the spellings for all the press, and if you win a scholarship that year.
Alexander. My first name is spelled U-N-A. My last name is spelled A-L-E-X-A-N-D-E-R. I attend the St. Croix Central High School and will be addressing issue 1 on behalf of the appellants. Good morning, Your Honors. My name is Bernice Burley. My first name is spelled B-R-Y apostrophe capital N-I-C-E. My last name is spelled B-E-R-L-E-Y. And today I will be arguing issue 2 on behalf of the appellant. Mr. Chief Justice, and may it please the court. This case is about politics, usurping the long-held protections guaranteed persons accused of crimes under the Constitution. Under the Due Process Clause of the 14th Amendment, no person accused of a crime should be convicted except upon proof beyond a reasonable doubt of every element necessary to make up the crime. Any court reviewing a claim for insufficient evidence must ensure that the lower court verdict is supported by a logical connection between the facts offered into evidence and the elements of the crime. But those facts cannot be conjecture, camouflaged as evidence.
Attorney Alexander, what elements of the conviction of Section 481B of Title 14 did the people not prove?
Your Honor, the government based its inferences on facts too weak to prove that Jack was in a public street and 2, lingering for the purpose to engage in underage drinking. As such, we ask this court to reverse the decision of the lower court and enter a judgment of acquittal on behalf of Jack Shepherd. Because there was insufficient evidence to establish that Jack was alongside anything other than a residential road dedicated to persons who live in and around Druids Fancy, the government cannot prove this public road element of each statute.
Well, why don't you, if you could, Attorney Alexander, tell us why the road the police officer was traveling and the road that the defendant was on doesn't constitute a highway or a public street. Why is it not just something we should accept as what the government says it is, a street, cars traveling on it, etc.?
Did we lose Attorney Alexander?
Uh-oh. It might not have been the best question, but I didn't think it was that bad. I didn't think it would stop the whole thing.
Okay, there we go.
Your Honor, Jack was on a private road. There's a Davis test in the Virgin Islands to determine what constitutes a public place. And in this case, Your Honor, a public place is any location that is in point of fact public rather than private, easily accessible and visited by many persons. To prove a place is public, the Davis court said the location must be used by the public in general rather than only the residents nearby. And as this court later said in Powell, a public place may be any private area so long as it is accessible to the public or close to areas used by the public. But not all residential streets are public.
Was this inside or outside the gatehouse? Had he gone outside the gatehouse of the neighborhood?
Yes, he did, Your Honor. But Jack was not on the road. He was on the side of a residential road. In this case, Your Honor, that makes it private. Determining whether any place is public is a fact-specific inquiry. Because there is no definition of what constitutes a public place, we have to rely on the accumulated legal meaning of the term. In this case, both sections 481B and 1191 reference the term a public place, but do not define it. As a result, we have to rely on the accumulated general meaning, evidence, and witness statements to determine whether the area where Jack was found is public or private. As this court mentioned in Wallace, there are several factors to determine what a public place is.
Is the fact that he's outside the neighborhood and he's walking along a road where there's traffic, does that not make it public?
He was not on the road, Your Honor. He was on the side of the road. And in this case, that makes it private.
So if he'd taken one step to the left and been on the road, he'd been in a public street. But the fact that he's one step to the right and beside the road makes it private. That's the position, right?
No, Your Honor. The road will still be private because it is not easily accessible to the public. And in this case, Your Honor, Jack was on the side of that residential road because the factors were the area is not operated or maintained by the government. It is not paved or has street lights. And it does not have speed bumps, Your Honor. Before we get into the facts of this case, let's understand the context in which this incident occurred. Your Honors, this was not about keeping Jack safe. If the officer wanted to keep him safe, he could have driven him home or contact his parents. This was the political opponent's son. The officer and Attorney McCoy used the arrest of Jack to abuse the discretion of their office to promote the political ambition of Attorney McCoy.
How does that get to the questions in front of us? We're talking about the sufficiency of the evidence. It may be that there's questionable motivation here, but But Attorney Alexander, how does what you're saying about the motive of the Attorney General, the prosecuting authority, speak to whether or not there was enough evidence to convict?
Your Honor, there was insufficient evidence. Page 6 of the record shows that Attorney McCoy wanted to be as aggressive as possible towards Jack. Why? Once they arrested Jack, they would use this arrest for his political opponent. They would destroy Jack's father's plan to run for office. Politics affected their application of the law, and that should not happen.
Attorney Alexander, that is not part of the standard with which we review your position, is it? What is our standard of review on your claim that the evidence was insufficient?
Your Honor, to affirm a jury's verdict, a court must find that there was substantial evidence presented at the trial to allow a rational trier of fact to convict the standard of beyond a reasonable doubt, whether the evidence is viewed in the light most favorable to the prosecution. In this case, Your Honor, the court based its inferences on weak circumstantial evidence, Your Honor. When the police...
And that's unrelated to the motive of the prosecutors, isn't it? Or is it not?
It's unrelated, Your Honor. Their motive was purely political. When the officer first stopped Jack, he was 16. The officer could have asked him for an ID or asked him, "Where are your parents?" or merely drop him home, Your Honor. The officer did not. He handcuffed him and threw him in the back of his car, treated as a criminal. They treated a child, Your Honor, as a criminal. That should not be the case. When they manipulated the facts to create an intent for drinking.
How did they manipulate the facts? Explain that. That's a pretty strong charge. Wasn't he yelling party while he was running down the street to a costume party with a bunch of teenagers who were in fact drinking?
You're correct, Your Honor. But Jack just wanted to celebrate his 16th birthday on Halloween. Not because there was kegs of beer at the Moon Tower party meant that Jack, 16-year-old Jack, had the intent to drink, Your Honor. There was insufficient evidence to establish that he was lingering in the vicinity of Judith's fancy with the intent to drink.
Attorney Alexander, what would the government have needed to prove to show that Jack had the intent to drink? What would they have needed to show?
Your Honor, Jack would have himself had to confess that he had the intent to drink. In this case, he didn't, Your Honor. So the government cannot prove that fact of the statute. Your Honors, I see that my time is about to expire. May I conclude?
Please.
Your Honors, we ask this court to reverse the decision of the lower court and enter into a judgment of acquittal on behalf of Jack Shepherd. Thank you.
Thank you, Attorney Alexander.
All right, judges, when you are finished filling out your score sheets, just give me this all good signal and we will have the next competitor go.
Thank you. We're supposed to do the math. Is that correct, Attorney Thorpe? We're supposed to add these up?
Yes, please.
We are able to, I think we have the ability to add as well, but it would be easier to have the judges do the math.
Yeah, I probably should have left that to the one who's in charge of scoring to answer.
So I had my head down. Is that a we do the math or you do the math answer?
Either way, the math will get done, but it's easier we prefer the judges do the math, but
You haven't seen me do math.
can't be any as bad as me.
Lawyers and math, not the good combo.
Okay.
All right, Your Honors, are you all ready?
Ready?
All right, Ms. Burley.
Mr. Chief Justice, I may it please the court. It is far worse to convict an innocent man than to let a guilty man go free. Those words, first spoken by Justice Harlan, capture the impact of a judge's interpretation of a law that impermissibly shifts the burden of proof for each element of a crime from the government to the accused. This undermines the most basic protection afforded to people under the Due Process Clause of the 14th Amendment to be free from arbitrary deprivation of life, liberty, or property. This despite the long-held understanding that the government must prove every element of an offense beyond a reasonable doubt to convict anyone of a crime. And when a judge incorrectly interprets the law, her instructions to the jury can substantially and adversely affect the constitutional rights of the defendant. Because of the court's interpretation of Section 1191, C, D, and E relieves the government of an essential element of the crime in defiance of 1, the rule of lenity, 2, the legislative history, and 3, the rule of impari materia. Mr. Shepard.
What is, Attorney, can you please share with us, Ms. Burley, what is the element you think the government should have proved but was relieved of proving because of what the Superior Court did?
Justice Jordan, the government should have included the missing 5th element, which is seen in Section 1191, subsection D, which states that a law enforcement officer shall give the suspect the opportunity to identify himself and explain his presence and conduct. But in this case, the government failed to prove that 5th element of the crime. Therefore, Mr. Shepard's 14th Amendment constitutional rights have been violated, and as a result, we ask this court to reverse the decision of the lower court and find that the Superior Court did err in its decision. The rule of lenity requires that this court interpret the ambiguous language of the statute when read as a whole to create an additional substantive element that must be proved by the people beyond a reasonable doubt. As
Ms.
this
Burley, I want to take you back to what you said a few minutes ago about legislative history. What is there in the legislative history that makes you say these are affirmative defenses?
Your Honors, the original statute was created in the 1960 enactment. And in the original statute, it included this missing fifth element, which is why I am here today. It included stating that the law enforcement officer shall give the suspect the opportunity to identify himself and explain his account for why he is here. Therefore, if we're going to use that to prove that this legislative history is used to do this, that this is missing the fifth element of the crime. As this court made clear in Willis, when
Attorney Burley, doesn't the fact that the legislature amended the statute and took out that element and put in that language about the seemingly to place the burden on the defendant, doesn't that indicate that the legislature intended to do exactly what the Superior Court determined that the prosecution had to prove, and that this was an affirmative defense?
Chief Justice Brady, this act was repealed in 2019. And Your Honors, this we can interpret as an algebra. We can use a mathematical formula to explain the statute. We can take subsection A plus subsection B, and that equals loitering. Subsection A plus subsection C also equals loitering. Subsection A clearly defines what it means to loiter, and loitering means to stand idly around in a public place with the intent to engage in any one of the listed activities in subsections B and C. The problem with subsection B, Your Honors, is that it's missing this fifth element of the crime, which is shown in subsection D. Subsection B opens with the clause, a person commits the crime of loitering when they engage in gambling, lingering in a public place, prostitution, or the illegal consumption of alcohol. However, without the law enforcement officer, how can we prove that Mr. Shepard had the intent to commit the crime of loitering or any crime as a matter of fact?
Well, under our standard of review, aren't we supposed to draw every inference in favor of the government? Every inference.
Yes, Your Honor.
So isn't there an inference to be drawn from the fact that he acknowledged, he admitted to the police officer, I'm going to the Moon Tower party, and the Moon Tower party was a party at which alcohol was freely flowing?
Your Honors, the police officer arrested Jack before he was able to question him about his intent to go to the party. And remember that Jack was a minor, a 16-year-old minor, and he just wanted to celebrate his birthday party, which was on Halloween.
Well, that's true. He wanted to celebrate. The question is, how did he want to celebrate? Did he want to celebrate with alcohol? And if we're viewing the evidence in the light most favorable to the prosecution, is it not a fair inference that he was going to a party where there was lots of alcohol because he wanted to participate in the drinking of all that alcohol?
Your Honors, this is not why I am here today. That is what my co-counsel, Ms. Alexander, addressed in her case. I am here to prove the crime of loitering, not whether it was Jack's intent to consume alcohol. But without the law enforcement officer, you cannot prove if he had the intent to commit the crime of loitering. Your Honors, the problem with subsection C is that it expresses language which creates a conclusive mandatory presumption in violation of the Winship Doctrine. The Winship Doctrine prohibits the state from using evidentiary presumptions in a jury charge that have the effect of relieving the state of its burden of persuasion beyond a reasonable doubt.
But Attorney Burley, subsection C just indicates that taking flight and prowling in an unusual manner or disguising oneself are only factors to be considered. They're not determinative factors. Is that correct?
Yes, Your Honors, that is correct. But in this case, subsection C renders as ambiguous and unconstitutional because we cannot determine whether in subsections A, subsection B, or even subsection C, whether someone can commit the crime of loitering. It's unclear.
Are you acknowledging then, or are you admitting that the element of for the purpose of unlawfully consuming an alcoholic beverage is part of loitering? I mean, that is part of what you're arguing, right? Or not?
Yes.
You're arguing 1191, and that's an element of that offense, right?
Yes, Your Honor, it is. But in this case, even though it's listed underneath subsection B, we cannot prove that Jack did have the intent to drink alcohol because you need the law enforcement officer to prove to see if that evidence is substantial, which is why we asked to add this missing fifth element of the crime, which again states in subsection D, a law enforcement officer shall give the suspect the opportunity to identify himself and explain his presence on conduct. Your Honors, this is a mandatory
was the
observation.
answer that he gave not an explanation? What when he tells the officer what he's doing, doesn't that satisfy that element?
No, Your Honors, it does not, because there must be an exception to the exception of the crime. We can look at it in pari materia. On page 8 of the record, in section 481B, the trial judge made an exception by adding a fifth element of the crime. The record shows that the court interpreted the exception regarding the child's whereabouts to be an element of the crime to be proved by the government beyond a reasonable doubt. Your Honors, I see that my time has expired. May I conclude?
Yes, briefly, please.
Your Honors, we ask this court to reverse. Thank you.
Thank you, Ms. Burley.
All right. Your Honors, just give me a signal when you are finished scoring.
She sat down and he's looking for us.
We all set?
All set.
All right. All Saints Cathedral School PC, representing the government of the Virgin Islands. Could you please put your notices of appearance on the record?
Good day. May it please the court, I am Layla Evelyn, first name Laila, last name Evelyn. I am with All Saints School, and I am representing the appellee, and I am responding to issue 1.
Good day, may it please the court. I am Kayla Peterson, first name Cayla, last name Pettersen. I am with the All Saints Cathedral School, and I will be representing the appellee on issue 2.
Attorney Evelyn?
Good day, may it please the court. The Moot Superior Court was correct in determining that there was sufficient evidence to sustain a conviction under 1191B5 of Title 14 and subsection 481B of Title 14, and their ruling should stand. As determined by this court in Davis v. the People, when determining whether there was sufficient evidence, this court should conduct a de novo review and look at the evidence that was presented at trial to determine if a reasonable jury could determine that there was evidence of every element of the crime. As your honors consider the evidence that was presented at the Moot Superior Court, your honors should consider the facts in the light most favorable to the government, as this court clearly established that principle in Ponce v. the People. Importantly also, you should allow for all reasonable inferences in favor of the government. I will first outline why Jack Shepard was correctly charged and convicted for being in violation of statutes 1191B5. When looking at the evidence in the light most favorable to the government and allowing for all reasonable inferences, we can conclude that Jack was lingering around in a public place that evening for the purpose of consuming an alcoholic beverage.
Attorney Evelyn, as I understand the facts, Jack was never, when confronted by the police officer, wandering around or loitering around. Rather, he was running, was he not?
Jack Shepard was, in fact, loitering on Highway 751. He was found upon the streets after 10 p.m. He was under the age of 16, and he was unaccompanied by a person legally responsible for him. However, when he noticed the police car, he fled and he started running.
Well, did the facts support that when he noticed the police car, he fled? Aren't the facts quite to the contrary, that he had no idea that it was police cars behind him? He was running to his friend?
No, Your Honor. When looking at the facts in the light most favorable to the government, you can see that Jack Shepard did in fact notice the police car behind him and he fled.
And well, address, if you would, your opponent's argument that this is not a public street. This doesn't fit a key element of either section 1191 or of section 481, because it's just not a public street.
Your Honor, the government provided sufficient evidence to show that Jack was in a public place. Jack was standing on the open public side of a road which borders a gated community.
It's a gravel road, just off the beat, well off the beaten path, isn't it?
Where he was standing is fully accessible to the public and along the police's normal patrol route. The government introduced evidence at trial that he was standing on a road identified on established street maps as Highway 751. Jack was on the public side of the sign, posted outside of the Judith's Fancy Community Gatehouse, clearly outside of the private residential community. Further, Your Honors, in Powell v. the People, it was determined that a public place may also include a private area that nevertheless may be accessible to the public. This space was clearly accessible to the public. This court has clearly stated all the facts that should be interpreted in the light most favorable to the government. Therefore, this court is compelled to accept as fact that Jack was standing on a public road. On the third element of statute 1191B5, for the purpose of consuming alcohol, the government provided sufficient evidence that he was there for the purpose of unlawfully consuming an alcoholic beverage. Even the jury, who had full access to the evidence presented, concluded that he was there for that purpose.
But Attorney Evelyn, since the police officer never gave Jack an opportunity to explain, as 1191D requires, Jack never had an opportunity to explain himself. How does that fit into your argument?
Your Honor, Jack was given an opportunity to explain himself. However, the police officer was not able to initially ask him because Jack fled from the police officer. However, after the officer got the situation under control, he was able to question Jack.
Well, he arrested him before he had a chance to say anything. The arrest was effected first. Does that make any difference?
Your Honor, a factor to be taken into consideration in loitering is if the person flees and if the person is in costume. Jack fled from the police officer, therefore there was no way for the police officer to question Jack. The police officer gained control of the situation and arrested Jack, and then he questioned him.
Attorney Burley, is there any evidence, Attorney Evelyn, is there any evidence in the record that Jack knew there would be alcohol at the party?
Yes, there is, Your Honor. Based on a prior conversation that was held between Jack and his friends Tony and Cynthia, as well as a guy named Dave Wooderson, this conversation happened at the Emporium parking lot. Dave said, and I quoted, that there would be full kegs of alcohol at this party, and Jack was present for this conversation. Therefore, Jack knew that there would be alcohol at this party.
Is it the government's position that anyone who attends a party with alcohol intends to consume the alcohol?
No, Your Honor, but the government was able to prove that Jack had the intent to consume the alcohol. On the third element of statutes 1191B5, for the purpose of consuming alcohol, the government provided sufficient evidence that he was there for the purpose of unlawfully consuming an alcoholic beverage. Even the jury who had—
And that, again, going to Justice Freeman's question, that depends entirely on the court accepting that everybody that goes to a party where there is alcohol intends to consume alcohol. That's the inference that's the inference you're asking us to make, right?
No, Your Honor.
Well, then what else do you have? He knows you've established, and we can accept for the sake of argument, he knows there'll be alcohol there. What do you have? What evidence was put in front of the jury that he intended to drink alcohol? Just because he's a teenager and teenagers certainly drink alcohol?
No, Your Honor. The government was able to prove that Jack knew that there would be alcohol at this party. And when looking at the facts in the light most favorable to the government, you can conclude that Jack Shepard most likely did not have permission to go to this party that had alcohol at it, because no reasonable adults would allow their underage, their minor child to go to a party that was serving alcohol.
Okay, we'll give you that. How does that demonstrate? So he didn't have permission. How does that demonstrate that he intended to consume alcohol?
Well, at this party, there were multiple underage children consuming alcohol, and Jack seemed very excited to go to this party.
Attorney Evelyn, where is a reasonable inference? Where does the reasonable inference end and pure speculation begin with regard to this particular issue? Wouldn't a jury have to speculate that Jack intended to consume alcohol?
When looking at the facts in the light most favorable to the government, we can conclude that Jack Shepard did have the intent to consume alcohol. Despite the police officer reading Jack his Miranda rights and informing Jack of his Fifth Amendment right to remain silent and not incriminate himself, Jack voluntarily responded to the police's question about where he was going. After processing Jack, the police officer went to check out the Moon Tower party and observed a large party that was filled with several alcoholic beverages, underage people drinking, and no one really in costume. It could be argued or reasonably inferred then that the purpose of the party was not really to display costumes, but rather to consume alcohol. So it can be reasonably inferred that Jack was there that night for the purpose of getting a ride to go to a party where he knew there would be alcohol for the purpose of consuming alcohol. Therefore,
Attorney Evelyn, doesn't Jack's costume that he was wearing at the time of his arrest undercut that argument?
Can you repeat that question, please?
Doesn't the costume that Jack was wearing at the time of his arrest undercut the argument that the party was not about costumes, it was about alcohol?
No, Your Honor. Jack was wearing a costume and no one else at this party was wearing a costume. So we can conclude that the purpose of this party was not a costume party, but therefore to go to this party and consume alcohol.
Now, if we accepted that inference is true, going back to what Chief Justice Brady asked you right at the beginning, there has to be a lingering, right? The police officer arrested this fellow almost immediately. Jack got arrested just like that because he was running. How does that fit lingering? How does that fit the common definition of loitering?
Jack Shepherd was lingering on Highway 751 with the intent to go consume alcohol at another location at the Moon Tower party.
Help me with lingering. There's a common understanding of lingering. It means standing around doing nothing. He's not doing nothing. He's running by the side of the road, correct?
Yes, you're correct, Your Honor. But before Jack fled from the police officer, he was waiting in that area for more than 30 minutes.
In that area, or was he waiting inside his own neighborhood at the gatehouse?
He was waiting on Highway 751.
So the position of the government was he was outside the gatehouse the entire time. He wasn't inside his neighborhood.
Jack Shepherd was on Highway 751. I will now address Jack's violation of Statute 481B. As to the first element to be proved under 481B, being under the age of 16, Jack was 15 years old when the police observed him and initiated the stop for illegal loitering. This statute clearly states any child under the age of 16 years, giving credit to the plain language of the statute, means that even if Jack was only a few minutes from turning 16, it applies to anyone, even under the age of 16.
Attorney Evelyn, I'm sorry to interrupt. I see that your time has expired. Could you sum up briefly, please?
Yes, Your Honor. In conclusion, Your Honors, in considering all the evidence that was presented at the Moot Superior Courts and evaluated by the jury before Jack was convicted in the lights most favorable for the government and allowing for all reasonable inferences for the government, it is clear that the Moot Superior Court was correct and their ruling should be upheld. Thank you for your time and consideration.
Thank you, Attorney Evelyn.
All right, Your Honors, just give me a signal when you're finished with your scoring and we will have the next student up.
You want to address the first Central High School though, Adam?
I was going to let them finish scoring first. And Judge Brady. All right, before we advance, I need to put on the record, this is my 7th online tournament, and this is the first time I have made an egregious screw up. But when Ms. Alexander disappeared, it was entirely my fault. I was putting teams in the waiting room and I accidentally moved them. It should not impact her score. I don't believe it did, but to be clear and put this on the record, that is 100% on me.
Understood. Thank you.
I'll say on the record, it certainly did not affect the way I scored.
That's right.
Thank you. All right.
It affected your score though, Adam. Sure.
Yes, I know. My evaluation will go down this year. I'll say it's Ms. Peterson. Are you prepared?
Okay.
All right. When you are ready, please begin.
Good day. May it please the court. Your honors, the Moot Superior Court was correct in interpreting sections 1191 C, D, and E of Title 14 as affirmative defenses. The Moot Superior Court was correct in placing the burden of proof for an affirmative defense on the defendant. An affirmative defense is a defense in which the defendant introduces evidence that is found credible and it will excuse them from being found guilty, like self-defense or insanity. That evidence is to excuse Jack, whereas he otherwise guilty of all the elements of this crime must be brought to court by Jack. As this court held in Wallace versus the People, when interpreting a statute, in our case, determining whether 1191 C, D, and E of Title 14 are affirmative defenses, the court must first look at the plain language of the statute. When your honors look at the plain language of 1191 C, D, and E, you will see that the Moot Superior Court clearly got it correct. 1191 E is clearly drafted as a defense because it states it is a defense for prosecution to loitering. The legislature—
Attorney Peterson, that's certainly correct that subsection E says what you say it says. Subsection D, on the other hand, seems to directly contradict and then says the police officer shall, which seems to put the burden on the prosecution to prove. But a more general question is, in this context, aren't we in essence requiring Jack to prove his innocence by considering this an affirmative defense, that Jack has to put himself in jeopardy and he can't rely upon his presumption of innocence, but he has to affirmatively present evidence or else he's going to suffer the consequences of a guilty verdict?
Yes, Your Honor. Jack did in fact not prove any evidence, and the government did in fact prove reasonable evidence beyond reasonable doubt of every element of the crime.
But my question is, considering this as an affirmative defense, aren't we really requiring Jack to prove his innocence as opposed to him being clothed with the presumption of innocence, and the prosecution has the burden of showing that he indeed did commit the crime charged?
Yes, Your Honor. The prosecution did in fact show that Jack was guilty of every element of the crime that he has committed.
Okay.
Well, let me try it by asking this. Isn't it wrong to tell the government you don't have to show that he's guilty of this offense? He has to show that he's not guilty of it by coming up with an explanation. That seems to be a constitutional problem, isn't it?
Yes, Your Honor, you are correct. And Jack does have the opportunity to show a valid reason in which he is not guilty, but the government did provide sufficient evidence. 11, in the legislature used plain, clear words that are commonly used to create an affirmative defense. Using the rules of statutory interpretation and looking at how 1191 was drafted and what each section says, it is clear that C, D, and E are intended to be read together.
If
Section-
that's true that they're to be read as affirmative defenses, well, maybe I should ask it this way. You said, and quite rightly, that subsection E uses the words, it is a defense. So that's a pretty good argument that that subsection is a defense. But subsection D doesn't use those words, as Chief Justice Brady pointed out. Does the fact that E says it is a defense and D does not say it is a defense make a difference?
No, Your Honor, but as you can see, that section 1191 C, D, and E are to be read together because the plain language is not very clear, and the legislature would then have to look for the intended of the defendants to give them an opportunity to be excused if they show a valid reason.
What language would you point to that shows these three sections are to be read together?
Your Honor, the language that I showed to put that 1191 C, D, and E are to be read together are that the statutory interpretation is like, the rules is like to be commonly because of the constitutional rights, and they all show that Jack was in fact guilty beyond a reasonable doubt of every element of the crime. Section D says the police shall give the suspect the opportunity to identify himself and explain his presence and conduct unless the suspect has fled or another circumstance which makes it impracticable prior to arresting the suspect. We can assume that the legislature, in drafting the statute, did not want police arresting people when they have a valid reason to be somewhere without at least asking them some questions to try to determine if they're loitering first. But Section C gives the police the benefit of the doubt and assuming that the person is loitering, if they take flight upon the appearance of a law enforcement officer, loiters or prowls in a manner not usual for a law-abiding citizen, or manifestly disguises or conceals himself. So we can assume that the legislature understood and allowed for there to be some cases where the police would have to make a decision and arrest without doing the standard question.
So in other words, Attorney Peterson, if I understand you correctly, you're saying, given the fact that the factors in 1191C arguably were present, then the officer can go ahead and make the arrest without paying attention to subsection D, and the factors of subsection C trump the requirement in subsection D that the suspect be given the opportunity to explain himself. Is that what your argument is?
Yes, Your Honor, because Jack was in fact wearing fully clothed dark mask costume late at night outside a private gated community, pacing back and forth in a prowling in a manner that was not usual for a law-abiding citizen, and that he fled from the police, which made him guilty.
And therefore, the officer did not have to give him the opportunity to identify himself and explain himself.
Until he had him secure in the vehicle and handcuffed and was no longer a potential threat. Yes, Your Honor.
Is there any evidence here that indicates that if the officer had just stopped Jack and told him, hey, stand still, I want to talk to you, that wouldn't have happened? Is there anything besides just speculation that shows, they had to secure this guy, they had to cuff him and get him in a police car before they could actually talk to him?
No, Your Honor, because Jack was in fact running away and concealing himself, which made this hard for the police officer to question him until he had him secure in the vehicle.
It is the fact that he was running, that by itself, in and of itself, by the prosecution's lights, is enough to say no opportunity to explain needed to be given. Is that it?
Yes, Your Honor, but the police officer did give Jack the opportunity to allow himself to question why he was doing this late out at night and like why he was waiting there.
But the language says prior to an arrest in subsection D.
Yes, Your Honor, but the police did give the opportunity for Jack to identify himself.
Yeah, but that was after he was in handcuffs. He was already arrested, right? So it wasn't prior to, it was after.
Yes, Your Honor.
Does that matter?
It does in fact matter, Your Honor, but Jack was found in a very traumatic, like in a very upsetting state, because as he was in fact running away from the police officer, and he was in a Boba Fett costume which was covering his face and body. So the police officer was not able to identify him. We understand from this court's ruling in Francis versus Franklin and Sandstone versus Montana, citizens have constitutional rights under the 5th and 14th Amendments to due process and are innocent until proven guilty, and have the right to remain silent and not incriminate themselves. It is not unconstitutional to require an affirmative defense, still requiring the government to make a case on all of the elements, but then allowing the defendant to speak up if they have a valid reason for being excused. In this case, the jury was properly instructed about the government's burden, and there was no burden shifting with regards to who has to prove the basic elements of loitering. The government had to prove that he was guilty of each of the following elements: that he was idly lingering around in a public place for the purpose of unlawfully consuming an alcoholic beverage. Thereby, Jack was guilty of violating Section 1191 of Title 14. The government fully proved all of those elements. The Superior Court judge's interpretation was correct, and the jury instructions were correct, and the government did prove every element beyond a reasonable doubt. Although Jack may otherwise be a good kid, he is still guilty of all the elements determined by the legislature to be loitering. Then the Moot Superior Court was correct in finding him guilty, and this court must not disturb that ruling, as the courts only hold persons to the law as drafted by the legislature.
Did they prove that he was without his parents' permission, or is that just supposition?
Yes, Your Honor, they did prove, because the Jack parents only gave him permission to go out with friends and not to go with friends to a party that minors would be illegally consuming alcohol.
So I don't mean to get back into the sufficiency of the evidence, but were they relieved of was the government relieved of its burden of proof just on the basis of that supposition, or that's really not your issue?
Your Honor, I wouldn't say that isn't my issue, but Jack did have permission from his parents, but not to go out with his friends to go to a party where minors would be illegally consuming alcohol. Your Honors, even if Jack tried to assert that he had permission, we can clearly assume that the permission he had from his parents to go out with friends was not to go to a party where minors would be illegally consuming alcohol. So the affirmative defense would not have been sustained if we look at what the court did in Maricopa County. Even if the jury instruction was wrong.
Attorney Peterson, I see your time has expired. Could you wrap up, please?
Yes, thank you, Your Honor. In conclusion, Your Honors, it is clear that the Moot Superior Court was correct and the ruling should be upheld. Thank you.
Thank you, Attorney Peterson.
All right. So, Your Honors, my first question would be, we are scheduled for a break. It seems that things are going well, but if you want the break right now, we can take it. If you wish to take the break later, we can do that.
I'll defer to my colleagues.
I'll defer to Judge Freeman then.
I wouldn't mind taking a short break.
All right, then let's try and keep it 5 minutes instead of 10, since we got a little bit of a late start.
Good enough.
Thank you. And periodically, we should be scanning and emailing the score sheets.
Yes,
And-
this would be a good time to do your first batch of them, so Rob can start getting them entered and everything.
All right, thank you.
Thank you.
Adam, do we have a new timer coming, or is this my time as well?
I don't know. Let me check the schedule real quick, Adam.
Oh.
Are you
Sorry, I
available to
forgot.
stay on if necessary?
Yeah, if you
Sorry.
need me, I can stay on if you guys need me. Just
Yeah,
let me-
sorry, I forgot I was on mute. You are on until 11:15. Mallory will log on shortly before 11:15.
Got it.
And St. Croix Educational Complex, we are on a short 5-minute break while the judges finish scoring and get score sheets out, at which point we will put your notices of appearance on the record and get going.
Okay, will do. Thank you.
All right. Judges, Moot justices, are you all ready?
Yes.
Awesome. All right. St. Croix Educational Complex, can we please have your notices of appearance on the record? You are still muted. There we go.
Good morning. My name is Kiana Alphonse, and I attend the St. Croix Educational Complex High School.
I can't hear. I'm sorry.
Can you hear me now?
A little better.
Can you move the one of the two closer? The computer or the computer closer to the podium, whichever.
I'll bring the board to pull that closer to.
Just a minute.
Can you hear me clearly now?
Better. Thank you.
Yeah, speak up when you're doing it. You are a bit far away. Also, just to the other people in that room, it is a really bad echo and any single movement is picked up while they are speaking. So you need to be extremely quiet if you're in the background over there. All right, can we please get the notices of appearance on the record?
Good morning. My name is Kiana Alphonse, and I attend the St. Croix Educational Complex High School. The issue I will be addressing is issue 2, and I'm on the appellate team.
Right.
I'm going to need the name again and a spelling.
That is Kiana, K-E-A, N as in Nancy, N as in Nancy again, A. My last name is Alphonse, and that is A-L, P as in Perry, H-O, N as in Nancy, S-E.
Thank you.
Good morning, Your Honors. My name is Alani Arnold, spelled A-L-A, N as in Nancy, I, Arnold, A-R, N as in Nancy, O-L-D. I attend the St. Croix Educational Complex High School, and I am arguing on charge 1.
All right. I guess issue 1, Ms. Arnold, are you ready to argue?
Are you ready to argue?
Whenever you are ready, you may begin.
Your Honors, may it please the court. Your Honor, the case we have presented today is not solely about Jack Shepherd, but about the freedom of movement for all Virgin Islanders to have the ability to go about their normal activities without the chance of being criminalized by police officers. Just as a background, we are talking about a high school teenager, a good student that every Virgin Islander desires, who has interest in computer science, the future of technology, and has the desire to pursue a future in the academic field. This conviction puts a cloud on his future if this conviction is not reversed of charging him for subsection C, D, and E, the intent to consume alcohol and loitering. Your Honor, in defense of my client, I will show where the lower court erred when, by violating his constitutional rights, by placing the burden of proof upon my client and the trial judge erring in terms of jury instruction, which shifted the burden of proof. In doing so, I will reference previous court decisions that have set the standard against shifting the burden of proof to the defendants.
Just so I'm clear, we're arguing at this point, issue number 2, the shifting of the burden of proof. Is that right?
Yes, Your Honor.
Okay.
Your Honor, we submit that the lower court erred when they made the decision to allow Jack to have the burden of proof. Firstly, This act violated his constitutional rights to due process. The well-enshrined Due Process Clause of the United States Constitution clearly provides protection for the accused against conviction except upon proof beyond a reasonable doubt, and ensures that no citizen be deprived of life, liberty, and property.
What's the one thing that you are saying, Attorney Arnold, the government should have proved, but shifted the burden of proof over to the defendant to prove?
Yes, Your Honor. As stated in Balboni versus Ranger, due process rights, both the 5th and 14th Amendment, are applicable to the Virgin Islands. This bedrock.
That I understand, and I apologize. I didn't ask my question very clearly, I guess. You're arguing that they made him prove something, the government did, that the government should have proved. And I'm trying to find out what it is you think that something was. What is it that the government should have proved that they were requiring the defendant, Jack, to prove?
Your Honor, the government had to prove that my client, Jack Shepard, had the intention to consume alcohol at the Moot Tower party. This leads me to address the subsection C, the charge of being considered loitering. When the trial judge instructed that a person commits the crime of loitering when one, the person is dilatory, stands idly around, lingers, delays, or wanders about, remains, abides, or tarries in a public place for the purpose of unlawfully consuming an alcoholic beverage, the application of this law denied Jack due process of law in the violation to the 14th Amendment. To charge Jack on the presumption that he knew the Moot Tower would have alcohol and intended to consume it cannot stand. Your Honor, there is no underlying fact within the fact pattern where the police has proven that Jack had the intention to consume alcohol.
I thought, and I apologize, Ms. Arnold, I thought that the court did instruct the jury that an element of the offense was that he was going to the party for the purpose of unlawfully consuming an alcoholic beverage.
Your Honor,
did the court instruct the jury that that was the government's burden?
the court instructed that it was my client's burden to prove that he was going to the he was or wasn't going to the party to consume alcohol. When the only intention and purpose Jack Shepard had was to wait for his friends to attend a social event.
Attorney Arnold, didn't the court determine it was an affirmative defense by looking at the plain language of 1191E? And doesn't that plain language indicate that that's exactly what the legislature intended, similar to a burden being placed on a defendant to prove self-defense, for example?
Your Honor, by subsection E, it's very subsection E is contrary to what the Supreme Court has established. The Supreme Court has established within Sandstrom versus the state of Montana that regardless of the situation, the defendant must never have the burden of proof. The state brings the accusation and the state must prove its accusation.
So in other words, this statute is unconstitutional on its face, and you're asking us to strike the statute as contrary to the revised Organic Act?
Yes, Your Honor. Where we can say that Jack Shepard had the intention to consume alcohol is if he was near alcohol, had it held in his hand with it open. Then it would be sufficient evidence for the prosecution to prove that then he would have the intent to consume alcohol and commit a crime.
Well, we have a standard of review here, right? And our standard of review requires us to give every reasonable inference to the prosecution. Isn't that true?
Yes, the standard of review, the novo, since this court is on appeal, we're looking at the legal aspects instead of the overall, the decision, the overall case, but only looking at the legal aspects that I'm bringing to you today.
Okay, and so your legal argument with respect to the consumption of alcohol portion of 1191 is what? What is the legal point you're making with respect to that element of the offense?
My legal argument to the consumption of alcohol is that my legal argument is essentially that my client did not have my client had to be given the opportunity by the VIPD officer in the 14th VIC, and that was disregarded, and the police did not abide by protocol.
So it was the failure to give an explanation. That's your real focus, right? They didn't give him a chance to explain, and that was something that they should have done as a matter of the statute. Is that right?
Yes, Your Honor. My client, the police, the VIPD officer has the responsibility to abide by this protocol. My client has the right to the constitutional amendment that he can plead the fifth and remain silent. But the VIPD has to give my client the opportunity. That does not mean my client has to respond.
From the briefing, it looks like the argument from the other side is he had a chance and he did explain. And he said, I'm going to the Moon Tower party. Isn't that adequate to satisfy the statute, and he was given the chance?
No, Your Honor, this is not adequate whatsoever, because the statute clearly states that the police officer must give my client the responsibility prior to being arrested. My client was given this responsibility after he was arrested on the way to the police station. So this does not stand whatsoever. This leads me to address the fact that the prosecution must prove every element of the accusation, not the defendant. In Jack Shepard's case, intent was an element of the crime. Jack Shepard was charged with the intent of consuming alcohol, and in the People's Court, based on a jury instruction, was expected to give the evidence to show his innocence. Within Sanchon versus the state of Montana, the Supreme Court agreed with the lower court. The Supreme Court of Montana agreed with the lower court's decision that some cases do not prohibit the allocation of some burden of proof to a defendant under certain circumstances. However, the United States Supreme Court has rejected such claims. The U.S. Supreme Court has made it clear that when the jury instruction has the effect of shifting the burden of proof away from the state onto the defendant, that goes against the federal constitution due process of law. No doubt, when Jack had to provide some burden of proof that he did not know the Moon Tower party was serving alcohol, and his purpose for being out that night was never to consume alcohol, that ran afoul to Sanchon versus Montana principle. Therefore, this demonstrates that giving Jack the responsibility to prove his intention is completely unjust and unconstitutional, when the Supreme Court overruled this decision in Sanchon versus Montana, the state of Montana. Thirdly, I would like to bring up subsection D and E. Jack was denied due process by the Your Honors, my time has concluded. May I briefly conclude?
Yes, do so briefly, please.
Thank you. Your Honor, this is not a dictatorship country where you must prove your innocence, but this is the United States of America where the due process holds. Your Honors, with this, I submit that the trial court decision should be reversed when the Supreme Court interpreted the statute to place the burden of proof upon my clients. Thank you.
Thank you, Attorney Arnold.
All right, judges, give me the signal when you're done scoring and the next person can begin.
Okay.
All right, it looks like all three are good. Ms. Alphonse, you may begin.
Good morning, Justices. May it please the court.
Yes,
Your
Ms.
Honor,
Alphonse.
Your Honors, the judgment of the Moot Superior Court should be reversed. The people failed to provide evidence of public place, failed to present sufficient evidence of Jack's age, and it also failed to display evidence of Jack's intention to consume alcohol. Here before us is a good, quiet, and introverted student whose future is about to be ruined if this court does not reverse the lower court. It is a young man with a record who will not be able to get scholarships, military, or any federal job.
Attorney Alphonse, excuse me, you said that the people failed to prove Jack's age. And what were the other two issues that people failed to prove?
They failed to prove evidence of public place, and they also failed to prove evidence of Jack's intention to consume alcohol.
Okay, let's talk about the age. What was the evidence regarding Jack's age?
Well, the evidence regarding Jack's age was that they received the testimony that he was under the age of 16. However, Jack was not given the opportunity to show a physical ID or actual birth certificate to the officer to display that that is his actual official age.
Well, isn't it, maybe I didn't understand the evidence, but I thought it was undisputed that he was 15 years old when all this started, and he turned 16 when the clock ticked past midnight. So that he was 15 years old when he was allegedly loitering in his Boba Fett costume. Is that not the state of the record?
Yes, Your Honors. May you repeat the question, please?
Well, isn't it a fact that he was 15 years old when he was waiting along or the side of the road for his friend Cynthia to come get him?
Yes, Your Honors, but the officer would not have known that. The officer only saw Jack at 11:55, so therefore he did not even know Jack was 15 at the moment. If he had asked for an official ID, then it would have been right to say that yes, the officer found official proof of Jack's age.
Does it matter that the officer knows it, or is it enough that it is the fact when it's proven in court?
It matters what the officer's protocol was, and it matters what was proven in court as well. A public place definition, which is taken apart from the Black Laws Dictionary, is known as to which the general public has a right to resort, but a place which is in point public rather than private and visited by many persons and usually accessible to the public. Therefore, Judith's Fancy does not meet the criteria of being a public place. At the time,
Attorney Alphonse, since there is Virgin Islands Supreme Court precedent regarding what is a public place, that's probably where we should look instead of the Black's Law Dictionary. What does the Virgin Islands Supreme Court have to say about what's a public place?
Your Honors, I did not see a listed definition in the statute, but it's more of stating that a public place is where people come to congregate on a daily, but a public street is more on the verge of a street that people use in residential areas versus it being a regular street where people travel on as if it's a highway.
Was there any barrier to the public entering the public street where Jack was found and arrested?
Mary, repeat that.
Was there any barrier to the public entering the street where Jack was found and arrested?
No, Your Honor. There was a Judith's Fancy's gate, but he was already ahead of that. But even in that moment, we are still able to tell that this is a private area, but not an actual private area. But it is not considered public because this is a residential street that you will not see regular people coming on to congregate, because this is the street you would see maybe the people in St. John who are also around the area of Judith's Fancy, where their residential area is to go to their homes.
So do you agree that the evidence is to be considered in the favor of the government when we consider the sufficiency of the evidence?
Yes, Your Honor, the interpretation of the statute.
Okay. Is it, I believe I saw on the record that this road has a street number. I think it's route number 700 something.
791.
Does that tend to imply that this is a public street?
Yes, Your Honors, because we know the government names all our streets and highways, yes. But however, the name has nothing to do with the fact that it was not a regular public street where people just come to congregate. It is not like a public place. It is a street accessible for residential people. Referencing the Davis versus People case, the people could not prove that the area was public, and therefore the defendant could not be charged with reckless endangerment. Therefore, in Jack's case, since the government cannot prove that that street was public place, they cannot convict Jack.
Well, if we thought no, it is a public place, what would your what's your best argument for the assertion that they failed in their burden of proof on a different element of the crime? Is it the consumption of alcohol, or is it some other thing?
It's the proving the evidence of his age and the intent to consume alcohol.
Okay. Turning to the consumption of alcohol, if we view this in the light most favorable to the government, why isn't it the case that if he's running down the street yelling, "Let's party," going to a place where there's going to be alcohol and he knows there's going to be a lot of alcohol, that a reasonable jury could infer he's going to go drink alcohol? What's wrong with that as a reasonable inference a jury could draw? It looks to me like we were frozen.
Can you guys hear me?
I'm sorry. I think we had a little technical glitch and maybe nobody else experienced it. It looked like it froze for a moment.
Yes, your screen was frozen for a second. So please allow an extra 5 seconds on the time.
And go ahead and repeat your answer if you would, please, Attorney Alphonse.
Okay, well, firstly, that reason would not be reasonable to convey that Jack was going to consume alcohol. Number one, they did not even know that Jack did not even know if the party was going to consume alcohol.
Yeah.
Technical difficulties again.
Yeah.
All right, you froze again. Please go.
You can go ahead, Attorney Alphonse, if you can. You seem to be unfrozen again.
Firstly, it was wrong to say that Jack was going to consume alcohol because nowhere in the fact pattern that it stated that Jack even knew the party had alcohol. Number two.
Was he not within earshot of the conversation that his friend Cynthia had with the person who invited them all to the party and said there's going to be full kegs?
Well, if we look at the fact pattern, it stated that the conversation only happened between Dave Witherson and Cynthia, which is Jack's friend. Jack could have been in the area with headphones in his ear, not paying attention to the conversation.
He was in the car, right? He was in the car when this conversation was happening?
Yes, Your Honors.
Okay.
However, that still does not justify the fact that he may have even heard the conversation. He has the right to be in his own world or probably have headphones in his ears. So therefore, we cannot convey that he even knew about the alcohol at the party. Okay. Number two.
Attorney Alphonse, if we're looking though to take all reasonable inferences in favor of the prosecution, doesn't that allow us to reasonably allow a juror to reasonably infer that Jack being present when that conversation took place, it's reasonable to infer that he heard that? And aren't you asking us to speculate that maybe he had earbuds in and wasn't paying attention?
I'm not asking to speculate, but that is still not a reasonable valid because that is not, there's no actual proof that he heard that conversation. And this is not religion. We're not going based off on prophecy or an assumption. You have to be clear on the fact in order to convict someone of it. And we cannot use what an individual is talking about to convey my client because there's no actual statement that.
All right, that's a technical glitch. Let's stop the time and wait till it reconnects. I have to apologize. There are storms passing and it can cause real internet issues. I don't know what St. Croix's weather is, but over here it's not very good.
We're just down the
Reminds
street.
me of last year's problem involving the WAPA outage.
It's sunny in Kings Hill and the complex is just down the street, so.
It is raining in downtown Christiansburg.
Well, no matter what kind of weather you guys are having, it's still nicer to be in the Virgin Islands at this time of year, I'm sure, than it is to be where we are.
Rob, do you have a cell phone or anything? I'm a little concerned that this hasn't reconnected.
Yes, I'll call. They said that the Wi-Fi is off at the school.
Oof.
I can try to call. I'll call the school. Maybe they can finish her argument. How much time is left?
Yeah, Adam, that's what I was gonna ask.
1 minute and 48 seconds.
So close, yet so far.
All right, I'll call Miss Garcia now.
Yeah, if they think it can be fixed very quickly, I think we should finish. But if not, we should move on to the next squad.
Is it possible to just put her on a cell phone that we can hear without?
I will ask.
Yeah, because if they can just talk on your phone, Rob, that would work.
Well, maybe there's a way you can dial into the number too with Zoom.
Oh yeah. Let me pull the Zoom invite info up.
I hate to have her feel like she lost her last couple minutes.
I know. Well, we would let her finish. We would just do it later, but I would much rather do this solution.
They should be online and be in the waiting room, Adam.
Oh, there they. Wait. This is complex. Complex. Yes, admit. St. Croix Educational Complex, welcome back. You have 1 minute and 48 seconds of your time pending. Please take a breath and exhale all of the stress, and the judges will be ready to continue evaluating you when you're ready.
Apologies for the interruption, but right now I would like to reference the U.S. versus People case, in which they were able to tell the defendant did consume alcohol by doing a breathalyzer test. So this is evidence to show that this is valid proof that he did consume alcohol in his blood. Therefore, in Jack's case, he didn't even get to the site. There is no proof that there was no alcohol near him. There was not even an alcohol bottle open in his hand. And screaming "Let's party" is not a crime. Because like I said, he could have been listening to music in his ears and running and, singing along to a song. So it is wrong to just go based on assumption.
Is Attorney Alphonse, is the element of the crime that you have to have consumed alcohol, or is the element of the crime under 1191 that you're loitering for the purpose of unlawfully consuming alcohol?
It is for the purpose of lingering with the intention to consume alcohol.
Okay, so doesn't that indicate that you don't actually have to have succeeded in consuming alcohol? You just have to have that purpose while you're loitering. Isn't that enough?
In a way, yes, but to be precise, no, it's not. Because based on assumption or because the law states with lingering with the intention to consume alcohol, that is down because if that was the case, the officers should have asked Jack, what was he doing there, trying to control the situation before he detained him. I would like to point out that also, he only asked him his intentions after he detained him. He asked him, well, you know, was his situation, and Jack responded with, I'm going to celebrate. He never stated that I'm going to a party to consume alcohol. In the Virgin Islands here, yes, most parties do have alcohol. However, it doesn't mean that everyone there will consume it, and it doesn't mean that every party would have alcohol. Seeing that my time is about to expire, I would like to conclude.
Please do.
In conclusion, we ask the Moot Superior Court to reverse the case because Jack was wrongfully committed. The people failed to provide evidence. Therefore, we respectfully ask the Moot Superior Court to reverse the lower court. Thank you.
Thank you, Attorney Alphonse.
All right, judges, you are used to the drill by now. Let me know when you are finished scoring.
Having no further business before the court, may I be excused?
Yes, you are excused. Thank you for your shift. It's much appreciated.
Thank
We're
you.
losing 50% of the atoms on this Zoom conference right now.
Good luck, everyone. Bye-bye.
Thanks.
Good morning, everyone. Good morning, justices. I'm Mallory Winnie Diaz, and I'm your new timekeeper.
Good morning.
Charlotte Amalie
Attorney.
High School, please make sure and pin Attorney Diaz up so that you can watch the time. Same with the justices.
Attorney Thorpe, it's saying that the host has control of the arrangement. It's fine now because we are seeing the three justices, you and then Ms. Diaz. So we're good for now, but we just don't have the ability to move it.
Oh, let me.
No, it's fine. It's fine. You're good. We actually have it. It's shown perfectly for us on our side. We're good. I'm just leaving you know that we don't have the ability to move it. Is the audio coming from our side clear?
Perfectly clear.
Good.
May I please go, Your Honors?
They haven't finished scoring yet. We'll let you know. All right. All right, looks like we're all good. Yep. All right, Charlotte Amalie High School, please put your notices of appearance on the record. And yeah, okay.
Good day, Your Honors, and all in attendance. My name is Giovanni Jean-Pierre. That is J'_O_VANNY. Last name JNO-PIERRE. From Charlotte Amalia,
Could you repeat that last name, please? I'm sorry, the spelling.
sure, last name JNO hyphen capital PIERRE.
Thank you.
And from Charlotte Amalia High School, on behalf of the people, today I will be addressing the first question on appeal.
All right, can we get your partner?
Good day, Your Honors, and all in attendance. My name is Alondra James. That is ALONDRA James, JAMES, from the Charlotte Amalia High School. I am representing the people of the Virgin Islands, and I will be addressing the second question on appeal.
All right. And just as a note, this team does have an alternate who unfortunately put in all the work but does not get to show us all their accomplishments. Her name is Linnea Herman. Mr. Jean-Pierre, whenever you are ready, you can begin your arguments.
May it please the court? Your Honors, the lower court correctly found that there was sufficient evidence to sustain Jack Shepard's conviction for loitering under Title 14 Virgin Islands Code, Sections 481B and 1191. The Superior Court's ruling should be affirmed for the following reasons. First, Jack Shepard was found on public property while underage. Second, Mr. Shepard showed express intent to violate Section 1191B. And third, the defense had the benefit of needing little evidence but still failed to provide it. To my first point, Jack Shepard was not only found on public property, he was also underage. The side of the appellant might want you to believe that Mr. Shepard was not loitering because he was on private property. But the fact is, Mr. Shepard was about 100 yards away from that gated community where the road is now accessible to the general public. The road on maps and in mapping services and the photos submitted into evidence by the people is listed as Highway or Route 751.
Does it matter that he was, well, I guess I should ask it this way, Attorney Jean-Pierre, he was inside his neighborhood, inside the gated community for most of the time that he was waiting for his friend, wasn't he?
No, Your Honor. Before he even had confirmation from his friend being on the way, he was already outside of Judith Fancy's gate on the public road, which means he was not waiting for someone at the moment.
I might have misunderstood, but I thought he was waiting by the gate for some time and then lost patience and started walking down the road. But assuming he was outside the gate, doesn't loitering require sort of lingering and hanging around? He was actually running to meet his friend when the police saw him and stopped him, right?
To loiter also means to wander about. And before he was running, he was wandering towards the end of the road until he had seen a car he presumed to be his friend's. Then he took flight.
Mm-hmm.
This very court in Wallace v. People stated that Section 3B of Title 20 is an express recognition in the legislature that private roads in this territory are generally only that in title, but in practice public. The opposing counsel may also want to dispute his age. However, the record is clear by a words of implication. First, Shepard's own attorney stated that the appellant was a 15-year-old minutes from turning 16. Second, Section 481 analyzed as a whole was not just a matter of neglect, was not just a matter of loitering while under 16 years old, but a case of parental neglect that causes child delinquency. This extends beyond the age of 16 and until the child has become 18 years of age, placing all minors, including Jack Shepard, fully within the intent of this statute.
Well, if we're going to talk about the intent of the statute talks about under the age of 16. That's textual, right? It's not 18 isn't the operative age, it's 16, isn't it?
In Section 481B it is, but analyzed as a whole, it does pertain to until the child becomes an adult at 18 years of age.
Okay. Now, so are you prepared to concede that somebody who's literally minutes from turning 16 years old is not really the target of Section 481?
No, Your Honors. It is precedent in the Virgin Islands that we look at the plain language of all statutes. The plain language does not give us leeway let's say 5 minutes before or after the child has become of age. Jack Shepherd was committing the crime even minutes prior to his birthday. He was still 15 years.
But after he wasn't arrested until he was 16, isn't that right?
Yes, Your Honor, but he did commit the crime while he was 15 years of age. To my second point, 14 VIC, section 1191B, states the act of loitering includes the act of lingering or remaining in a public place with the purpose of unlawfully buying, distributing, or consuming an alcoholic beverage. The appellant may claim that there is no way of knowing that Jack Shepherd would have committed this crime. However, the record reflects Jack Shepherd was heading to a party stocked full with alcohol. He was heard yelling, "Let's party," while running to the car he presumed to be his friends. And
Now, why is that enough evidence to say he was going to drink? How isn't it? Are you asking us, and did you in fact ask the jury to just speculate that he was going to drink?
Your Honor, on its own, it is not enough evidence. However, paired with the fact that Jack Shepherd had prior knowledge that there would be alcohol at this party, and the record reflects also, Jack Shepherd was not even invited to this party, only Cynthia was. He was actually told to be ditched, but he still wanted to go to this specific party. The people have the right to reasonably infer that he only wanted to go to this party to consume the alcohol.
Well, that's what position, attorney, that anyone who goes to a party where alcohol is being served intends to drink alcohol?
No, Your Honor, but when a minor who's actively searching out parties the entire day of and only resorts to going to this specific party where he knows alcohol is mentioned, it is reasonably inferred that he was going to drink alcohol. Although Shepherd was found in a Boba Fett costume, when the police officer who detained Mr. Shepherd arrived at the location, he did not see any Luke Skywalkers, not even a Princess Leia. The only thing in abundance was alcohol. It is clear from the very beginning that the party's focus was not on the costumes, and Jack knew that from overhearing the conversation Cynthia had earlier that day. The appellant is the son of a very well-known businessman.
Well, your opponents have made the argument that it's just a guess that he overheard the conversation. Is there any evidence that he overheard the conversation?
The fact pattern displays that Jack Shepherd was in the car where the conversation Cynthia had with that older gentleman took place. As I stated previously, Jack Shepherd is the son of a very well-known businessman in our community who plans to vie for the position of governor. This means Mr. Shepherd had every reason to disguise himself. He had a reputation to uphold, and so the head-to-toe Boba Fett costume already in his possession was the perfect thing.
So the assertion of the government is the fact that he chose a Boba Fett costume indicates a criminal intent?
Under section 1191C, it does state, and under subsection 3, to manifestly endeavor to disguise or conceal himself or any object. While he was covered head to toe in a Boba Fett costume, it
was a costume party, right?
It was advertised as a costume fiesta, but with emphasis on full kegs. And as I stated previously, when the police officer arrived at the location, almost no one else was in a costume. To my third point, on appeal, a jury's judgment is not disturbed nor overturned unless there's a lack of sufficient evidence. This is the general understanding in cases within the Virgin Islands and beyond when addressing appeals on this aspect, i.e. Ponce, Powell, Davis, Greer, Wallace, all be people in the Virgin Islands. The jury took 3 days to look at all the evidence presented primarily by the people with little in the way of defense, and this shows a thought out and thorough arrival at a verdict. Though speaking to insanity defenses, Petrick v. People states that it is precedent of this court that only some evidence must be introduced by the defense. This would then require the people to disprove the assertion of the defense. In our case, the defense needed some. Some may be little, but little is more than none. The people also get the benefit of all reasonable inferences. This is a reasonable inference based upon the party and Jack Shepherd's place within the community. Jubilees v. People provides that sufficiency of evidence appeals, though reviewed de novo, is highly deferential to the jury's original verdict. Ponce v. People adds that the people also get the benefit of all reasonable inferences. It is reasonable that as the jury deduced, as anyone would be led to believe that Mr. Shepard was not going to this specific party just to play ping pong or twister, especially when he wanted to do something special for his birthday and was so amped to get to this remote location while disguised.
Isn't it just?
Sorry, could we go back to what you said a minute ago about how the defense needed to produce some evidence? What is your position about what the defense needed to produce at this trial?
Your Honor, I see that my time is about to elapse. May I be granted time to answer your question and quickly conclude?
Yes, go ahead and answer Judge Freeman's question, please.
I believe your question was asking that the defendant had to provide some evidence, at least something. And it is stated that through You Believe v. People, I'm sorry, I misspoke. Patrick v. People states that it is precedent of this court that only some evidence must be introduced by the defense. This would then require the people to provide an assertion to disprove this by the defense. However, the people, I'm sorry, I misspoke again. The people on the behalf of Jack Shepard did not submit any evidence in the original trial. The evidence against Jack Shepard is sufficient on multiple elements as I have illustrated. It is for these reasons that this court should affirm the Moot Superior Court's ruling. Your Honors, thank you for your time.
Thank you, Mr. Jean-Pierre.
All right, give me the thumbs up when you're done scoring. And just a heads up, Mallory and I are in the same office and we are on generator. If the generator fails, we will disappear from here. I don't know why our electricity is out, but usually we don't have an issue with our generator, but anyone who lives in the Virgin Islands knows.
Well, I just put myself on my iPad, so I should be here and won't lose time again. So
Okay.
Hopefully we're going with that backup instead.
All right, good to know.
I just checked the outage meter and it looks like it's a relatively small outage though for you guys.
Oh, good. A small outage that happened to affect the two people helping run this competition.
Unless it's, delayed, but it's only showing a very small outage.
My apologies to Attorney Nopier for not giving the 3-minute time signal there.
May it please the court.
Oh, just wait. We'll let you know.
It just got updated. It looks like it's all of downtown Charlotte.
Oh.
Sorry.
All right, that looks like we've got 3 justices. Charlotte Amalie High School. Whenever you wish to begin.
May it please the court. The Moot Superior Court's interpretation and application of Section 1191 C, D, and E as requiring an affirmative defense in this case specifically is correct for the following reasons. Point 1. While Shepard's explanation at the time was believed, what was found did not dispel any concern. 2. Even if the burden does not entirely shift, some defense must be provided.
Can you explain that? Let me interrupt you. I'm sorry, Ms. James. What's on what? Isn't it just a basic tenet of Anglo-American law that a defendant never has to put on a defense? It's always the government's burden to prove beyond a reasonable doubt the elements of the offense. So on what legal theory do you rest when you say they had to provide something?
Could you repeat your question, Your Honor?
On what do you rely for the assertion that the defendant had to produce something at this trial, had to produce some defense? Isn't the defendant perfectly entitled to say nothing and present no evidence and leave the burden entirely on the government to prove his guilt beyond a reasonable doubt?
Jack Shepard wouldn't have been responsible, but it would have been heavily suggested for at least his parents or his attorney to provide something in his defense if he didn't want to be found guilty. To my first point, Nisby people, Sandstrom v. Montana, and Top v. US note that in some circumstances, the burden of proof can be shifted to a defendant. This is usually looked at as the burden of explanation shifting and not the burden of persuasion, which lies with the people. Top v. US looked at Fong Yu Tin v. US and noted that Tin, having to explain not being able to provide a certificate of residence, did not create an unnecessary presumption or burden on a defendant who would be waiting for deportation.
Is there an element of the offense here that under 1191 that the government should have borne but didn't, namely the requirement to have shown that he was given an opportunity at the scene to explain himself and failed to do so?
Could you repeat your question, Your Honor?
Well, part of the argument we're hearing from the defense is an element of the offense is that the person fails to give a defense or an explanation at the scene when given an opportunity to do so, but that here he was not given an opportunity, and it was for the government to prove that element. Maybe I've misunderstood it, but I take that to be the argument from the defense. I'm asking you to respond to that.
Your Honor, Jack was given the opportunity to explain his actions when the officer asked him what he was doing at that time of night.
That was after he was arrested, right?
Yes, Your Honor.
The statute says in 1191D that the suspect is to be given that opportunity prior to the arrest.
But Your Honor, the thing is with that is that from the officer's perspective, he was seen fleeing, so he wouldn't have needed that. He shouldn't have been given the opportunity, but the officer gave it to him anyway. But in our case, the burden did shift when a defendant, from the perspective of the officer, was costumed, moving rapidly, late at night, in an unusual manner, and was held for questioning by the officer. Flight, unusual behavior, and being completely disguised from head to toe are all considerations outlined in 1191C. Under 1191D, due to the defendant's perceived flight, the officer did not have to provide the opportunity to explain his conduct prior to the arrest. The officer so graciously did so anyway, at the most practicable moment.
What was impracticable about stopping a kid, 15 years old, and maybe by that time, 16 years old? I think it was 16 years old by the time they caught up with him. What was impracticable about just saying, hey, wait a minute, Boba Fett, where are you going?
Your Honor, could you restate your question, please?
Well, your argument appears to be You see, it seems like you're relying on the language in 1191D that says, unless the suspect has fled or other circumstances make it impracticable. I'm trying to ask you what made it impracticable for an officer in a police car, instead of arresting a guy and handcuffing him, putting him in the car, just to say, stop, tell me where you're going.
Since from the perspective of the officer, he was running away, it would have been illogical for him to start shouting, hey, what are you doing? Because for all he knows, he was running away from the gated community. For all he knows, he could have been some robber or some random crackhead who wouldn't have listened to him. Jack truthfully told the officer where he was going. If we look at 14 VIC 1191 subsections D and E, this is a clear shift of the burden of production within the statute. The officer believed Shepard. However, at this supposed costume party, what he saw were teenagers and kegs of alcohol. Your Honor, generally, a keg is defined as a container that stores at a minimum 15.5 to less than 30 gallons of liquid. 30. Might I add that there were multiple kegs and additional bottles at this party? This is a giant red flag. The party's location is
how's it a giant red flag as to Jack Shepard? What if you had a swimming pool full of beer? Why would that make? How would that?
There would be alcohol at this party. He was most likely going for the alcohol since he wouldn't have had any other ulterior motives.
How about just to go and have fun with people he knew without drinking? Don't people ever do that?
Could you restate your question, Your Honor?
Well, you're asking us to uphold a conviction where one of the elements is that he had the purpose of going to drink alcohol, and you're making the argument, it sounds like, that there was lots of alcohol there, and therefore he must have been going to drink alcohol. I'm questioning you about that inference. Why is that a logical inference? Why isn't it just as logical to say, here was a quiet kid who was excited to be with other people on his birthday, and he had no intention to drink alcohol, no matter how much other people were drinking?
When him and his friends were out, they were looking for parties to go to, since they would want to celebrate his birthday and it was Halloween. So they could have gone to any of those other parties that did not have alcohol, but they chose that party specifically. The party's location, the Moon Tower, is the most remote part of St. Croix. This adds another red flag.
Let me just, I'm sorry to interrupt you again, Ms. James, but is there any evidence in the record that there was another party that was an option for him to go to?
Yes, there is, because they had enough time. They would have had enough time to look for those parties while they were out. Subsequently, his lack of parental permission, as my co-counsel alluded to, raises a fourth red flag. It is unlikely that a responsible Caribbean parent would let their child leave the house at around 11 in the night to attend a party that was miles away in a secluded location on Halloween with no objections. Considering his father's social standing and position, he wouldn't let this happen under his watch, since the implications of him being an irresponsible parent could potentially smear his campaign. When the officer returned to the station, he called Jack's parents. The lack of parental explanation when he was picked up, the lack of testimony from his parents in the courtroom, and the lack of testimony or cross-examination of the defense's witness, especially when 1191 D and E provided this at a minimum, shows that some aspect of the burden did in fact shift to Shepard and his legal team. To my second point.
Is there anything to be drawn or understood from the existence of the words, it is a defense in subsection E, and the absence of those words in subsection D of section 1191? Does that indicate that maybe this isn't an affirmative defense?
Your Honor, could you restate your question, please?
Well, you're saying that the burden was on Jack here, Mr. Shepard, the defendant, right? To prove that he had an explanation. But in subsection E, it identifies it as a defense. We'll give you that. But in subsection D, it says virtually the same thing, but it doesn't say it is a defense. I'm wondering whether that absence of the words "it is a defense" in subsection D has any legal import.
Subsection D would not be a defense. If this court finds 14 VIC 1191 to be more investigative, even with the clear language in subsection E that outlines defenses the defendant could use, we should look to Powell v. People. That case notes that if a defendant, through either cross-examination or entering evidence, raises one or more affirmative defenses, then it becomes the people's burden to disprove those affirmative defenses. Let's look at the evidence Shepard's attorney provided in the lower court. Shepard's attorney provided the following. Nothing, Your Honors. In Heinleger v. People, after his confession and in an attempt to suppress the confession, the defense rested. On appeal with no other evidence, all they argued was a statutory interpretation about a comma. That was not enough.
Counsel, is it your position that when an affirmative offense is available under a statute, a defendant must present evidence in support of an affirmative defense?
They do not have to add evidence. They wouldn't have to do that.
Okay.
Also, I see
what
that
significance is it that Mr. Shepard presented no evidence?
Could you restate your
What is the
question?
significance of what you said that Mr. Shepard presented no evidence?
Could you restate your question, Your Honor?
How is it legally significant to your argument that Mr. Shepard presented no evidence in this case?
It's significant because, I'm sorry, could you repeat your question one more time? I'm sorry.
You mentioned that Mr. Shepard presented no evidence in this case. How is that significant to your legal argument?
I see that my time has elapsed. Can I get to my closing, please?
Sure. Did you have an answer for Justice Freeman's question or not?
No, sorry.
Okay.
In closing, even if only a speck of the burden shifted, Shepard and his attorney provided nothing in defense. It is for the stated reasons that this court should affirm the lower court's ruling. Your Honors, thank you for your time.
Thank you, Attorney James.
Thank you. Let us get St. Croix.
They just confirmed.
Oh no, Judge Jordan. So.
Okay.
Oh, wait. All right, so St. Croix Seventh-day Adventist School. Can we get your notices of appearance on the record, please?
Good day, honorable justices and all. My name is Danny Phillip, spelled D-A-N-N-Y. P as in panda, H-I-L-I, P as in panda. I attend the St. Croix Seventh-day Adventist School, and I'm arguing on behalf of the defendant, Jack Shepherd, on issue number 1.
So you're on it. Sorry, Mr. Phillip. So I have this correct. PHI1LIP?
Yes, that is correct.
And you're arguing issue 2?
Issue number 1.
Issue 1. All right.
Good day, honors. Good day, all. My name is Eden Smith. That is EDENSMITH. I'm appearing on behalf of the appellate to answer the second question for this case. I'm requesting that this case, the ruling of this case, be overturned. Thank you.
All right, Mr. Phillip, whenever you are ready, you can begin your arguments.
May it please the court. As all of us have once turned 16, we can relate to Mr. Shepherd's suffering on the eve of his birthday. Imagine yourself as a young man, eager to celebrate your sweet 16th birthday with your best friends, Cynthia and Tony. But instead of it being the pinnacle of your life, it becomes a living nightmare. Having to remember that you were arrested on your birthday for the rest of your life. What would you have to say to your grandkids when they ask you about your 16th birthday? Despite being an admirable young man, Mr. Shepherd has been scarred, and the prosecution is unable to show him what he did wrong to deserve it.
Mr. Phillip, I'm quite sure that this was a traumatic event for your client, but the question remains, what elements did the people of the Virgin Islands fail to prove in that Jack violated both Section 481B and Section 1191B5 of Title 14 of the Virgin Islands Code?
The prosecution did not provide sufficient evidence to convict on either count because it failed to produce any evidence from which a reasonable jury could find that 1. Mr. Shepherd did or intended to consume alcohol. 2. Mr. Shepherd was in a public place. 3. Mr. Shepherd was being dilatory or standing idly or lingering. In addition, Mr. Shepherd, who was only 2 minutes away from turning 60 and was within his neighborhood, was not within the legislature's intent of 14 VIC, Section 481.
Well, he wasn't within his neighborhood when he was arrested, was he? Wasn't he running along a road outside his neighborhood?
In Powell v. People, the Supreme Court of the Virgin Islands stated a public place is defined.
Well, before you tell me about a case, Mr. Phillip, I'm just asking you, as a matter of fact, on this record, wasn't he outside his neighborhood running along a street when he was arrested?
No, Your Honor. He was still in a private place that is still under the jurisdiction of Judith Fancy. As it says in Powell v. People, the Supreme Court of the Virgin Islands stated that a public place is defined as a place to which the general public has a right to resort, is visited by many persons, and usually accessible to the public.
Was the public not allowed to drive along that street?
In the area where Mr. Shepherd was, where he was next to the grass, next to the white fence, walking, the public does not have a right to resort there. Because if I wanted to set up a tent there and stay there, can I? I certainly cannot. Judith Fancy is.
How about the consumption of alcohol? You've said that they didn't prove that either. What's our standard of review? What sort of how are we to look at the proof that was put forth by the government? Don't we have to say it's entitled to every inference in favor of the conviction?
Yes, indeed. This court will review this court case de novo, viewing the evidence in the light most favorable to the people and the benefit of all reasonable inferences. Now, as it relates to your first question on Mr. Shepherd and the consumption of alcohol, since no alcoholic beverages were found on Mr. Shepherd and there was insufficient evidence for a jury to reasonably infer that Mr. Shepherd intended to consume alcohol, because the officer did not know him personally, the prosecution cannot prove either of these.
Well, he was running and yelling, "Let's party," when he was arrested. And then he told the officer he was going to a party where, in fact, people were partying pretty hard with alcohol. From that, is there enough for a jury to infer that he was intending to consume alcohol?
No, Your Honor, because in Patrick v. People, the Supreme Court of the Virgin Islands instructed before a non-expert witness can testify to sanity, they must show familiarity with the defendant. In our case, for the prosecution to prove Mr. Shepherd's intent to consume alcohol, they needed to present evidence of the officer's or somebody's familiarity with the defendant prior to the arrest of being a drinker of alcohol. The prosecution did not do this. However, we know that Mr. Shepherd is a good kid, he's a good student, and does not engage in most of these activities because he stays home all the time. Going back to point 2, Judith Fancy is a private community that charges residents for a private guard at the gate. This guard prevents outsiders from entering or resorting without proper credentials, which prevents many people from entering. However,
was he outside of the neighborhood when he was arrested? Was he had gone past the gatehouse and was running down Route 700 something, wasn't he?
Yes, indeed he was. But the area around the gate is also Judith Fancy's property, and he has a right to resort there because it is a private place and not a public place as it relates to Powell v. People, because the general public does not have a right to resort there. However, Mr.
How far away from the gate does Jack have to get before he's in a public place? He's on Route 751. The map that was admitted in evidence shows that that is a road that the public is entitled to drive on.
Well, Mr. Shepherd was next to the white fence, next to the green class, which is in the vicinity of Judith Fancy Gate. If someone were to walk to the area where a public still has the right to resort and is accessible to them, then that would count as a public place. But where Mr. Shepherd was does not count as a public place, but as a private area. Even considering the evidence in the light most favorable to the people, a reasonable jury could not find that Mr. Shepherd was dilatory or standing still or lingering. The evidence says that Mr. Shepherd was walking/running with the purpose of catching a ride with his friends, Cynthia and Tony. Therefore, Mr. Shepherd was not standing still and was walking.
Mr. Phillip, I understand that Mr. Shepherd was running immediately before his arrest, but I believe the evidence shows that he was standing and looking at social media on his phone in the minutes before midnight when the officer first observed him. Was that enough to show that he was loitering?
No, Your Honor, for 2 reasons. 1, the police actually found him when he was walking. 2nd, Mr. Shepherd was in his own neighborhood with the purpose of catching a ride. which defeats the definition of dilatory. Therefore, Mr. Shepherd was not standing still and was walking with a purpose. The legislative intent of 14 VIC Section 481B was to protect young minors under 60 in public places from the possibility of doing crimes or having crimes being done to them. Interpreting a statute, the Supreme Court of the Virgin Islands stated in Tupingi v. Tyson that the legislative intent must not be undermined when interpreting a statute. In Tupingi v. Tyson, the court determined that Tupingi's income fell within the scope of the legislature's intent for the statute. It is the opposite in our case.
Well, is it the opposite? Here's a young man, if we're viewing the evidence in the light most favorable to the government, who is told that there's a party where there will be lots of alcohol, who is evidently excited to go to the party where there's lots of alcohol, who arranges for a ride to get to the party where there's going to be lots of alcohol, and who is actually running and yelling, "Let's party," at the time he's arrested, trying to get to the party where there's lots of alcohol. What is it in that series of things that fails to meet Section 481B or Section 1191B5? Looks like he's out and out in a public place trying to get somewhere to get alcohol.
That the prosecution did not bring sufficient evidence to prove the intent that Mr. Shepherd would have had to take alcohol. They did not do this. Therefore, they cannot prove that he is going to take alcohol because there is no familiarity that the officer or anybody had with Mr. Shepherd being a drinker of alcohol. The legislature was not trying to protect Mr. Shepherd in 14 VIC. I see my time has expired. May I briefly conclude?
Yes, before you wrap up, tell me about your policy argument. You said that the legislature could not possibly have intended to mean that if somebody is almost is going to be 16 shortly, that this statute does not apply to somebody in that circumstance. That's not consistent with the language of the statute. But you said that that's the legislature's intent, and that's a policy argument, is it not?
Indeed, it is. The legislature intent for the statute was to protect young minors under 16. We're talking about 12-year-olds, 13-year-olds, not minors who are 2 minutes away from turning 16 in their own neighborhoods.
All right. Thank you for that. Go ahead and wrap up if you would, please, sir.
In conclusion, this court must reverse the conviction wrongfully entered against my client, Mr. Shepherd, because the prosecution did not present sufficient evidence to meet its burden. Thank you.
Thank you, Mr. Phillip.
All right, judges, you know the drill. Give me the signal.
Okay.
And then St. Croix 7th Day Litigator Smith. Yes, I will let you know when the judges are ready to hear you. All right, we got three. You may begin your arguments when you are ready.
May it please the court. The Moot Superior Court erred when it forced my client, Mr. Shepard, to use 14 VIC subsections 1191 C, D, and E as affirmative defenses. This was done in violation of his 14th Amendment rights as applied to the Revised Organic Act of 1954. In my argument, I will address why the burden of proof should not have been shifted. What are the differences between 1191 C and D versus 1191 E? And why 1191 C and D cannot be affirmative defenses, and the similarities between 14 VIC subsection 481B and 1190 C as support to my arguments. Because we are in the Moot Supreme Court, this court will view this case de novo and view the evidence in light that is most favorable to the prosecution. Because of the similarities of this case and Gray versus People, case law indicates that legislative intent is a key factor in determining statutory interpretation. On the topic of the burden of proof, before the burden of proof can be shifted onto a defendant, it is the prosecution's duty to establish all components of a charge.
Mr. Smith, doesn't 1191D specifically, I'm sorry, 1191E specifically use language to set up an affirmative defense?
Exactly,
meaning
Your
that the
Honor.
burden is on the defendant.
No, the burden is not on the defendant. In 2019, the original statute of 1191 was revised to be non-ambiguous. When the legislature drafted 1191 C, D, and E, they worded E in a manner that made it a defense. The same is not so for 1191 C and D. While 1191 E is worded, it is a defense of prosecution, which is clearly a defense. C and D are worded in a manner that says, amongst the factors to be considered in determining if a person is loitering, explicitly states that C is a factor, ergo an element to be considered when determining whether or not a person is loitering.
Well,
When
Mr.
the
Smith,
prosecution shows,
Mr. Smith, doesn't that create, in fact, something in the statute that would, at least you said it made it unambiguous. It sounds like it maybe made it a little ambiguous between what C and D mean as compared with what E means. If that's true, don't we have to try to read the statute to harmonize it in some fashion?
Your Honor, when the legislature revised 1191 C, D, and E as affirmative defenses, C and D are worded in a manner that if the prosecution chooses to use them, they become elements of a prosecution, for the prosecution. As elements, it is the prosecution's duty to prove 1191 C and D. In this case, the prosecution chose to use 1191 C as a way to affirm 481B. Once the prosecution chose to use 1191 C, that then 1191 C then became an element to be used by the prosecution. And as an element, it is the prosecution's duty to prove 1191 C, not Mr. Shepard's. On the wording of 1191 D, the statute does say that unless the suspect has fled or in another circumstance makes it impractical prior to an arrest for loitering, the law enforcement officer shall give the suspect the opportunity to identify himself and explain his presence and conduct.
And here your client was fleeing. So doesn't that fit specifically within the language of subsection D that says, unless the suspect has fled?
Your Honors, in this case, according to the officer's testimony, When the police turned onto Highway 751, the officer observed Mr. Shepard walking down the side of the road, not running.
Yeah, but then he started running, and the government's entitled to an inference that he was running away, aren't they?
They are entitled to inference, yes, Your Honor. However, based on the evidence, a reasonable prosecution based off the surrounding inferences, the prosecution cannot conclusively prove that Mr. Shepard was fleeing. That is why 1191D cannot be used as a defense for Mr. Shepard.
Well, what about the other part of subsection D? It says, unless the suspect has fled or another circumstance makes it impracticable. So even if he wasn't fleeing, even if he was just running, didn't that make it impracticable to ask him about what he was doing?
While the statute does mention flight, it is not a key factor in determining loitering. In this case, the wording "or another circumstance makes it impractical." If you look at the surrounding environment of Mr. Shepard, the police were in a cruiser while Mr. Shepard was on foot. When you look at it chronologically, there's no inference that the officers had any problem arresting Mr. Shepard. Using the language from the statute, it states that after the police turned on their lights, they quickly apprehended Mr. Shepard after reading his Miranda rights. So based off the evidence, there's nothing to infer upon that another circumstance made it impractical for the police to arrest Mr. Shepard, Your Honor.
So what is the defense position with respect to what the police officers should have done when they saw somebody in an outfit disguising themselves from head to toe running away from them?
Your Honor, the statute indicates that unless the officer caught the suspect fleeing from an arresting officer, that officer should give a suspect the opportunity to identify himself. This was not the case here. The officer simply arrested Mr. Shepard, put him in the cop car, and then when taking him to the police station, then questioned him about his presence and conduct. This violated the due process clause of the Constitution.
What happens to the presumption then, Mr. Smith? The presumption that that the government is entitled to an inference rather than a presumption, an inference that that somebody running away from them is fleeing from them. That's part of our standard of review, isn't it?
Yes, Your Honor. When you consider the surroundings of Mr. Shepard and his environment, you cannot reasonably infer that he was fleeing from police custody. When you consider his environment in that there are multiple avenues of escape, if he truly wanted to escape, he would have. This is not the case here, Your Honors. On to why 1191C.
Mr. Smith, let me ask, you've differentiated based upon the clear language between C and D on the one hand and E on the other hand. And I take it you concede that subsection E does provide a burden shifting, or at least a burden of production for the defense to present that defense at trial?
Yes, Your Honor.
And your client, your client didn't present any such defense at trial. So couldn't a jury, even if you're right and the trial court was wrong, and C and D were part of the government's burden, but if a jury could reasonably infer, see the facts in the way that the police officer saw them, then the burden under E is on your client to explain himself, is it not, or to present this defense at trial?
Your Honor, as a defendant, it is not the defendant's duty to provide any evidence to the court. It is the prosecution's duty to prove every element of a charge. That is the burden of proof. While the defendant can provide some evidence in that the preponderance of evidence can occur, it is never the defendant's duty to provide evidence of a crime, to defend himself. It is the prosecution's duty to prove all elements beyond a reasonable doubt that the defendant committed a crime. So while E may be used as a defense, Mr. Shepard did not have to provide any evidence to the jury. using the available evidence, it is the prosecution's duty to prove all elements of a charge using the police's perception. Now on to the similarities between 14 BIC 481B. All right. Your Honors, I do realize my time is short. I'll now move on to my conclusion. So in conclusion, Your Honors, the wording of the statutes of 1191 C and D cannot provide a specific affirmative defense. In fact, the wording of the legislation, notably in the case of 1191 D, requires that the prosecution rely on the arresting officer's observation and speculation. In light of the legislative intent of C and D, and that it cannot be proven beyond a reasonable doubt, this court can conclude that the Moot Superior Court erred when it interpreted the statute to place a burden of proof upon the defendant to prove subsections 1191 C and D as affirmative defenses.
Thank you very much, Mr. Smith.
Thank you for your time, Your Honors, and have a good day.
Thank you.
All right, that concludes that squad's arguments. Judges, while you tally, I will get the other squad admitted here. St. Croix, 7th day. All right, so St. Croix, I will move you into the waiting room while you wait for your next round of competition.
Good morning.
Good morning. Can you hear me just fine?
Yes.
All right.
Okay.
We are waiting for the judges to score, and then we'll have you put your notices of appearance on the record.
Thank you, Adam.
No problem.
Thank you, thank you.
And just while we have some downtime to remind you, Sulaine, you guys won't be moved back to the waiting room because this is your one competition. So you can stay in once this is over.
Right, thanks.
The school following Antilles wanted to know if there's going to be a lunch break. Do we know?
I would think most definitely yes. Judges?
I certainly hope so.
Yes,
Okay.
there will be a lunch break. All right, Judge Freeman, you ready?
Yes.
All right, looks like we got all three online. So please put your notices of appearance on the record.
Good afternoon. My name is Angeline Narens. That is Angeline. Last name Narens, Nairns. I attend Antilles School and I will be arguing issue 1 for the appellee.
Good afternoon. My name is Aisha Kimani. That's AISHAKHEMANI.
Can you please give the spelling of your last name one more time, please?
Yes, KHEMANI. I'm from Antilles School, and I'll be representing the people of the Virgin Islands, addressing issue 2 for the appellee.
Thank you.
All right, Ms. Narens, you can begin whenever you are ready.
Okay. May it please the court. The Moot Superior Court should be affirmed because there is sufficient evidence to prove Jack was loitering. because he was found on a public street after 10 p.m. on a night in which he was 15 years old. He fled from police once they arrived at the scene, and he had intention to illegally consume alcoholic beverages. Jack was apprehended on the side of a publicly accessible street outside of Judith's Fancy just after midnight on October 31st for loitering. Jack's 16th birthday was the 31st of October. However, he was loitering in the late hours of October 30th, specifically between 11:25 p.m. and 12:05 a.m. During those hours on October 30th, Jack was still 15 years old.
Does it make any difference that this is a young person who was within literally minutes of crossing the age threshold identified in section 481? In fact, he wasn't arrested until he turned 16. Does that matter legally?
Your Honor, it does not matter what time he was arrested because he committed the crime when he was a 15-year-old. And according to the statute, if you are under the age of 16 when you commit the crime, then you are able to be convicted of loitering.
So the legal position that the territory has is that you can be seconds away from being 16 years old and the cops can get you, and that's what this legislature intended, right? That's the legal position.
Yes, Your Honor, as long as he is 15 years old, he can be convicted of the crime under the age of 16, even if it's seconds or years or minutes.
Okay.
So once the police noticed Jack on the side of the street, they heard him exclaim, "Let's party." And at that exact moment, he began running in the opposite direction of the approaching patrol vehicle. He did in fact notice that there were headlights behind him approaching him, yet he still kept running in the opposite direction. He was on the streets because he was waiting for a ride to the party that was occurring later that night at Moot Tower, and he had intention of being a passenger in the vehicle on the way to this party. And after the police dropped Jack at the station, they decided to investigate into this party that he was going to attend. And upon arrival, they discovered beer kegs and bottles of Crucian rum, along with many young adults and high school students. And it was evident to the police that underage drinking was occurring.
Why does that mean anything about Jack's intent? The fact that other people are drinking and choosing.
The fact that other people were drinking at this party that Jack was going means that the people, according to the binding Virgin Islands Supreme Court case of Ponce versus People, the people are given the benefit to all reasonable inferences, meaning that it is reasonable and legal to assume that since Jack was on the way to this gathering where all of his peers and other young adults were partaking in underage drinking, it is very reasonable to assume that he would also do the same.
Well, that's exactly what I'm trying to ask you. What's the logical inference that says, I guess I should ask it this way. Is it the territory's position that everybody who goes to a party where there is alcohol should be assumed to be going to the party to drink alcohol? That should just be the assumption.
Yes, Your Honor. If everyone at the party is drinking alcohol, it is assumed that everyone who is going to go to the party will also do the same.
Okay.
So 14 Virgin Islands Code, section 481B states that any child under the age of 16 years old found upon or remaining upon these streets or highways after 10 p.m. and unaccompanied by their legal guardian shall be taken into custody. Jack was on a public street outside of Judith's Fancy from 11:25 p.m. to 12:05 a.m. on the night before he turned 16.
Your friends on the other side take issue with the fact that he was on a public street. They say that he was in close proximity to the Judith's Fancy gatehouse. And then even when he left the Judith's Fancy gatehouse, he was not on the street, but rather on the side of the road that cannot be considered a public place. How do you respond to that argument?
Well, Your Honor, it is a public place because it is accessible to the public. In the binding case of Powell versus People, a public place can be defined as a place accessible to the public or a place that is in such close proximity to a public area that any dangerous conduct could harm those in that area. And since Jack was, although he was close to his private gated community, he was still on a street that was accessible to not only the police car, but also his friends that were going to pick him up on that street. He was on a street that was accessible to the general public.
Okay, thank you.
In the binding case of Ponce versus People, the ruling determined that it is necessary to view all evidence in light of the people, meaning that it is necessary to view all of the evidence against Jack in light of the people.
What's the evidence that Jack didn't have permission to go to a party with his friends?
Well, Your Honor, in the fact pattern, there's nowhere that states that he did or did not have permission. We just know that.
And on whom does that fall? Who's got the burden of proof on that piece of the statutory language?
Well, according to the statutory language, in this case, the burden of proof does fall on Jack because all of the provisions in statutes 1191 subsection C, D, and E are to be interpreted as affirmative defenses. So it is on the burden of proof, it falls upon Jack, the defendant.
I might be mistaken here, but I thought that the lack of permission was something that the government had to prove, but you're saying that's not so. He has to come forward and say, "Oh, I had permission." That's the territory's position here.
Yes, Your Honor.
Okay.
Yeah. So upon a police arrival, Jack ran in the opposite direction of the approaching patrol vehicle. 14 Virgin Islands Code Statute 1191, subsection C1 states that a factor to be considered when determining whether a person is loitering is if that person takes flight upon the appearance of a law enforcement officer. So even if Jack didn't know what kind of car was trailing him, it was later discovered to be the police car, and he still chose to run in the opposite direction of the approaching vehicle.
Attorney Nairns, is there any evidence in the record that Jack knew it was a police officer in the vehicle?
No, Your Honor. Jack did not know that it was a police officer, but he was aware that there was a car behind him. And when it approached him and detained him, he did know that it was a police officer.
Right. Does the evidence show that he continued to flee after learning that it was a police officer in the vehicle?
No, Your Honor. That is because he was detained when the police officer arrived to him. Because he illegally ran from the patrol car, there is sufficient evidence to sustain Jack's conviction under subsection 1191 C1.
What made it? You just said he illegally ran. What made his running illegal? Especially if, as you seem to concede, he didn't know it was a police officer.
Well, Your Honor, since he ran from the police car, according to 1191 subsection C1, running from a police vehicle when you're loitering means that you can be convicted of loitering if you do flee from the police officer. So since he did run from the...
Yeah, it says from the appearance of a law enforcement officer. If he doesn't know it's a law enforcement officer, how can he be held responsible for fleeing from a law enforcement officer?
Well, if we look at it literally, we can see that he was running in the opposite direction of the approaching patrol vehicle. So when the law enforcement officer did appear at the scene, he was in fact seen running in the opposite direction. If you may, I'd like to conclude my arguments. I respectfully request the Moot Superior Court affirm the conviction under subsection 1191 B5 of Title 14 and subsection 481B of Title 14.
Thank you, Attorney Nairns.
All right, just give me the signal when you're ready. Ms. Kamani, I will let you know when you can begin when the judges finish scoring. All right, it looks like we got all three ready at the exact same time. Ms. Kamani, you can begin.
May it please the court. Our position is that the lower court was correct in placing the burden of proof upon the defendant to prove subsections 1191 C, D, and E as affirmative defenses. This burden should lay on the defense because, firstly, the provision is not an element of a crime. And secondly, the provisions bear the statutory hallmarks that show the legislature intended for the defense to prove those facts. On the night of October 30th, 2021, a 15-year-old Jack Shepard was seen loitering by a Virgin Islands police officer in the vicinity of Judith's Fancy with the intention of attending the Moon Tower party, a place where alcohol was illegally being distributed to minors. Upon seeing a police car, Jack took flight and was subsequently charged with loitering on the streets and loitering pursuant to 23 VIC 481B and 14 VIC 1191 respectively. We disagree with the defense about the legislature's intent when it pertained to the statutory language.
Ms. Kamani, Attorney Kamani, let me ask you about 1191. Would you agree that 1191E contains the words "it is a defense," but neither subsection C or D contain that language?
I would disagree, Your Honor. While C and D don't specifically use the word defense, subsection C, D, and E all work hand in hand. You can't reach a conclusion on subsection E if subsection C and D aren't proved.
Well, if you at least acknowledge that the words "it is a defense" do not show up in C and D, at a minimum, doesn't that indicate that there's some ambiguity in the statute? If E says it's a defense, but D says almost the same thing and doesn't say it's a defense, how do you square that?
So, Your Honor, I would refer you to the cases Greer versus People and Dupigny versus Tyson, which laid out the process of statutory interpretation. And those cases stated the first thing that we should look at is intent of the law. And since C, D, and E all work together, we believe it was the intent for them to be declared affirmative defenses for the defense.
Attorney Khomeini, wouldn't it be also reasonable interpretation of the statutory intent to just take this plain language of each subsection and leave E alone as a defense to be presented, and the burden in subsection D, that's part of the case, the people must prove that the officer must give the suspect the opportunity to identify himself, and that's part of the people's case, and then the defense can respond to the people's case by saying, yes, but the officer never did give me an opportunity to identify myself and explain. Doesn't that seem to fit better with the plain language of the statute?
Your Honor, subsection D says that unless this is only the case when the suspect has fled. And in this case, our suspect, Jack Shepard, did flee for the police officer, and or even though he might not have intended to at the time, that's all the police officer could see. He was disguised in a Boba Fett costume and he was running away. So he deemed him a threat, and he did give him the opportunity once they were driving in the vehicle to explain his whereabouts. And that's where, when he said he was going to the Moon Tower party, a place where alcohol was illegally being distributed.
But that's after he was already arrested. Your point, I guess, being that even if the officer had given him the opportunity prior to arresting him, then Jack's own words would have been sufficient for the officer to go ahead and make the arrest anyway, because he said, I'm going to Moon Tower.
Yes, and as when he was spotted on the streets, he was 15 years old. And according to the statute, he should have been under the supervision of his parent or guardian or heading home, and his parents should have known where he was. And he did not give that explanation to the police officer. Instead, he said he was going to a party where alcohol was being distributed. Rather than being an element of the crime, the provision before the court today is an affirmative defense. Therefore, the due process.
Which provision is an element of affirmative defense?
All three of them, C, D, and E, they were candidate.
Well, give it to us in plain English. What is it that you assert he was responsible for proving and didn't prove?
He was responsible for identifying himself and explaining his conduct, which he did not prove.
Okay.
That's what.
And is that, now let's assume you're right that the territorial legislature intended to make that an affirmative defense. Is it really the case that you can require somebody to defend themselves? Is it a violation of due process to say you're going to be guilty unless you explain yourself? Or is it always the government's burden to show somebody's guilty whether they explain themselves or not?
So it is the government's it is the government's job to prove if it is an element of the crime. But in this case, it's our position that it isn't an element of the crime, rather an affirmative defense, and therefore the defendant should be required to introduce evidence which, if found to be credible, will negate criminal liability.
But doesn't that fly directly in the face of the presumption of innocence?
No, it doesn't. That would only apply for when it would be an element of the crime. But since it contains the statutory hallmarks seen when the use except is usually used, it indicates traditionally indicates statutory intent to create an affirmative defense. And subsection E specifically calls this a defense, and that's where we're getting the.
Even if your interpretation is correct, that that's what the legislature intended, is the legislature permitted to put a statute in place that flies in the face of the due process rights of a defendant under the Constitution and the Revised Organic Act?
Yes,
requiring that the defendant is not required to prove his innocence, but rather the burden is always on the government to prove the culpability of the defendant.
Yes, Your Honor, they are allowed to make a law like that when it is not an element of the crime. It's not considered an element of the crime. In Maricopa County, a case that discussed burden of proof under similar circumstances, an Arizona Court of Appeals decided whether a juvenile had violated a 10 p.m. curfew. When determining where the burden of proof lies, the court stated a defendant who relies upon an exception to a criminal statute made by proviso or distinct clause has the burden of establishing or showing that she or he comes within that exception. Furthermore, the court stated the state is not required to prove negative statutory exceptions. According to the Arizona Court of Appeals, such exception is a matter of defense where it is not an ingredient of the offense.
Is it the government's burden or the defense's burden to address the question of whether Jack Shepard had permission to be out? And I'm talking about under section 481B.
It's Jack's burden to prove that he had the permission to be out because it is an affirmative defense.
Now, I'm just curious about that because I was under the impression, and I asked Attorney Merritt this as well, that's why I'm asking you, that the jury was instructed that in order to convict, the government had to prove as one of its elements that Shepard was without a legally responsible person's permission to travel to or from his home. That I thought was what was ruled by the Moot Superior Court and not appealed by the government. Now, I might be wrong about that, but if that's true, does that undermine your argument in any way, the argument you're making here today?
No, it does not. It's our position that it's Jack's responsibility to prove that, and he was given the opportunity to prove that, and he did not say anything about being in contact with his parents. And if a police officer is picking you up, the first thing you want to do is be able to, justify that your parents know where you are. Instead, he said he's going to a party where alcohol was later discovered. So, continuing on the Arizona Court of Appeals case, the use of the word "except" makes it very clear. In accordance with the analysis in Maricopa, the defense is required to prove the child was in transit to his home or to a safe place where he would be supervised by adults, and therefore the burden of proof lies on the defendant. Furthermore, it is important to note that the provision contains hallmarks that show the legislature intended for it to be proved by the defense. In the binding VI Superior Court cases, Greer versus People and Dupigny versus Tyson, the process of statutory interpretation was laid out. During the procedure, one should first look for the law's intent. Both courts found that
was the law's intent here to catch some kid who's like 5 minutes from being 16? Is that really the law's intent?
Your Honor, the law's intent is to make sure children are safe, and that was what the police officer followed. He saw a child that was wandering on a road alone at night, disguised in a costume, a child that eventually appeared to be running away from him. I see my time is concluded. May I finish my answer to your question and conclude?
Yes, briefly, please.
And he saw that, considered he was a threat, and he saw that, he was kind of disturbing the peace, and he wasn't safe. He was without a parent or guardian, and therefore he is exactly the type of person that the legislature intended for. In conclusion, I respectfully request the court to uphold the lower court's decision to place the burden of proof upon the defendant to prove subsections 1191 C, D, and E as affirmative defenses. Thank you.
Thank you, Attorney Kamani.
All right. We are, actually, let me admit all of the other schools so they can all hear this. All right, good afternoon, everyone. We are at the lunch break time, and we are actually doing decently in spite of our late start. If it is okay with the judges, I would like to keep it on schedule for our start and return time, but I don't want to rush you if that's, we would be back, everyone joining it around 10 after, and at 1:15 we begin arguments.
That's fine with me.
All right, no one needs anything. I'm happy to give longer. I mean, we appreciate your help, so I don't want to make it awful for you or anything.
See you at 1:15.
All right. All right, everyone, I will see you back at 1:15. Judges, please email the intervening scores during this break.
Will do.
bride.
That is true. But however, he did get the text message that Cynthia would be late to pick him up. With this being said, there was no time that was specified as to whether she was coming right away or an hour away. He stayed there and remained in that area until he became so impatient and so eager to go and drink some alcohol. He walked all the way down Highway 751. So far that our police officer could only see his back. And he was wearing a costume with neon on the top and also the bottom. This shows how far he was and how far he lingered. Similarly, there was sufficient
Attorney
evidence.
Pickering, let me ask, did the people prove, and did the people have to prove that Jack was not in transit from his home to another place supervised by adults with his parents' consent? Was that part of the people's proof at trial? And is that part of the proof that is required of the people to get a conviction for 481B?
Yes, Your Honor. However, he does not have any permission from any legal guardian to go where he was going.
And was that part of the people's case at trial?
Yes, Your Honor.
How was that proof presented?
Your Honor, this defendant had a birthday party and was going to the bowling alley. Initially, that was where he was intended to go with his friends to hang out. However, this party was canceled and then he went back home. After this, the permission to be outside of his home had expired. However, Cynthia planned with him to go outside the guard gate for him to be picked up. Why? Because he did not have permission from his parents to go to this Moon Tower party all the way on the other side of the island.
So you're asking us to assume without any proof that the parents didn't know that he was going to go someplace with Cynthia. Didn't know he was.
No, we are not asking you to assume. We're asking for you to make the reasonable inference that since he did come home after the bowling party was canceled, that his permission to be out his home had expired, and he did not indicate any other asking for permission to go out to this Moon Tower party.
Does he have to indicate that? Does he have to show that? Or do you have to show that he didn't have permission?
We are showing that he did not have permission, Your Honor. Your Honor, I see that my time has expired. May I conclude?
Please do.
Your Honors, we ask this court to affirm the decision of the lower court and find that Jack Shepherd violated both statutes. Thank you.
Thank you, Attorney Pickering.
All right, Mr. Couture, I will let you know when you can begin your arguments once the judges finish scoring. Looks like we have two. Judge Freeman, you finished? All right. Mr. Couture, you can begin when you are ready.
Mr. Chief Justice, and may it please the court. The U.S. Supreme Court has recognized not once, not twice, but time and time again that the 14th Amendment of the U.S. Constitution prohibits any state from depriving a person of liberty without due process of law. This protection guarantees that a state cannot shift to the defendant the burden of proving an element of the crime charged. That is the people's responsibility. However, as this court has shown, when the statutory definition is comprehensive in itself and does not require reference to any exceptions, those exceptions are usually considered as affirmative defenses. This is the case when the language and structure of a statute define a crime so complete as to deem any additional factors listed as descriptive terms rather than additional elements. Because the court's interpretation of Section 1191, C, D, and E relied on the plain language, the legislative history, and the structure of the statute, the lower court correctly interpreted the language thereunder as a statutory exception, distinct from the other provisions that must be proved by the defendant.
Attorney Couture, subsection C and subsection D, the plain language that you're looking at, say nothing about the burden shifting, but rather that appears to be elements that the people must prove. But yet the trial court, and I guess on appeal, you're asking that we concur that somehow C and D get folded into the language of E. Why cannot C and D stand on their own, and it's only an affirmative defense required by the legislature in subsection C, as the plain language says?
Your Honor, if C, D, and E were elements, it would be listed under subsection B. Subsection B lists all of the elements that consider loitering. It explicitly says a person commits the crime of loitering when, if any of the activities such as C, D, and E were listed as such, it would be under B as elements.
But doesn't C really just give further indicator of what factors can be considered to see if any of the subsections of B apply? And then D seems to set a prerequisite to arrest, requiring that the officer give the suspect an opportunity to explain his conduct. Not sure why those, first of all, those don't seem to be parts of the crime itself. And secondly, I don't know why those have to be folded into subsection C as part of the affirmative defense.
Your Honor, subsection C are factors to be disguised, to be fleeing upon the sight of a police officer, or not behaving as a law-abiding citizen. These, in isolation, are not illegal activities. They are suspicious, however. In 1968, the role of the police officer when it comes to identification was in fact an element. However, it was repealed in 2019. Now, this
what should we draw? What inference or conclusion should we draw from that, Mr. Couture?
Your Honor, the conclusion that we should make is that the role of the police officer when it comes to identification is an affirmative defense. It was repealed. That is why. This is the intent. It was intended.
Mm-hmm. And well, let's take a look at subsection D. It says that before there's an arrest, there's supposed to be some opportunity. It says the officer shall give the suspect the opportunity to identify himself and explain his presence and conduct. Now, that didn't happen here, right? That did not happen prior to the arrest, correct?
No, Your Honor.
Okay, but wasn't it incumbent on the government to prove that it did, that opportunity was given? I mean, isn't that there's nothing in subsection D that says defense. It just seems like that says this is what you have to prove, doesn't it?
Your Honor, subsection D is an exception. It explicitly states unless the individual flees or another circumstance makes it impractical. The word unless denotes an exception.
Sure, but it's an exception to the rule that you have to give the person a chance to explain. It says you have to, prior to the arrest, give that suspect the opportunity to explain, unless he's running away, fleeing from you, or it's otherwise impractical. So in the main, the general rule is the territory has to prove that there was an opportunity for the suspect to identify himself and explain his presence and conduct. Isn't that the import of the language?
No, Your Honor. If the government had to prove it, it would be listed under subsection B, where the elements of the crime must be proven by the government. This brings me to the plain language of subsection B. The language under subsection B captures the required elements of the crime of loitering for purposes under section 1191. As this court made clear in Willis, when interpreting a statute, this court's analysis starts with a thorough review on the first canon statutory interpretation. If the language is clear, the inquiry ends. This is because the legislature is presumed to have expressed its intent through the ordinary language of the statute. This court explained in U-Bios that when a statutory definition is comprehensive in itself and does not require reference to any exceptions, those exceptions are usually considered as affirmative defenses and need not be proved by the prosecution.
So why would we assume, or why should we conclude, I should say, that subsection D is not just as much an element as subsection B? It's true it's not listed as one of the 7 things under B, but what is it that should prompt us to say, when the quote, the enforcement officer shall give the suspect an opportunity, close quote, that's not an obligation on the state, on the territory?
Your Honor, if it needs to be proven by the government, it would be under B, yes.
That's the answer, is if it's not under B, it can't be on the government, period.
That is correct, Your Honor.
Counsel, is it your position that if the defendant in this case did not flee and did not make it impracticable for the law enforcement officer to give him the opportunity to identify himself and explain his presence, then that would have been required?
Yes, Your Honor, it would be required.
Okay, so in that circumstance, would it be an element?
In that circumstance, yes, it would become an element to be proven by the government.
Okay, so why is it in any circumstance an affirmative defense?
Your Honor, this is an affirmative defense because it is an exception. The word unless denotes an exception. It is as clear as day, Your Honor. Exceptions are affirmative defenses. Anything not in subsection B is not an element which is an affirmative defense. All elements that must be proven by the government would lie under subsection B.
Is there no reasonable interpretation of the statute that would look at subsection E, where it says it is a defense, and then look at subsection D and notice the absence of those words and say, well, the legislature knew how to identify a defense when it wanted to, and it didn't identify D as a defense. It identified E as a defense. It did not identify D as a defense. Ergo, D is not an affirmative defense. Is that a possible way to read that statute?
No, Your Honor. Subsection E explicitly states defense to prosecution. That means it is an affirmative defense, not an element.
Sure, that I will give you that. The question is, since the legislature demonstrated they knew exactly how to identify an affirmative defense, and they didn't do that in the immediately preceding section, is there no logical inference to be drawn that, well, they didn't intend for D to be an affirmative defense. They intended that to be a burden on the prosecution.
No, Your Honor.
Why not? What work is the word defense doing in E if it's just as much a burden on the defendant in D as it is in E? Is it just an extra word that they put in? I probably didn't ask that question very well, Mr. Couture, so let me try it one more time. Since they went out of their way to say this is a defense when they talked about subsection E, since they didn't say that in subsection D, doesn't that communicate that it's not meant to be an affirmative defense?
No, Your Honor.
Then why not?
Subsection E says defense to prosecution, which means that it's an affirmative defense to be proven by the defendant. Subsection E cannot be an element to be proven by the people. If that's the case, it would be in subsection B. Subsection E also is excluded from the elements of the statute because subsection B is explicitly referred to as an offense. Subsection E explicitly states that it is offense to prosecution under subsection A if the law enforcement officer failed to give the defendant an opportunity to explain his presence of conduct, or that the explanation given is true enough to dispel any concern about his presence on the street. This subsection gives the accused the opportunity at trial to put on a defense where he can dispel any concern or alarm about his conduct on the evening in question. Now we can refer to the legislative history. The legislative history shows that clear intent for subsection C, D, and E to be concerned as affirmative defenses. When the legislature first passed section 1191 in 1968, the legislature was structured different from how it is now. In the version of 1968, there were only 7 ways in which someone could be found loitering. And under subsection 1, it referenced circumstances that must justify suspicion of criminal activity. When the legislature repealed that law in 2019, it clarified that those same circumstances. Your Honor, I notice that my time has expired. May I conclude?
Please do.
We ask this court to affirm.
Thank you, Mr. Couture.
Hey, thank you. St. Croix Central, your arguments are done for the day, so I will leave you in the Zoom conference to observe. And I will add in Charlotte Amalie High School while the scores are being done. 1, 2.
This was Tuesday, apparently. It's correct. That's your problem, not ours. We're right here doing what we're doing. We looking at you.
All right, you ready, Judge Jordan?
Yep.
All right. Charlotte Amalie High School, can we please get your notices of appearance on the record?
Good day, Your Honors, and all in attendance. My name is Shanae Sherville. That is Shaynee, accent on the first E. Sherville, Cherival, with the Charlotte Amalie High School, and I am representing the people of the Virgin Islands, and I am arguing the first question on.
Can you give me your last name again, please? Just a little slower.
Sorry, that is Sherville, Cherival.
Thank you.
And I will be arguing the first question on appeal, whether there was sufficient evidence to uphold a conviction under 481 and 1191.
Good day, Your Honors, and everyone in attendance. My name is Kimaya Solomon. That is Kemiah. Last name Solomon, Solomon. I am from the Charlotte Amalie High School, representing the people of the Virgin Islands and also answering question 2.
All right, Ms. Sherville, whenever you are ready, you may begin your arguments. We can't hear you.
May I ask who the timekeeper is?
Right there, Jacob.
Thank you. May it please the court? Your Honors, a jury found Jack Shepherd to be an unaccompanied 15-year-old out past the hour of 10 p.m. in clear violations of Title 14 Virgin Islands Code, Section 481. They also found he was loitering for the purpose of consuming alcohol in violation of Title 14 Virgin Islands Code, Section 1191. They convicted on both counts. The jury's determination and the Superior Court's ruling should be affirmed for the following reasons. Evidence and inference sufficiently shows Jack Shepherd at the age of 15 was out of his house past 10 p.m., lingering and wandering for the intent of consuming alcohol while underage. He was unsupervised, nor was he given permission or under the direction of a legal adult at that time.
How do we know that he was not given permission?
Your Honors, as stated in Ponce v. People, the people have the right to all reasonable inferences. So considering the fact that neither of his parents nor his attorney attest the fact that he had consent from his parents, we have all reason to believe that he was out without their knowledge or consent.
Isn't that a violation of the Fifth Amendment to say, because you didn't say you did have permission, we can assume you didn't? I mean, that's putting the burden on him to come forward with evidence when I thought the burden was always and forever on the government to prove its case beyond a reasonable doubt.
Your Honors, while Jack was not under any obligation to attest that his parents had given him permission, in his defense, his attorney could and should have opposed that.
I'm still not sure I understand. if the burden is on you to show he didn't have permission, are you saying it's enough if you say, well, they didn't say that he did have permission? Is that the legal position you're taking?
May you rephrase your question, Your Honor?
Well, it sounds like the legal position you're taking is that it was his burden to come forward and prove he did have permission, when I thought it was part of your burden under section 41B to come forward and show he wasn't given permission. Now, straighten me out. I guess what you're saying is, no, we didn't have to show that. He had to prove he did have permission. Have I understood that right?
No, Your Honors. I am simply saying that using the right that the people have to make reasonable inferences and view the evidence presented in the light most favorable to the people, we can conclude that he was out past 11 p.m. without the permission of his parents.
But then what is the evidence that's in the record from which the jury could draw a reasonable inference that his parents did not consent to where he was?
Your Honors, a fact that could be argued that could be argued as to why we have concluded that he did not have evidence, that he did not have permission from his parents, could be the fact that we are here today, Your Honors. If his parents had in fact given him permission to be where he was or go where he was going, it is very likely that Jack would have attested that in court, or his attorney would have attested that in court, and he would not be convicted under 481. Your Honors, we have all reason to believe that Jack was out past 11 p.m. for the purpose of consuming alcohol. To state the facts, Jack Shepard, an introverted homebody, wanted to do something special for his 16th birthday. In doing so, he and his two friends purposefully sought out parties happening around that time and caught wind of a costume fiesta and were informed that there would be alcohol present. He later got home and, after getting dressed, went out of his house an hour after 481's curfew, unsupervised. He then idled and wandered along the side of the road from 11:25 to 11:55 for a ride to a venue that would still be at least another 30 minutes away.
Can I stop you there? Because I might have the facts wrong, but I thought that for most of that time, maybe all of that time you've identified, he was hanging around the guardhouse at the entrance to his residence. He wasn't out on the road. He was sitting near the guardhouse checking social media. Have I got the facts wrong?
Your Honors, while it is stated that Jack did stay close to the guardhouse for a short period of time, it is also stated that he soon got bored and wandered along the side of the road, moving away from the Judith's Fancy guardhouse, placing him on public road.
Sure, that did happen at some point, but does the timing matter here? I mean, assume he had stayed inside his neighborhood the whole time, you couldn't say he was in a public place at that point, would you? Or could
No,
you?
Your Honors, because Judith's Fancy is seen as private property.
Okay, so if he'd walked outside 1 minute before the police apprehended him, and he was out there for 60 seconds, could you be making the argument that he was loitering?
May you repeat your question, Your Honor?
Well, I'm asking you to assume, for the sake of discussion, that he did stay inside the guard shack until just 1 minute prior to the time that the police apprehended him. He'd walked out and they captured him just that fast. You couldn't say he was loitering in a public place on that kind of timing, could you?
No, Your Honors, because if he had stepped right outside Judith's Fancy guardhouse, that could still be seen as private property. But Jack, however, wandered past the Judith's Fancy guardhouse, past the roundabout, which is there for the public's convenience.
Yeah, so the question I'm trying to get to is, how long does he have to be out there before it becomes loitering? You've agreed that if it was 1 minute before he was arrested, it wouldn't be loitering because it wouldn't be enough time. So how about 3 minutes, 4 minutes, 5 minutes? How long does he have to be out there near the road before the territory would say, okay, now it's no longer him not loitering, it's him loitering? What's the time frame?
Your Honor, I do not believe this is a matter of time. I believe this is a matter of distance that he had from the Judas Fancy Guardhouse, which occurred over a course of a half an hour.
Okay.
Shepard waited patiently on the side of the road for half an hour and at the first light of an oncoming vehicle, yelled, "All right, let's party," as he ran towards his supposed ride. Opposing counsel may say that Shepard was excited to show off his costume or socialize or make new friends. It should be noted that Shepard attended annual comic conventions and his birthday falls on Halloween. He had multiple opportunities to wear his costume, have fun on his birthday, many of which would not have involved him out of the house an hour past 481's curfew in an attempt to attend a party in a remote location where copious amounts of alcohol would be present that was unbeknownst to the police. To my second point, Your Honors, the people have little to no reason to believe that Jack was under the direction or had consent from his parents or any legal adult. Very few parents would let their teenager leave the house past 11 p.m. to attend a party in a remote location on the eve of Halloween, much less a politician with a reputation to uphold.
So,
Again,
counsel,
yeah.
I'd like to ask you a little bit about his intent to consume alcohol. What is your best evidence that he had an intent to consume alcohol?
Your Honor, the fact that he was aware of there being alcohol at the party, not to mention his uncharacteristic excitement and dedication to attend this party, despite his history of staying home and watching TV or hanging out with his two friends, is enough reason for the jury, for the people, to make a reasonable inference that he had intended to consume alcohol at this party. Your Honors, if Jack's parents had knowledge of his plans, they would have expressed their consent to him being out at the station or in court. Furthermore, upon the officer's questioning in the car, Jack would have told the officer that he had permission to go to the aforementioned party if he had it. Considering the location and nature of the party and his seemingly newfound affinity for delinquency, it is very likely that Jack's parents did not know the nature of the party or his plans, or was not provided truthful or sufficient context.
Ms. Charaval, is very likely enough when it's your burden to produce evidence and to prove to a jury beyond a reasonable doubt every element?
Yes, Your Honor, because all evidence and inferences should be seen in the light most favorable to the people.
Right, but what is the actual evidence that you're pointing to that he didn't have his parents' permission?
Your Honor, the fact that his parents did not attest to him having permission, that they did not give any statement to him having their consent when they picked him up at the station or when they were in court beside him.
So it's the silence. It's the silence of Jack and his parents that is the proof you rely on.
Yes, Your Honor.
Yeah. How about the public place part of this? And I'm curious, since it says he sat down on the side of the road near the grass by the fence to wait for Cynthia. That's the factual record we have. Does that mean he was sitting down near the gatehouse?
That can be inferred, Your Honor.
Okay.
But
if he's near the gatehouse and that's where he's sitting from 11:25 to 11:55 until he gets the next text, he's still on private property, isn't he?
Your Honors, Jack did not remain by the Judas Fancy Guardhouse for the entire 30 minutes. I see that my time is about to elapse. May I be granted time to conclude?
Sure, you can answer that last question if you like, and then you can conclude.
Yes, Your Honor. Your Honor, as I stated, Jack did not remain by the Judas Fancy Guardhouse for the entirety of the half an hour he was waiting for Cynthia. It is on record that he, in fact, wandered past the Judas Fancy Guardhouse and passed the roundabout, which is there for public convenience, placing him on public road. To conclude, the evidence is sufficient on all elements, and it is for these reasons that the court should affirm the Moot Superior Court's ruling. Your Honors, thank you for your time.
Thank you, Attorney Sherrill.
All right, Lydia Solomon, you can come to the podium and get ready. I will let you know when you can begin speaking.
May it please?
Nope, we're still waiting for one. All right, looks like we're all good to go. You can begin when you are ready.
May it please the court. In many cases, and based upon certain aspects of statutes, the burden of producing information that can show a defendant is innocent or to clear up confusion can, and in our case, did shift to the defendant. The Moot Superior Court's interpretation of Section 1191 C, D, and E is correct and should be affirmed for the following reasons. Jack Shepherd's intention might not have been to flee from the officer, but the officer made a justifiable inference when arresting him. If Jack Shepherd was headed to a costume party, within a full costume party, then when upon arrival, the officer should have seen costumes, but the officer didn't testify as such. The only thing that was seen was alcohol, and this did little to dispel any concern or alarm. To my first point.
Does that make a difference in what's in Jack Shepherd's mind? It's not what's in the mind of everybody else at the party. It's what's in Jack Shepherd's mind that matters, right? What his intent, what his purpose in going to the party was is what counts, isn't it?
Your Honors, the only thing that was emphasized when Jack Shepherd heard about the party, it was characterized as a costume fiesta, but the only thing that was emphasized was the alcohol. 1191 Section D states that unless the suspect has fled or another circumstance makes it impractical prior to an arrest for loitering, a law enforcement officer shall give the suspect the opportunity to identify himself and explain his presence and conduct. As stated in Heiliger v. People and Greer v. People, if the legislative intent is clear from the plain language of a statute, no further inquiry is necessary. Upon the view of the police officer, Jack Shepherd was running away from a private gated community covered from head to toe at the late hour of the night after curfew, unaccompanied by an adult.
Did Jack Shepherd get a chance to explain himself before he was arrested?
No, Your Honor. Proper police work states that an officer, if he sees a situation that is out of hand, he must assess the situation, get control of said situation, and then ask questions.
Is it your position that the officer could not have had control of the situation short of handcuffing Mr. Shepherd and placing him in the police car?
Your Honor, Jack Shepherd, in the view of the police officer, was running away. It's late at night. He's fully covered. He's running away from the direction of a gated community. The officer's inference might have been, this is a criminal doing criminal activities. The officer stopped Jack, arrested Jack, and got him in the back of the car to ask him questions. I would say, yes, the officer felt most in control then. Now, Your Honor, the officer only asked Jack the most important questions at the moment. With that question, the burden then shifted to Jack to explain himself. Jack stated he was going to a costume fiesta. This fiesta was in a secluded location and one that law enforcement was not aware about. Shepherd's intent was to attend this party, and he was believed. This, however, brings me to my second point. Your Honor, Jack Shepherd was a well-known cosplayer. With that being said, if the party was supposed to be a costume fiesta, then the officer should have reported or at least testified that there were costumes observed.
Why? I'm not sure I understand what that has to do with what Jack was told. I mean, the record appears to be clear that he was told it was a costume party. He and his friends went home to get costumes because they believed it was a costume party. And I didn't think there was anything in the record that indicated they thought it was something different than a party to which you were supposed to wear costumes. So if they were misinformed, or if they were properly informed and everybody else just decided not to wear costumes, what does that have to do with whether Jack Shepherd's purpose in going to the party was bad or not?
Your Honor, within the case, it said that Jack Shepherd and his friends went home to change. It did not say into costumes. So the fact that Jack made the inference that it was a costume party just says, okay, he got the name Costume Fiesta. But that was never emphasized when they were talking about the party. The only thing that was emphasized would have been the amounts of alcohol, specifically the kegs. And Your Honor, for the record, Jack was not invited to said party. Between the conversation with Cynthia and the other gentleman in the car, the other gentleman specifically said, why don't you ditch those losers to Cynthia?
Did he know that? Did he hear that?
Yes, Your Honor.
How do we know that he heard that and that he wasn't invited? But
Your Honor.
In fact, how do we know he heard anything about alcohol?
May you rephrase the question, Your Honor?
Well, the only mention that there was going to be alcohol before this was from this fellow David, who was speaking to Cynthia, right?
Mm-hmm. Yes, Your Honor.
Okay. How do we know that Jack Shepherd heard that conversation?
Your Honor, we know that Jack Shepherd heard this conversation because within that conversation, he mentioned the party. So if Jack heard about this party, then obviously it would have meant he heard that there would be alcohol at this party. To my second, making the inference that nobody at the party was wearing costumes means one of two things. One, if Jack Shepherd was to arrive at that party, then costumes are not the purpose. Instead, it is what was present. And two, the costumes are a pretense for what was intended, for the intended actions at said location. Powell v. People states that evidence provided by the people need not exclude every hypothesis of innocence. The defendant, however, remained free to provide an alternate theory. They did not.
You seem to be implying that the defendant here had some role to play in setting up this party, and that he did it as a sham for drinking. But I didn't see anything in the record that indicated he had anything to do with setting the party up. Am I misunderstanding what you're getting at?
Yes, Your Honor. What I'm trying to say, Your Honor, is that Jack Shepherd had a lot of intent to going to this party. So much intent so that we all know that Jack Shepherd's father was a well-known businessman in the community. He was also vying for the position of governor. Jack knows that if he got in trouble, that would be very bad for his father when running. His father also knew that. So let's say, Your Honor, hypothetically, Jack's going to this party. He needs something to wear, but he can't make it known that he's going to this party where he knows there will be alcohol. So he puts on one of his costumes, head to toe coverage. Nobody can identify him at that point, Your Honor.
Attorney Solomon, if you are at the trial level and you're making that argument to the jury, aren't you just asking the jury to speculate completely and to convict based upon speculation that because the father is such and such, then the son must have felt this way? Isn't that way lower than the level of proof that's required to show Jack's intent?
No, Your Honor. We can see that most of the people's arguments are based off of reasonable inferences made by the people. If we take a look at Willis v. People, it provides the statutory provisions addressed to the same subject matter be harmonized and presented in a coherent scheme. To tie 1191 and 481 together in the context of loitering under both the Maricopa County case outlines the below factors, specifically 1 and 2. These factors note that a statute of ordinance affecting minors must focus upon 1, the vulnerability of youth at night, and 2, ensuring minors avoid detrimental choices such as drugs, alcohol, and crime.
Well, let's give it to you. We'll accept that that's the purpose of the legislature is to protect people, but the statute 1191 specifically says that the government, the police have to give an opportunity for the suspect to identify himself and explain his presence. And I think you've acknowledged that that didn't happen prior to his arrest. Was it incumbent on the government to demonstrate and prove that this was somehow impracticable to give him that opportunity?
Your Honor, as I said before, the officer's job was to assess the situation, get control, and then ask questions. If the officer thought that getting him into the back of the vehicle after he was arrested and asked him questions, then that was most.
So that was the government's burden, though, right? To show
Yes.
that.
Yes, Your Honor. In closing, when 14 VIC 1191 C, D, and E are taken into consideration upon Jack's arrest, the actions of the people are justified. The officer saw Jack Shepherd in a state which looked like he was running away, giving the officer probable cause to intervene. The officers provided Shepherd the opportunity to explain his presence and conduct. That explanation did nothing to alleviate or dispel any concern or alarm. In conclusion, the burden shifted, even if slightly. Shepherd and his attorney provided nothing in defense. It is for the stated reasons that this court should affirm the lower court's ruling. Your Honor, thank you for your time.
Thank you, Attorney Solomon.
Thanks.
All right. While you are scoring, I will get the other team set up. And 15. Okay, St. Peter and Paul. All right, Charlotte and Molly, you will not be removed. You are done arguing for the day, so you can stay in and observe. All right, St. Peter and Paul, are you there?
Hello, do we sound good? Good afternoon.
Yeah, that's what I was just checking. Yes. All right. While the scores are being done, just wait and hold tight. And when everything is ready, I'll have you put your notices of appearance on the record.
Okay.
Sorry, I thought I had hit unmute. All good. All right. St. Peter and Paul, please unmute and put your notices of appearance on the record.
Good afternoon. My name is Pierre Joseph. P as in pencil, I, E as in elephant, R, E as in equal. Joseph, Joseph, P as in pencil, H. I attend St. Peter and Paul Catholic School and will be arguing issue 1 for the appellant. Good afternoon, Your Honors. I am Ethan Farrell. That's E as in echo, T as in tango, H-A-N, last name, F as in Frank, A-R-R, E as in echo, L-L. I attend the St. Peter and Paul Catholic School, and I will be representing Jack Shepard, the defendant. The issue that I will be arguing is whether the Superior Court erred when it interpreted the statute to place the burden of proof upon the defendant to prove subsections 1191's C, D, and E as affirmative defenses.
All right, Mr. Joseph. When you are ready, you may begin.
Good afternoon, Your Honors. May it please the court. The Superior Court committed clear error in its ruling that there was sufficient evidence to sustain a conviction under subsection 1191B5 of Title 14 Virgin Islands Code and subsection 481B of Title 14 Virgin Islands Code of Jack Shepard, and here are the 2 reasons why. First, the prosecution evidence is insufficient under subsection 1191B5 of Title 14 because he did not linger with the intent to consume alcohol or to commit a crime. His only intent was to meet with his friends.
How do we know that? Especially in light of our standard of review, Mr. Joseph, why isn't it a fair inference in favor of the government that he knew there was alcohol and he was going to this party because he wanted to, as he yelled while he was running away from the cops, to party?
Even viewing the evidence in the light most favorable to the people, it is not a reasonable inference that Jack would have drank alcohol based on the evidence at track, because if he reached at a party, he would have probably never decided to drink the alcohol. Just because he decided to attend to the party does not automatically means that he had the intentions of drinking alcohol. Keep in mind, every Saturday night, he would spend home alone playing video games and watch shows by himself home alone. And it was his upcoming 16th birthday, so he wanted to do something memorable and different. So which is why he decided to attend to this party. So there's no actual evidence of him having the intentions of drinking alcohol, Your Honor.
But Mr. Joseph, isn't it reasonably inferable that part of the partying he wanted to do on his 16th birthday, coming of age, was to join with these older young people, and not that we will never know what his intention was, but can't the jury reasonably infer that his intention was to consume alcohol based upon the facts that are in the record?
No, Your Honor, because there was not enough evidence of him directly, specifically stating that he wanted to drink alcohol. He just wanted to have a fun time for his upcoming 16th birthday, Your Honor.
Is it your view that he would have to admit his intention in order for it to be proven?
Can you repeat that question, please, Your Honor?
Is it your position that your client would have to admit his intention to consume alcohol in order for the government to prove he had that intention?
Yes, Your Honor, and he never stated that he wanted to drink alcohol, Your Honor.
What about the circumstantial evidence? Would you agree that his intention to attend a party where alcohol was present could lead someone to believe he intended to consume alcohol?
Right, Your Honor, but it's still not a reasonable inference that Jack would have drank alcohol based on the evidence at track, Your Honor. There's not enough evidence to directly state that, to directly believe that he would have drank alcohol attending this party, Your Honor. Secondly, the prosecution evidence under subsection 481B of Title 14 does not sustain a conviction of my client because he was not under the age of 16 when he got detained.
Does that
First,
matter? I thought he was hanging around while he was 15. It's true he turned 16 when the clock rolled past midnight, but he was 15 when he was wearing a Boba Fett costume, sitting by the side of the road, waiting for Cynthia to come get him, right?
Yes, Your Honor, that may be true, but when the police officer detained him, it was October 31st, 12:05 a.m. If the police officer were to ask Jack how old he is, Jack would have replied 16, which is how subsection 481B of Title 14 would not apply in this situation.
Yeah, it's the age you're at when you commit the crime that matters, isn't it? Not the age you're at when they finally get around to charging you.
Well, Your Honor, there was no crime that was committed because he was not loitering in a public place. For the crime to be...
That's a different issue though, right, Mr. Joseph? We're talking about his age. At the time he gets arrested, you're right, he's 16. But at the time he's alleged to have been loitering, he was 15, right?
Your Honor, at the end of the day, he got detained when he was 16. If the police officer were to question him, he would have stated that he was 16, which is how it does not apply here, Your Honor.
So your legal position is it only matters how old you are when you get arrested. It doesn't matter if you fit within the age category at the time you're doing the thing that they say is the crime. I'm understanding you right?
That's because when the police officer detained him, he treated him as an adult by reading his Miranda rights. If the police officer had treated him like an adult by giving him his Miranda rights, and we also applying the subsection 481B, there's an imbalance in that situation. So it can't go both ways, Your Honor, which is why 481 cannot apply in this situation, Your Honor, because he read him his Miranda rights. Okay. Subsection 1191 of Title 14 states, to loiter means to be dilatory, to stand idly around, to linger or delay or wander about, or to remain, abide, or tarry in a public place. So to be prosecuted with this statute was incorrect because Jack did not stay anywhere near that was open to the public. Instead, he stayed on the grassy knoll area, which is thought of as a private space rather than a public one. Reporting his conviction, claiming that there was no evidence that his crime occurred in a public place.
But wasn't Davis under a tree and on private property? And even though the public may have come and purchased some goods from the pop-up store that the person had there, it was more clear that it was on private property. In this case, wasn't Mr. Shepard stopped when he was running away from the private area of Judith's Fancy on the publicly designated highway number 751. So isn't that a distinction between the Davis case and this case?
Well, actually, Your Honor, in the Davis case, Davis had argued that since he was feet away from the actual public area, that should be considered his crime should be considered in a private area. But it applies here because Jack was feet away from a public area. He was on a grassy knoll area, which ought to be seen as a private area. So Jack
well, Mr. Joseph, if he was running along the side of the road when they arrested him, right?
No, Your Honor. Actually, Your Honor, he was casually walking to a destination where his friend would soon be coming from. And keep in mind, it's midnight, it's dark, and in the picture, it shows that there's no street lights. So it would have been hard for Jack to know that there was a police officer behind him. So when he was
whether he was aware of it or not, I'm sorry, that wasn't really what I was getting at. What I'm getting at is he was running. That's in the record, right? He was running when they arrested him.
He was running out of excitement when he saw his friends.
Okay.
Then
So and he was running along Highway 751, right?
Correct, to his friend's car.
Okay. Isn't 751 a public road that anybody in the public has a right to be on and drive up and down on?
Right, but that was not the area where he remained. He remained in a grassy known area at Judith's Fancy Guard Gate. Then later on, he was walking to the destination where his friend would pick him up from. So that could not be considered as a lingering because it was just him walking to a destination, Your Honor.
Okay.
The prosecution was incorrect to sustain a conviction against Jack under subsection 481 of 481B of Title 14 because Jack was arrested at the age of 16 because his birthday is on October 31st. The prosecution evidence was insufficient to pin this element on my client beyond a reasonable doubt. Jack was detained on October 31st around 12:05 a.m., which means he was already 16 when he was caught. Thus, he did not require his parents' permission as the prosecution misunderstood the situation.
Are you admitting that he didn't have his parents' permission?
Can you repeat that question, please, Your Honor?
Are you admitting that he did not have his parents' permission?
No, I did not state that, Your Honor. I was stating since he was 16, there's no need of knowing whether he needed his parents' permission or not, Your Honor. To conclude, Your Honors, the evidence of Jack's guilt was insufficient and was unjustly charged by an attorney general who had political issues with Jack Shepherd's father. The prosecution evidence used in subsection 1191 of Title 14, B5 was insufficient of Jack's guilt because his only intent was to meet his friends, not to commit a crime. And my client did not violate subsection 481B of Title 14 because he was not under the age of 16 when he got detained. The court should reverse the ruling of the Superior Court that there was sufficient evidence to sustain a conviction of my client, Jack Shepherd. Thank you.
Thank you, Attorney Joseph.
All right, Mr. Farrell, the judges are tallying, and I will let you know when you can begin your arguments. And while you're tallying, I want to give a shout out to my longtime high school classmate who just texted me letting me know she's watching. We have known each other since August 24th, 1986. Hi, Tierney. All right. Mr. Farrell, you can begin when you are ready.
Good afternoon, Your Honors. May it please the court. The Superior Court erred when it interpreted the statute to place the burden of proof upon the defendant to prove subsections 1191's C, D, and E as affirmative defenses. This court should overturn the Superior Court's decision because first, subsection C was ambiguous. Second, subsections D and E shifts the burden and it's unconstitutional. And finally, the legislature erred when they added subsection E and it should be revoked. First, when you interpret subsection C, the language is plain, but its application is ambiguous. The statute states, among the factors to be considered in determining if a person is loitering are if that person, 1, takes flight upon the appearance of a law enforcement officer, 2, loiters or prowls in a manner not usual for a law-abiding citizen, and 3, manifestly endeavors to disguise or conceal himself. The legislature did not assign weight to any of the factors and leaves room for other factors, unknown factors. The first rule of statutory interpretation deals with the statute's plain language. Factors are neither elements nor defenses. Subsection C simply
And subsection C seems to be just saying these are things you can think about when you're deciding whether what happened was loitering. What's ambiguous or unlawful about that?
What's ambiguous about subsection C, Your Honor, is that the legislature did not assign any weight to any of the factors and leaves room for other factors.
So don't legislatures regularly say here are some things you can consider and not assign specific weight to them? Why was the legislature obligated to give an exclusive list and weights for each of the factors?
Well, Your Honor, if the legislature gave a list stated in subsection C, it would have to be implemented with the other factors of the case. And in this case, it was not implemented. Factors are neither elements nor defenses. Subsection C simply provides guidance for the trier of fact, just as the definition of loitering in subsections A. My second point is that subsections D and E are in conflict. Subsection D states, unless the suspect has fled or another circumstance makes it impracticable prior to an arrest for loitering, a law enforcement officer shall allow the suspect to identify himself and explain his presence and conduct.
Right. Can you just go ahead and get straight to telling us how that's in conflict with subsection E?
Subsections D and E are in conflict because D puts the burden on the officer while E shifts the burden back onto the defendant.
Could they be read together as putting a burden on the defendant?
Can you please rephrase your question, Your Honor?
Well, if D and E are covering the same ground and E is specifically saying this is a defense, why shouldn't we read subsection D as simply providing a statement about when it would be an exception to the rule that you have to give a suspect a chance to talk? In other words, instead of saying they're in conflict, why can't D logically be read to say, well, there are circumstances where you don't have to give the suspect a chance, like when they're running away from you or it's otherwise impracticable?
Well, Your Honor, D is not a affirmative defense nor factors. D is an element. Since the state is in the best position to prove D as an element because they control the officer, the burden should remain with the government.
But even so, Mr. Farrell, if you're right, and that burden remains with the government on D, and the trial court was wrong. Doesn't the plain language of D suggest that there can be an arrest if the officer perceives that the suspect is fleeing, or if there are other circumstances that the officer can articulate as to why it's impracticable to ask him, "What's up, son?" before he arrests him?
Well, Your Honor, as my co-counsel stated, the officer didn't give him an opportunity to identify himself.
Yeah, but he was running away from the police car, right?
Well, Your Honor, he was not running away from the police car. He saw his friend's headlights and it got him excited. And then he started to go to the car because he was waiting for a very long time. And he didn't realize that a police car was behind of him.
Does that answer the legal question? Take the factual circumstances out. Let's pretend we were talking about somebody other than your client. Just looking at the law as it is there, the Chief Justice has asked whether by its term, subsection D doesn't say, hey, there are circumstances where you can arrest this person, a person who's a suspect, and that doesn't turn it into an element of the offense. It's just saying the circumstances when you can be forgiven for not giving the suspect a chance to explain. I don't want to put words in my colleague's mouth, but I'll just own that as my own question. What's wrong with reading it that way instead of reading it as an element of the offense?
Because if the D is an element to the case, and if the way that you're implying is a factor and D is not a factor, it's an element. The factors are stated in C. Since the state is in the best position to prove D as an element because they control the officer, the burden should remain with the government. The state can then call the officer to testify and explain the situation. And if the officer is not telling the truth, Jack may be compelled to take witness and stand on his own behalf, which could lead him to self-incrimination in violation of his Fifth Amendment right. He should not have to prove his innocence by proving the failing of a police officer. When interpreting the law, this court must construe 1191 in a constitutional manner and avoid absurd consequences. Putting a burden on the defendant to show that the officer satisfied their duty would be absurd. Additionally, when two statutes conflict, the burden is put on the state. Sansom v. Montana states, after careful examination, the court reiterated that the state has the duty of proving intent as it is an essential element.
I'm still a little bit stuck on your statement that D and E are in conflict. Can you identify the conflict between the two?
The conflict between the two, Your Honor, is that D is stating that the burden should be on the state, while E is shifting the burden back onto Jack. And an improper burden shifting is unconstitutional.
Well, I'm wondering what language you're looking at in subsection D that prompts you to say it says the burden is on the state to prove that.
Subsections D state, unless the suspect has fled or another circumstance makes it impracticable prior to an arrest, a law enforcement officer shall allow the suspect to identify himself and explain his presence and conduct. While E states it is a defense to prosecution for loitering as defined by subsections A if the law enforcement officer fails to allow the defendant to identify himself and explain his presence and conduct. It applies here because the state must prove that Jack is guilty beyond a reasonable doubt, and Jack is innocent until proven guilty. Also in Sansom, they concluded since the jury instructions given to the Sansom jury shifted the burden of proof from the state to the defendant, it resulted in a constitutional error.
This applies because the statute shifts the burden on Jack in violation of his 6th Amendment right to a fair trial and his 14th Amendment right to due process.
Mr. Farrell, if subsection D had introduced itself in the very same manner as subsection E by saying it is a defense to prosecution if, unless the suspect, etc., would you be saying they're in conflict, or would you accept that introductory language made it a defense?
Well, Your Honor, if D simply stays the same as subsections E, it will still be unconstitutional because the burden first remains with the state and it cannot be shifted to the defendant unless the defendant is presenting evidence. In this case, Jack is not presenting any evidence. Finally, the legislature erred when it added, Your Honor, I see my time has exceeded. May I have leave of court to conclude?
Yes, go ahead and conclude, please, Mr. Farrell.
To conclude, Your Honors, I'm humbly asking this court to reverse the lower court's decision when determining the statute's interpretation to place the burden of proof upon a defendant to prove subsections 1191's C, D, and E as affirmative defenses. Thank you.
Thank you, sir.
All right, St. Peter and Paul, you can stay in and observe. You are finished with your arguments for the day. And I will be bringing in Good Hope Country Day School while the scores are being tallied. All right, Good Hope Country Day, are you there and can you hear me fine?
We are, and I will adjust the camera in one moment.
Well, you're coming through clearly, so that's good. And
it looks like we have another add-on that entered, right?
Yes. Jacob, you good with finishing a little early since Adam's on?
Tell me, Adam, you ready to take the baton?
Yep, I'm good to go.
All right, thanks a bunch. Remove pin. Add pin.
You guys can hear us clear enough?
Yes, it's a bit echoey, so I would be cautious about other people in the room moving around while the student is speaking.
I am leaving the room. I was just making sure that everything was technically up. Here's it goes. You guys good?
Well, while you're in there, do you have Adam Sleeper? Is he showing up as the timekeeper? Adam, do you want to speak so your window shows up?
Sure.
Can you see him?
Have me?
Wait, you want to sit over here?
Sure.
Good Hope, do you have the timekeeper? Can you see him clearly?
Top corner for our screen, yes. Mr. Sleeper, will you just hold up one of your signs, please? Perfect. Everyone see?
Yes.
All right, thanks.
All right, thank you. Thank you. Want to make sure that's working. So to confuse you even more, we have a third Adam is the timekeeper on the.
Would you like us to do our notices of appearance in order? And then
Just a second. When the judges are finished tallying their scores, we will have the notices of appearance. One.
We're ready, Adam.
Oh, okay. All three? All right. Then please put your notices of appearance on the record.
Good afternoon, Your Honors. My name is Sahai Alfred. That is T-S-E-H-A-I. Last name A-L-F-R-E-D. From Good Hope Country Day School, and I will be arguing for the appellee, the people of the Virgin Islands, addressing the first issue of appeal of whether the Moot Superior Court erred when it determined that there is sufficient evidence to sustain a conviction under subsection or 81B of Title 14 and subsection 1191B5 of Title 14.
Can you please give the spelling of your first name again?
Yes, it is T-S-E-H-A-I.
Thank you.
You're welcome.
Go ahead.
Good day, your honors and honors attendees. My name is Wyatt Bracey. That is W-Y-A-T-T. Last name, B as in boy, R-A-C-Y. From Good Hope Country Day High School. And I will represent the appellee, the people of the Virgin Islands, on the second issue of appeal of whether the Moot Superior Court erred when it interpreted the statute to place the burden of proof upon the defendant to prove subsections 1191, C, D, and E as affirmative defenses.
All right. You may begin when you are ready.
May it please the court. Your honors, before I begin my arguments, I would like to remind this court that a particular deferential standard of review is applied to sufficiency of the evidence claims as asserted in Ponce versus People. This states that this court must affirm a jury's verdict so long as there was substantial evidence to allow a rational trier of fact to convict beyond a reasonable doubt when the evidence is viewed in the light most favorable to the appellee. The essential facts of this case have not changed, and when presented with these same facts at their core, a group of rational and impartial citizens found the evidence to be sufficient enough to convict beyond a reasonable doubt. The people will show you today that these jurors' decisions should be affirmed for four main reasons. First, there is sufficient evidence to prove that the appellant was in a public place. Second, that the appellant was lingering. Third, that the appellant had the purpose of consuming alcohol. And fourth, that the parental permission is not relevant as the appellant was not going to a place supervised by adults.
Well, let's start with the question of lingering, and you'd agree that by its very meaning that has a time element to it, right? If you're someplace for 1 second, you're not lingering. If you're there for an hour, maybe you are, right?
Yes, I would agree with that general definition.
Okay. The facts seem to indicate that he was sitting by the guard shack for a while, and then when he got a text at 11:55, the defendant moved from where he had been and went out along the road. Is that an accurate statement of facts?
Yes, Your Honor. At 11:25, he arrived at the guard gate and he remained there for 30 minutes. And then at 11:55, he.
Okay. And then the police catch sight of him 3 minutes later at 11:58, it looks like, or something like that. It's 3 minutes. Is that enough time to linger in a public place?
Yes, the appellant was lingering because he was remaining in a public place for 30 minutes. And he was specifically lingering because in that 30 minutes, he was sitting idly. He was scrolling through social media, which is specifically an idle action, as is an action without a clear intent, especially in intent of transit.
Well,
Additionally,
this assumes that being by the guard shack is being in a public place, right? If we were to disagree with you on that point, would you be in a position where you'd have to say 3 minutes isn't long enough to be in a public place, that he was in a private place? If we said the guard shack area was a private place, he was only out by the road for a very few minutes, correct?
yes.
Okay.
But I would assert that it is a public place. As defined in Ponce versus People, a public place may include ostensibly private areas that are nevertheless actually accessible to the public, or which are so close to areas that are used by the public that the defendant's conduct could cause a grave risk of death to those in the public area. So anything outside or very near the Judas Fancy Guard Gate is a public place.
They hire a guard to sit in that guard shack, right? They treat the residents treat that guard shack as a private place, don't they?
Regardless of the guard gate person being there, it's the guard gate, anything outside or very near it is still a public place, as cited in the definition.
Well, so even if it was a public place, The police officer didn't see the defendant here until 11:58. So how could we say that he was lingering before 11:58 at the earliest?
Well, regardless of when the officer saw him, what's important here is when the appellant was committing the crimes. And as stated before on page 3 of the record, the appellant was at the guard gate from 11:25 p.m. to 11:55 p.m. And regardless of when the officer saw him, he was still committing the crimes outlined in 481B and 1195B.
What evidence was presented at trial that he was committing the crime at that time?
The evidence that he was in a public place for 30 minutes, the evidence that he was scrolling through social media, which is specifically an idle action. Additionally, the fact that after that 30 minutes, he received a text from Cynthia saying that she was on her way. So Jack could have, in that 30 minutes, Jack could have inquired to Cynthia more about her arrival time, or he could have returned to his private home within a walkable distance. Therefore, he was lingering because he was staying in a place for an unnecessary amount of time, and he was idle in that place. To talk about the purpose of consuming alcohol, Jack violated subsection 1191B5 because although the evidence the people present for Jack's intent of consuming alcohol is circumstantial, as asserted in Wallace versus People, circumstantial evidence is almost exclusively how intent is proven, providing rational and logical inferences as to the defendant's state of mind.
And what are you relying on to show that that was his state of mind? What are the circumstances?
Well, there are many factors that the jurors took into account when considering Jack's purpose of consuming alcohol. First, the fact that Jack yelled, "All right, let's party," and party as a verb holds the intent of drinking alcohol as defined in Oxford Advanced American Dictionary. To party is to enjoy oneself, especially by eating, drinking alcohol, and dancing. Additionally, the fact that he knew there was alcohol at the party, as cited in Cynthia's conversation with Wooderson, which he overheard, or Wooderson said there'd be full kegs.
How do we know he overheard that conversation?
Well, in page 2 of the record, it cites that Wooderson pulled up the car next to Cynthia, and Jack was in that car with Cynthia. So a rational juror can reasonably conclude that Jack would overhear that conversation as Cynthia overheard it as well.
Well, could a rational juror also conclude that since the fellow who pulled up said, "Hey, dump the geeks in the back seat," that he was speaking maybe not so loudly, so as not to be heard calling them geeks?
Well, even if your honors disagree with the fact that the appellant did not overhear this, there's still sufficient evidence to conclude that Jack had the intent of consuming alcohol. If you add the fact that the jury knew that Jack was a quiet and introverted teenager, and from testimony, the jury also knew that Jack wanted to have a special and memorable experience for his 16th birthday. A rational juror can reasonably conclude that drinking alcohol at a party, as it's not something usually that introverted and quiet teenagers do, would definitely be special and memorable for Jack. Additionally, he not only wanted this experience, he was actively seeking out parties as it was his idea to go to the bowling alley. And his sole purpose for going to the bowling alley was not to bowl, but was to find Halloween parties happening later in the night. Also, the officer, once he investigated the party, saw several kegs of beer and Crucian rum bottles. Additionally, inciting beer.
Is it the territory's position, the people's position, that everybody who goes to a party intends to consume alcohol? That it can be safely concluded that if you're going to a party, you're going there to drink?
No, that's not our position. Our position is that if you pair all the factors that the jury knew, that you can reasonably infer with circumstantial evidence that Jack had the purpose of consuming alcohol. Furthermore, in citing Greer versus People, the appellant Greer made abnormal statements which were support for the jury to sustain his conviction. Jack's statement, "All right, let's party," was an abnormal statement because he presented it with abnormal excitement. He yelled it while running excitingly down the street and yelled it loud enough for the officer to hear it through the confines of his closed car. Not only does Jack's abnormal exclamation of the phrase further indicate his purpose of consuming alcohol, it is also support for the jury to sustain his conviction as noted in Greer versus People. Last, the appellant violated subsection 481B because although it is unclear if parental permission was given, this is irrelevant as Jack was not going to a place supervised by adults.
How do we know that? How do we know there weren't adults here? What evidence is there in the record that there was not an adult, some misguided person over the age of 21 who was supervising this party?
There is evidence that Wooderson, an adult, would be in attendance, as cited in page 2 of the record, but Wooderson would not be supervising the event, as supervise implies an oversight of correct behavior. Wooderson was supplying alcohol to minors, encouraging underage drinking, and encouraging Jack to be out past curfew time, or Cynthia to be out past curfew time, which in no way is an.
So by your definition, anybody who's there serving alcohol, no matter how old they are, could not be supervising it, because giving alcohol to underage individuals is definitionally not supervising. It's the opposite of supervising. Is that what I'm hearing?
Well, yeah, as yes, Your Honor, as supervising implies an oversight of correct, lawful behavior, moral behavior. Encouraging underage drinking and supplying alcohol to minors would not be supervising.
So,
Attorney, I'm just going to say, Attorney Alford, what about the element of proof that Jack was not in transit from his home to another place? Is that a burden that is on the people, and did the people satisfy that burden at trial?
May you repeat the question, please?
481B. It's a defense if he is in transit to or from his parents' home to another place supervised by adult with the express consent or under the direction of his parent. Is that an element that the people had to prove, and did the people prove that element?
Yes, that element is something that the people had to prove, and my argument, or the people's argument, is that because of the wording of that statute, although it's unclear if Jack had parental permission, because there was no supervision at the event, the element is proved, and parental permission is not relevant. To conclude, the government urged these jurors to leave their families and leave their jobs in order to determine these facts. Their decision should be honored and held with the appropriate weight. For these reasons, the appellee respectfully requests that the judgment of the Superior Court be affirmed. Thank you.
Thank you, Attorney Alford.
All right, Mr. Bracy, I will tell you to begin once the judges are finished scoring. Looks like Judge Jordan and Judge Freeman are good, and Judge Brady is just finishing. All right, Mr. Bracy, you can begin.
May it please the court. Your Honors, before I begin my arguments, I would like to first recognize that the second issue of appeal should be reviewed de novo, with a heightened level of review for plain error. And as cited by this court in Davis versus People, where no objection is made or an instruction is not requested, the claim of error is subject to plain error review in reference to jury instructions. And while the exact appeal before the court today is different in language than that of Davis versus People, the essential aspects remain the same. The appellant did not object at trial to the jury instructions, which they ultimately claim left out essential elements of the crime, in this case, loitering. And As the court is well aware, to find plain error, the court must find an error at the trial level. That error is plain, and the appellant has the burden of proving how that error affected his substantial rights.
Well, would you agree, Mr. Bracy, that the right to remain silent is a fundamental right?
Yes, Your Honor.
Would you agree that if the failure to instruct the jury in a way that put all of the burden for proving the elements of the crime on the government were in fact the basis for the jury's verdict, that would be a plain due process violation?
Your Honor, can you repeat the question?
Would you agree or disagree with the idea that if the jury instruction left the jury with the impression that there was some obligation on the defendant to prove his innocence as opposed to an obligation on the government to prove his guilt, that would be a due process violation?
Yes, Your Honor, definitely. But it's important to remember also that a constitutional lapse in judgment at the trial level does not immediately create due process or affect this defendant's substantial rights. There are other factors that go into that. But keeping that in mind, plain error review, the people respectfully request that Your Honors affirm the decision of the Moot Superior Court for two main reasons. First, subsections C, D, and E are not essential elements of loitering as defined by the statutory definition given in subsection A. And second, subsections D and E serve the purpose of avoiding charges which would otherwise be criminal, congruent with the court's understanding of an affirmative defense. Now, subsections C, D, and E are not essential elements of loitering, and we can first look to subsection C, because while it is mentioned in the statute's definition of loitering given in subsection A, the language is clear. To loiter, you must engage in any one of the activities set forth in subsections B and C. It is not a requirement that any elements of C be proven to find someone guilty of loitering, but C rather provides three of many charges which the prosecution can optionally bring against the defendant.
So assume we thought that was right, Mr. Bracy. Explain to us what work subsection D is doing. What's the purpose of subsection D if it's not to say that the government has an obligation to prove it gave the suspect a chance to explain himself?
Well, Your Honor, while subsection C is mentioned in the statute's definition of loitering, subsections D and E are not even mentioned. And as cited by this court in U. Biles versus People, when a statutory definition is comprehensive in itself and does not require reference to any exceptions, those exceptions are usually considered affirmative defenses.
That's a great point. That's a great point, Mr. Bracy. But subsection E goes out of its way to say it's a defense, and subsection D doesn't say that, right? Subsection E says it is a defense. Subsection D doesn't say that. So doesn't that overcome the presumption you've just described and leave us with the impression that subsection D wasn't meant to be an affirmative defense, but meant to be an element to be proven by the government?
No, Your Honor. No, Your Honor. As subsection D's similarity in language to that of subsection E also aids in its interpretation. And furthermore, we can look at the statutory history of loitering. And if we look at the 1968 enactment of this law, the legislature only put forth 7 charges which a defendant can be charged with for loitering. And if we look at the 2019 enactment, not only was the language pertinent to subsections D and E initially involved directly with a crime and removed from subsection B, it would be in this case, if they were to directly transfer it. It was removed to subsections D and E. And as a result of that, it makes it more clear the legislature's intent and statutory interpretation thereof. Additionally, subsections D and E serve the purpose of avoiding charges which would otherwise be criminal.
Attorney Bracy, let me just ask, D and E both address the same topic about giving the suspect the opportunity to identify himself. And E specifically says it's a defense. D doesn't say whether it's a defense or whether it's to be proven by the people. Since the specificity of E on the same subject that is included in D, forget about C for a second, but just as to those two subsections, couldn't we find that the trial court was correct because D and E address the same subject and the more specific subsection says it is an affirmative defense, and therefore we can interpret the second subsection, that is D, which addresses the same subject, also as something to be affirmatively presented by the defendant?
Your Honor, if I understand your question correctly, yes, the similarity in language between subsection E, the clear affirmative defense, and subsection D will aid in their interpretation as affirmative defenses. Additionally, subsections D and E serve the purpose of avoiding charges which would otherwise be criminal, and that is saying as was put forth by this court in Nibs versus People. A defendant pleads insanity to avoid legal responsibility for acts that would otherwise be criminal. And the same intent can be seen in both subsections D and E. If Mr. Shepard were to prove that the law enforcement officer, that he did not make it impractical, and the law enforcement officer did not question him about his whereabouts as an affirmative defense, then he would avoid the charges which would otherwise be criminal.
Isn't
Mr.
that
Bracy,
creating a circumstance? I'm sorry, Justice Freeman, go ahead.
Thanks. Mr. Bracy, I just want to talk about subsection C for one moment. What is your strongest argument that subsection C is an affirmative defense?
Your Honor, it's the people's assertion that regardless of the interpretation of subsection C, as it was never instructed to the jury, and it is not an essential element of the crime in this case, the interpretation, regardless of Your Honor's opinion of it, is not relevant in this case, as it is not an essential element, as the prosecution never charged Mr. Shepard with it. Now,
I'd like to ask, I was about to ask if the language shall give, is that's mandatory language in section D, right?
It could be perceived as such, Your Honor, yes.
Okay. Which means that except in the limited circumstances identified in subsection D, the government has to do the thing that they're being directed to do, which is give an opportunity to explain. The suspect is given an opportunity to explain, correct?
Your Honor, while the people do assert that subsection D is clearly an affirmative defense, as the reasons stated before, if Your Honors disagree with that assertion, there was sufficient evidence provided at trial that Mr. Shepard made it impractical by fleeing upon the appearance of the law enforcement officer, negating the officer's right or responsibility to question Mr. Shepard and providing substantial evidence that a reasonable juror could find beyond a reasonable doubt.
What is it about a 15-year-old just turning 16 moments before running away in a Star Wars costume that creates a circumstance that is so impracticable for a police officer to control short of arrest?
Well, Your Honor, Mr. Shepard, as subsection D is clearly stated in difference to that of the 1968 enactment, it's clearly from the officer's point of view. And at the time, the officer did not know Jack's intentions, and criminal intent would not imply in the same way that it would to some subsection B5. And as such, the officer clearly saw him flee and knew that Mr. Shepard, that he was not required to interrogate Mr. Shepard. Since subsection C, D, and E are not essential elements of loitering, as defined by the statutory definition given in subsection A, and subsections D and E serve the purpose of avoiding charges which would otherwise be criminal, congruent with the court's understanding of an affirmative defense, The appellee respectfully requests that the court affirms the decision of the Moot Superior Court. Thank you.
Thank you, Attorney Bracy.
All right. So Good Hope, you will remain in the Zoom conference because you are done arguing, so you can observe from here and you won't be removed.
Okay, thank you.
Right. So this is another 10-minute break. Let's take it and give the Moot justices time to submit their score sheets, and we will update with this round and get everything moving. And then we will start our last two squads arguments of the program. So we will begin at 3:25. Okay, All Saints, can you hear me just fine?
We can't see you yet. We're working to get our technology together. Can you hear us?
Yes, I can hear you just fine. My video wasn't on immediately, so you should be able to see me now.
Okay, great. Thanks very much. And we were having, technology issues with seeing the timekeeper with our previous team.
Okay, can you see?
So we can't see it.
All right, can you see? You're muted, Adam.
Can you see me now?
I can see you now, yes.
All right, I have him pinned as the top four along with the justices. So he should stay there for you. But if you need to, select the little three dots in the corner of his window and select add pin if it allows you.
Okay, I think we can see him now. I think he turned back off his video on his own, but we should be able to see him when he turns it back on. So thank you for that instruction. Appreciate that. Thanks. Okay, and
Okay, we are on break while the judges submit their scoring, and we will begin at 25 after.
great. Thanks so much. We'll be ready whenever you are.
All right. right. Okay, we got everyone. Sorry about that. I was texting with our keynote speaker there. All right. Can we please get the notices of appearance on the record?
Good day. May it please the court. I am Zania Fleming. That's Xania. Last name Fleming from the All Saints Cathedral School. I will be representing the appellant arguing issue 1.
Sorry, Ms. Fleming, I just want to verify, you only have one M in your last name?
Yes.
All right, thank you.
Good day. May it please the court. I am Alia Francis. That first name Aliyyah. Last name Francis. And I am with the All Saints Cathedral School. I am representing the appellant, arguing issue 2.
All right, and on this squad, there is an alternate, Ms. Ariana George. Thank you, Ms. George. We wish to recognize you for all your hard work up to this point. And with that, Ms. Fleming. Oh, there she is. There she is.
hard work. I appreciate
All right. With that, Ms. Fleming, you can begin your arguments.
Good day. May it please the court. Your honors, the Moot Superior Court erred in determining that there was sufficient evidence to sustain a conviction under 1191B5 of Title 14 and subsection 481B of Title 14. As established by the court in David v. the People, when determining whether there was sufficient evidence, this court should conduct a de novo review and look at all of the evidence that was presented at trial to determine whether a reasonable juror could determine that there was evidence of every element of the crime. Even when you look at the evidence in light most favorable to the people, as the court established in the rule in Ponce v. the People, and give all reasonable inferences to the government, there is no way possible that a reasonable fact finder could find my client Jack guilty of all the required elements of the crime, and the government never fully put on their case. As your honors look at the evidence that was presented to you, you will see that the government failed to provide sufficient evidence to prove all the required elements of 481B of Title 14.
Which elements were not proven, Attorney Fleming? Starting with 481B.
Your honors, the elements that were not proven was the fact that he was under the age of 16.
Well, he was indeed under the age of 16 when he was doing the things they accused him of doing, wasn't he? Wasn't he a 15-year-old, almost 16-year-old, but not quite, when he was sitting around near the guard shack, checking his social media and waiting for Cynthia?
Yes, your honor. Jack was 15 years old when the police initially observed him, but when to assess whether someone is loitering, it takes more than a minute, and he wasn't even observed until around 11:58.
Well, whether they were observing him or not, he was doing the thing that they say is a crime. He was sitting around checking social media and hanging out, waiting for Cynthia, wasn't he?
Yes, your honor, but to be considered loitering, you have to be standing around idly or wandering, and my client was not. He was simply standing on the side more than 2 minutes, 30 minutes. And
well, 30 minutes, right? By the account we've got, from 11:25 to 11:55, he was hanging around near the guard shack, but not inside his neighborhood, perhaps. It's not entirely clear. And isn't a half hour of hanging around enough to be considered lingering?
No, your honor. He was
Why not? How long does it take before somebody says, oh, that's lingering?
Well, your honor, to be considered lingering, you would have to be idly standing around for the purpose of unlawfully buying, distributing, or consuming an alcoholic beverage.
Well,
My
that's a
client-
separate thing. Instead of getting to the purpose of consuming alcoholic beverage, I was trying to get you to focus with me for just a minute here on the idly standing around, because you seem to be taking issue with that. And I'm trying to understand why you're taking issue with that. If he, for a half hour, was standing around looking at his phone, isn't that idly stand? Isn't that by definition the sort of lingering that loitering is meant to get at?
No, Your Honor,
Why not?
because he was not in a public place.
Different issue, but go ahead, go to that.
He was out on Halloween night heading to a party with friends. It's too far of a stretch and cannot be considered a reasonable inference that Jack was there for the purpose of getting a ride to go to a party. He was not there for the purpose of getting a ride just to get alcohol or to consume alcohol. Therefore, Your Honor should overturn the Moot Superior Court's decision that Jack was in violation of 1191b5. The government cannot and did not provide sufficient evidence to convict Jack on either count. A major flaw in the government's case that justifies overturning the case is the fact that the police officers failed to do all the steps and ask Jack questions before arresting him, as required by law. As clearly outlined in the plain language of the statute, it was the officer's duty to ask Jack what he was doing there before arresting him.
Well, counsel, what about the exception in the statute? It says, except if he's fleeing or if there's some other circumstance that makes it impracticable. Isn't that applicable here?
No, Your Honor, because my client was not fleeing. He was simply running towards his friend's car, and once he realized that it was a police officer behind him, he stopped and gave the officer ample time to ask him what he was doing and what his intent was.
So what if we accept that he was not fleeing, but I think everyone agrees he was running? Would that possibly make it impracticable with all inferences drawn in the government's favor?
May you repeat your question, please?
I think, do you agree that he was running when the officer saw him?
Yes.
Okay, and if we're going to draw all inferences in the government's favor at this stage, could a jury find that it was impracticable for the police officer to question him?
Can you clarify your question, please?
Sure, I'm wondering if it is possible that a reasonable jury could think it was impracticable for a law enforcement officer to question your client because he was running at the time that he was spotted.
No, Your Honor, because as I stated, once my client realized that it was a police officer, he came to a full stop and the officer had ample time to ask him what he was doing. While we admit that Jack was covering his face, he was in costume because it was Halloween and the police had no problem apprehending him. They could have asked him after they stopped him, but before they arrested him, to identify himself and what he was doing, and if he had permission. The jury was not properly instructed as to the government's true burden of proving all elements beyond reasonable doubt, and that the mistake is enough to overturn the Superior Court's decision. There is not enough evidence.
Well, what is it in the jury instruction that you think was inaccurate? I understood you to be arguing about the sufficiency of the evidence, but are you arguing that there was something wrong with the jury instruction with respect to section 481B?
Yes, Your Honor, because the police could not prove that my client was found upon the streets or highways, or he was not given opportunity to explain his presence or his conduct until after he was detained.
Okay, those are evidentiary points, not so much jury instruction points, are they?
Can you clarify your question, please?
Well, a minute ago, I thought I heard you say that the jury was misinstructed, but perhaps I misunderstood you, because it sounds like what you're really saying is the government just didn't prove their case. Now, that is a sufficiency of the evidence challenge, and let me ask you about the purpose of consuming alcohol part that you've mentioned a couple times. He's caught running down the street yelling, "Let's party." after having been told that there was going to be a party where copious amounts of alcohol would be served. That's what the record reflects. Why couldn't a reasonable jury, taking those things into account, say, well, he knew there was alcohol there and he wanted to get to it, because that's what let's party means.
Your Honor, it is too far of a stretch and cannot be considered reasonable to infer that because Jack was there for a purpose of getting a ride to the party, that he was there to drink alcohol or to consume alcohol.
Well, can you tell us what's unreasonable about a jury believing that a teenage boy going to a party where he knows there's going to be a lot of alcohol and saying let's party thinks that yeah, he's going to do that. We think that is his purpose. Why is that an unreasonable inference, since we have to draw every inference in favor of the government at this stage?
Well, Your Honor, my client usually never participates in underage drinking. He's a good kid. He usually never gets in trouble. He participates in school and he hangs around a good crowd of people. So it's almost impossible for me to believe that my client had the intent to drink alcohol at the party.
Okay, well, I can appreciate and admire your faith in your client, but our standard of review requires us to sort of lean in the direction of the government, doesn't it? Don't we have to pull every reasonable inference in their favor, even if you, who knows your client, would say that's hard to believe? How do you meet the standard of review?
Well, Your Honor, even if you look at the evidence in light most favorable to the government, there is no way a reasonable juror could find my client guilty of all the elements of the crime.
Which one are we still missing?
May you clarify what you're asking me, please, Your Honor?
Well, you said there's no way they could prove the elements of the crime. I understand you're not giving up any of them. We've spoken about a couple of them. Is there another element of this crime that you think the government failed to prove?
Yes, Your Honor. The government also failed to prove that my client was found upon the streets or highways. He was on private property of Judith's Fancy, where he and his family lived. He was on a private gated entrance road to the gated community, no place close to posing a threat to the public.
When the officer saw him running, however, wasn't he on Route 751, which is a designated publicly marked road that the public's invited to drive on?
Yes, Your Honor, but that wouldn't be considering loitering because he was walking, or as you said, running towards his friend's car. And to be considered loitering, you would have to be idly standing around or lingering.
So I guess what you could be saying is that if he had been on public property while he was sitting around for half an hour looking at his phone, if he had been outside the guard gate, maybe he could have been loitering. But he was on private property, so he can't be seen to be loitering. When he got into the public space, the time was too short and he wasn't standing around, he was running. So for that reason, the loitering conviction cannot stand. Is that an accurate indication of what you're suggesting?
Yes, Your Honor. May I conclude my argument?
Yes, please.
In conclusion, Your Honors, the Moot Superior Court erred in determining that there was sufficient evidence to sustain a conviction against my client, Jack Shepard. There is no way that he could be found guilty beyond reasonable doubt by a reasonable juror of all the elements required under Section 1191B5 or 481B. The evidence established that Jack was not standing idly around or lingering. He was simply waiting for his friend, and he was not on a public street or highway. He was standing at the gay house on Judith Fancy's property, and he was not planning to consume alcohol. He's a good kid who does not want to drink, has no record, who truly enjoys cosplay and wanted to go to the party. Thank you for your time, Your Honors.
Thank you very much, Attorney Fleming.
All right, Ms. Francis, wait, I will let you know when you can begin your argument. The judges will have to complete scoring first.
Okay.
All right, I see two done. Judge Jordan, you still working?
I am. Give me a minute.
All right.
Yep.
All right, Ms. Francis. You may begin.
Good day. May it please the court. Your Honors, the Moot Superior Court did err when it interpreted the statute to place a burden of proof upon the defendant to prove subsections 1191, C, D, and E as affirmative defenses. The burden is always on the government to prove all elements of the crime, including that the police officer had asked Jack whether he had permission from his parents to be out at that time. In our justice system, the presumption of innocence is a fundamental principle that requires the government to prove every element of the crime beyond a reasonable doubt, and is protected in the 5th, 6th, and 14th Amendments of the United States Constitution.
Ms. Francis, are you suggesting that on its face, Section 1191E is unconstitutional because it requires the defendant to affirmatively show that he didn't have an opportunity to explain and identify himself?
Perhaps, Your Honor, the statute as drafted is constitutional. It includes a suggestion that the defendant must have some part in speaking up to maintain his innocence, which is contrary to well-established legal principle that the government must fully prove a person to be guilty. The way the statute is drafted, it could be incorrectly interpreted, as it was in Jack's case, to shift the burden of proving an element of the crime to the defendant, which would be—
What's the element you're pointing to specifically, Ms. Francis? Attorney Francis, I'm a little bit confused about what exactly you're saying the government should have proved, but they were making your client prove.
Okay. Your Honor, I am saying that the government should have proved subsection C, D, and E.
And is there something in C, D, and E that you're looking at that makes you say, oh, look, this is the thing that the the trial court mistakenly told the jury was my client's responsibility to prove, when actually it was the government's responsibility. And instead of just the section number, what is it you think the jury was confused about? What thing did they have to decide that should have been proved by the government, but was being asked of your client to prove?
I am saying that, Your Honor, that he should have been, the police officer or the government should have proved whether or not Jack was on the road without permission from a guardian after 10 p.m.
Okay, so that's the part. All right, and on that part, was it not enough for the government to demonstrate that your client, after he was in custody, acknowledged that he was going to a party which turned out to be a heavy drinking party, and that the jury could infer from that, yeah, mom and dad didn't say, honey, go get drunk, to their 15-year-old turning 16-year-old son?
Well, Your Honor, in Davis versus the People and Wallace versus the People, the courts established that the prosecution must prove all elements of the crime beyond a reasonable doubt and cannot rely on assumptions or speculations. So it would be wrong to presume that Jack was going to a party just to drink alcohol by simply waiting on the side of the road for his friends.
Okay.
As this court held in Wallace versus the People, when interpreting a statute, in our case determining whether 1191C, D, and E of Title 14 are affirmative defenses, the court must first look at the plain language of the statute. When Your Honors look at the plain language of 1191C, D, and E, you will see that the Moot Superior Court clearly got it wrong. Although 1191E might be thought to be a defense because it states it is a defense for prosecution to loitering if ... Section D clearly states that prior to an arrest for loitering, a law enforcement officer shall give the suspect an opportunity to identify himself and explain his presence and conduct unless the suspect has fled or another circumstance makes it impractical.
Is that an element of the crime? Does subsection D state an element of the crime?
Well, Your Honor, subsection D explicitly requires police officers to provide suspects an opportunity to identify themselves. Although it might not be a specific element, it is part of the statute that they need to prove.
Okay, so if they need to prove it, that makes it an element, right? That's the definition of an element. The government has to prove it. So it sounds like you're saying, yeah, D is an element, but here's my question for you then. If I read section 1191B, it starts out by saying a person commits a crime of loitering when the person does the following things, and it lists 7 things. D is not part of that subsection. It looks like structurally, the statute has all the elements of the crime under subsection B. Is that a mistaken view of the statute?
Well, Your Honor, this could be seen as a mistaken structure of the statute, but what I am covering is whether or not subsection C, D, and E should have been placed on the defendant to be proved as affirmative defenses.
Ms. Francis, do we have to agree with you on all 3 subsections, or would it be possible for us to agree with the government that subsection E is an affirmative defense for the reason that you stated a few minutes ago, that it does say it is a defense to prosecution?
Section 1191E does not relieve the government of its burdens to prove all the elements of the crime and following the requirements of inquiring before making the arrest for loitering. The burden lies with the prosecution and must be proven beyond a reasonable doubt. This section speaks to additional opportunities for a defendant to justify and excuse their behavior, but the government must have met its burden of following the statute, which require asking before arrest, Your Honor.
Okay, and now you're referring back to subsection D, right? Asking the suspect to identify himself and explain his conduct?
Yes, Your Honor.
Okay. But there are exceptions to that rule in subsection D, correct?
Yes, Your Honor.
Okay. All right. So it sounds like maybe you're saying the government needs to meet its burden, but there is a defense to be made based on subsection E.
Well, no, Your Honor. I am saying that the government must prove all burdens of the elements of the crime. Subsection E just allows for a defense to be made if the government had met the statute before.
Okay.
The jury in the Superior Court was provided incorrect jury instructions regarding an essential element of the crime that relieved the government of some of its burdens, which led to an error in the decision. As established in Sandstrom versus Montana, a jury instruction that places the burden of proof on the defendant violates the due process clause. This clause ensures that no state can create or enforce a law that limits the rights of U.S. citizens or deny them life, liberty, or property without due process. This is a fundamental and sacred principle of U.S. law, and this court must overturn the lower court's decision in light of the incorrect jury instruction.
Which specific thing are you thinking about when you say the court gave an incorrect jury instruction? Is it about the lack of parental consent? Is it about consuming alcohol? The purpose of consuming alcohol? What's the part that they got wrong, that the judge got wrong?
Well, Your Honor, the judge got sorry, I misspoke. The parts that I am referring to, Your Honor, are the sections which state he was loitering without the parental supervision and him being out at past 10 p.m.
Okay, and does that depend on our agreeing with you about whether or not he was in a public place, or does that depend on our agreeing with you about whether he had a purpose to consume alcohol?
May you rephrase your question, Your Honor?
I guess I may be just asking you to replow ground you've already done a good job with. So go ahead and wrap it up if you want.
Thank you, Your Honor. In conclusion, I urge
Attorney Francis, before you conclude, let me just make sure I understand one thing you just said. You said, understandably, your position is that an affirmative defense may be okay, but only after the people prove its case completely. Then the burden of going forward could shift under subsection E. Is that what you said?
May you repeat, Your Honor?
Well, let me just try again. You said the people have the burden of proving all the elements. And one of the elements you said is found under D, that the police officer shall give the suspect the opportunity to identify himself and explain. And only after the people have presented all of their proof sufficient to sustain a verdict, then does the burden potentially shift, the burden going forward to have the defendant show that the officer had actually failed to identify himself and explain, or to give the opportunity to the defendant. I'm not sure that's very clear. Can you answer that, or is that just too jumbled?
It's a little bit jumbled, Your Honor. Can you repeat it for me one more time?
All right, let me just try quickly again. Let me just do it this way. What do you have to say about subsection D, where the officer says, look, this guy was fleeing from me, he was running. Now I know after the fact that he wasn't running away from me, he was only running towards his friend, but all I saw was this guy running. I couldn't track him down, and plus he was disguised, he was in a costume, so I don't know what's going on here. It's impracticable for me to stop him and say, what? Because the suspect has fled, or there's another circumstance making it impracticable, couldn't a jury determine that the people have met their burden under D because they're excused in light of those circumstances?
No, Your Honor, because sorry, I misspoke. When the officer had saw Jack loitering as he claimed to be on the street, Jack was running towards his friend's vehicle. And he saw this as Jack fleeing from the police. But when the police officer called out to Jack, Jack had stopped. And at that time, the police officer had time to ask Jack what he was doing. So in that time, before the arrest, the police officer clearly had time to ask the question. So the government had not met the burden.
All right, thank you, Attorney Francis. Is that, do you have a brief summary or is that it?
Yes, Your Honor. In conclusion, I urge the court to consider the incorrect interpretation of the statute by the Superior Court in this case, which led to the jury instructions that shifted the burden and put it on Jack. It is critical to overturn it to avoid setting a bad precedent for future cases and avoid an unfair, unconstitutional result for Jack. Thank you for your time, Your Honors.
Thank you, Attorney Francis.
All right, all saints, you are done arguing for the day, so you will remain in the Zoom conference, and I will admit our next squad while the judges complete scoring. All right, St. Croix, are you able to hear me clearly?
We can. Good Hope Country Day. We can hear you just fine.
I meant the St. Croix School arguing, but thank you.
We can hear you.
Okay, thank you.
Okay.
All right, looks like we got one done. Two. All right, St. Croix Seventh-day Adventist, could we please get your notices of appearance on the record?
Good day, Your Honors, and good day all. My name is Jijana Charles. That is capital J apostrophe J OHN-NA. Last name Charles, capital C, lowercase HARLES. I attend the
Could you give me your first name one more time, please?
capital J apostrophe lowercase j OHN-NA.
Thank you.
I attend the St. Croix Seventh-day Adventist School, appearing on behalf of the appellee, the people of the Virgin Islands, arguing issue 1.
Good day, Your Honors, and good day, all. My name is Ruben Christian. That is R-E-U-B-E-N. Last name C-H-R-I-S-T-I-A-N. Representing the St. Croix Seventh-day Adventist School, appearing on behalf of the appellee, the people, arguing issue number 2.
All right, Ms. Charles. It's an awkward. All right. You may begin when you are ready.
May it please the court. Your Honors, it is the role of the police officers to protect the citizens and their property. The Moot court did not err in determining that there was sufficient evidence to uphold a conviction under 14 VI Code subsection 1191B5 and 481B, which says Mr. Shepherd committed the crime of loitering when he was remaining around a public place for the purpose of unlawfully consuming an alcoholic beverage. And he was under the age of 16 without the permission of his parents in a public place, Highway 751, after 10 p.m.
How do we know he was without the permission of his parents, Ms. Charles?
Sorry?
I'm sorry, can you hear me, Attorney Charles?
Yes, I can.
Okay. How do we know that what what the defendant was doing was not permitted by his parents? What evidence is there to show that he was not permitted to do what he was doing by his parents?
Because, Your Honor, Mr. Shepherd has his friends pick him up halfway down the street instead of in Judith Fancy. And after the time of 10
I thought the record showed he was running to him just because he was impatient, not because he was not because they were embarrassed somehow to drive up to him, but he was impatient. Isn't that what the record shows?
Yes, Your Honor, it does show that he was impatient, but a reasonable inference could show that Mr. Shepherd didn't have the permission of his parents because he went into his house and just ran out and went outside and was just had his friends pick him up halfway down the street at almost 12 p.m.
Ms. Charles, wouldn't it be just as reasonable for a jury to infer, well, he went back to his house, he said to his parents, I'm going out to the party, I'll see you later?
Yes, Your Honor.
Why is one inference permitted and the other inference not permitted?
Because, Your Honor, there was alcohol being served at that party. I don't think any reasonable parents would let their child go out after midnight to go to a party with alcohol. This court will review the evidence that was offered in this case de novo and consider the evidence in the light most favorable to the people, granting reasonable inferences under Ponce v. People. The jury heard evidence that the officer on patrol had just responded to a disturbance not far away when he saw Mr. Shepherd on Route 751. The evidence shows that he was wearing dark clothes and a mask which concealed his identity. And upon the entrance of the police, he began to flee. At which time...
It seems clear on the record that he wasn't fleeing the police, he was running to his friends. Isn't that accurate? I mean, the police may not have recognized it, but this wasn't fleeing from the police, this was running to his friends. Isn't there a meaningful difference there?
Well, Your Honor, at the time, the police didn't know that, Your Honor. He just saw Jack walk in, and then all of a sudden, Jack saw the police at the corner of his eye and then just started to run away. At which time, the police put on his siren, drove up to the person, and proceeded to make an arrest. Since the defendant was fleeing, it was deemed necessary to detain the defendant without asking any questions. Your Honors, the police saw a person in dark clothing wearing a mask on the road at night. Your Honors, Mr. Shepherd was in a public place after 10 p.m., which is an element of the crime. Your Honors,
How do we know he was in a public place, lingering in a public place? It's true he was running along a roadside when the police apprehended him, but in the time before that, wasn't he hanging around the guard shack right at the entrance to the neighborhood?
Yes, Your Honor, but that could be seen as suspicious. Why would a young boy be outside just remaining around, walking, looking at his phone, getting up, sitting down, and then walking all of a sudden? That would come up.
Let's accept that looks suspicious. The question you seem to be focusing on was public place. So I'm asking you, if he's right there at the entrance to his neighborhood, isn't he still in a private place? Suspicious looking or not?
No, Your Honor. A public place could be a public place could be in a private area.
I'm confused by that.
Your Honor, a public place may include private areas that are accessible to the public, but which are still closed to private areas. And Highway 751 fits right into the description and is where Mr. Shepherd was arrested for loitering.
Now, he was arrested just moments after the police saw him, right?
Yes, Your Honor.
So they didn't know, or they had no reason to believe he had been in anything other than that roadway for a while. Perhaps that explains why they did what they did. But aren't we obligated to look at the record and say, hey, he wasn't running along 751 or doing anything like that before the police saw him. He was back there right at his neighborhood. So I guess I'm going back to the question of private place. What's the proof that this area that we're talking about was a place that the public thought they could just come up to and walk around on? Wasn't it incumbent on the territory of the Virgin Islands to prove that this was a public place, not to ask the jury to assume it was a public place? And by that, I mean the entrance to Judith Garden.
Well, Your Honor, there is reasonable inference to say that Mr. Shepherd was loitering on the street. Now, tell me, why would a 15-year-old boy be out this late without an adult going to a party with alcohol? Because a reasonable person could come to the conclusion that he was going to the party to drink. He did shout, "Let's party." A reasonable person could find that there was sufficient evidence under 481B that Mr. Shepherd, a minor, was loitering without the permission of his parents. There was no evidence presented to the jury that Mr. Shepherd even had the permission of his parents to be out at this late time. It could infer that Mr. Shepherd may have had the permission of his parents.
Is it on Mr. Shepherd to prove he had the permission of his parents, or is it on you as the representative of the territory or your colleague, whoever tried the case, to prove that he didn't have permission?
It's on the people to prove that Mr. Shepherd come to the car. To go to the bowling alley, but certainly not to the Moonlight Tower, given that there was alcohol being served. And it could be inferred that Jack didn't have the permission of his parents because he had his friends pick him up halfway down the street instead of in Judith Fancy at almost midnight. In Maricopa County, the defendant received permission to go to a friend's house and substantially ended up in the park. It was held that she did not have the permission of her parents, and there was found guilty. Your Honors, Mr. Shepherd returned home just like that juvenile, and then left for the Moonlight Tower to party. I wonder what my appellant's expectations of what happens at a party is. And the evidence shows there were kegs of beer at that party, which the officer substantially broke up. In Maricopa County, the statute did not violate her constitutional rights, and the jury was held guilty. In our case, Mr. Shepard received due process and his constitutional rights were upheld.
Attorney Charles, in Maricopa County, the father, I believe it was, did testify that he gave permission, but the conviction was upheld because the permission was to a certain area adjacent to the park, but not to the park itself. But in our case, we don't have any evidence, as far as I'm aware, and you can please correct me if I'm wrong, as to whether the parents knew about it, didn't know about it. And if there's no evidence one way or the other, isn't the people simply asking the jury to speculate that, well, there must not have been consent? Isn't it an element that has to be proven by the people?
Yes, Your Honor.
And what's the evidentiary proof in the record other than the fact that Jack was picked up down the road, not at his house? And if that's the only evidence, is that enough to allow a reasonable inference, or is that just asking the jury to speculate that he probably didn't have permission?
Well, Your Honor, the people give sufficient evidence that Mr. Shepard would, beyond a reasonable doubt, didn't have the permission of his parents because because Mr. Shepard committed the crime of loitering. And there was sufficient evidence, Your Honor, because he was roaming in a public place for the purpose of unlawfully consuming alcohol. And he was a minor under the age of 16 on the streets after 10 p.m. In conclusion, the people are asking the court to affirm the conviction to find Mr. Shepard guilty of 1191B5 and 481B because the evidence was sufficient to rationally support the jury's findings of the guilt beyond a reasonable doubt for the crime of loitering when he was roaming around a public place for the purpose of unlawfully consuming an alcoholic beverage, and for the fact that he was under the age of 16 without the permission of his parents in a public streets, Highway 751, after 10 p.m.
Thank you very much, Attorney Charles.
All right, Mr. Christian. All right, so
May it please the court?
just a second. I'll let you know when you can begin. The judges will finish scoring first.
Understood.
Number 1, 2, 3, All right, you may begin.
May it please the court. Our claim is that the Moot Appellate Court did not err in shifting the burden of proof onto the defendant, as we request, Your Honors, that you affirm the lower court's decision of issue 2 of this case, and we request that you view this case in de novo, where we will review all of the evidence anew in the light most favorable to the people, granted reasonable inferences. Your Honor, the 14th Amendment, which discusses due process, explains we the people cannot infer intent on the basis of elements of the crime. However, in Leary v. U.S., as the court arguing the case instructed that the evidence of possession allowed the inference to assume he knew the substances were illegally imported. Even though in this case the court found that the situation unconstitutional, as they could not connect point A, Mr. Leary's possession of the drugs, to point Z, to Mr. Leary's supposed knowledge of the drugs being illegally imported. We can reasonably infer that Jack could have had intent to consume alcohol, as 1, he knew there was alcohol at the party, 2, he had no visible permission from his parents to go to this party, 3, he seemed to be running from the police car, which can all potentially lead to 4, the pressuring of Jack to consume alcohol.
Is there something, Mr. Christian, that you're going to point us to that will lead us to believe that that there was a problem with the jury instructions, that there was an interpretive error with respect to the statute?
Can you clarify, Your Honor?
Well, I understood that you were going to be speaking to the question of whether or not 1191 is a statute that the Superior Court misunderstood because it made 1191 C, D, and E, that it was something that the Superior Court correctly interpreted to put the burden of proof on the defendant as an affirmative defense. If I'm right about that's the thing you're going to argue, can you please tell us why it is that subsection D of that statute appears to put a requirement on the government, not on the defendant? And I apologize if that very long question leaves you puzzled. Do you want me to take one more crack at it?
No, I believe I understand what you're saying, Your Honor.
Okay.
Well, from what you're saying, it explicitly stated in front and on top of 1191E, correct?
Right, exactly. 1191E says it's an affirmative defense. So, I mean, it says it is a defense, so it looks like an affirmative defense. But 1191D doesn't say that. So why would the Superior Court say it is?
Because along with the C and E, they're only factors to be considered. They are not essential elements of the crime. Mr. Shepard can choose to use these affirmative defenses to rebut our argument if he chooses to do so. Yeah.
And when I read section D and it says that prior to an arrest for loitering, a law enforcement officer shall give the suspect the opportunity to identify himself, doesn't that indicate that this is something that is supposed to happen and the government has to prove it happened?
No, Your Honor. For me to prove my case and to win my case, I must prove all of the essential elements of the crime, which are outlined in 1190, which are outlined in count 2 of this case. If I happen to prove that the police officer did answer questions, ask Jack questions, that only enhances my case. It does not mean that I proved the entire case or not. As I said earlier, 1191 C, D, and E are affirmative defenses, not essential elements of the crime.
Okay.
What is it about subsection C that makes it an affirmative defense? What language in that subsection says affirmative defense?
You see, Your Honor, it does not, it explicitly states at the top of all 1191 C, D, and E that there are factors to be considered, not essential elements of the crime, as I told, as I said earlier.
Okay. Is it your view that everything in a statute is either an element or an affirmative defense? There's nothing else?
Can you clarify that, Your Honor?
Is it your position that all language in a statute must either be an element of the offense or it must state an affirmative defense?
Well, Your Honor, as stated in Dupingi versus Tyson, when the language of a statute is clear and unambiguous, no further analysis is required in order to discern the meaning of that statute. Therefore, if the legislature meant it to be easy to understand, therefore I do not need to explain whether if it's an affirmative defense or an element of the crime, because it would have been said so in plain language, which in this case, the elements of the crime are the elements of the crime, and the affirmative defenses are the affirmative defenses.
Okay, so subsection E says it is a defense, so that's pretty clear and unambiguous. But is there any ambiguity with subsection C or D?
Yes, as I said earlier, there are at the top of the section, it says there are factors to be considered. In other words, I do not necessarily need to prove them in order to win my case. And also, Mr. Shepard can choose to use them if he must bring forth an argument to rebut our claim as the prosecution.
That's how 1191C begins. 1191C says that the three things that they list are factors to be considered. But that's not how subsection D begins. Subsection D simply says that, or it seems to say, hey, the government, it seems to say that the police have to give an opportunity to explain before an arrest, unless there's a good reason why they can't do it, because the guy's running away or it's otherwise impracticable. So what is it about subsection D that leads you to say, and you have repeatedly said, that it's an affirmative defense? What is it in the language of D that makes you say, yeah, that's a burden that's on the defendant to prove if he wants to show an affirmative defense?
Well, Your Honor, there are for Mr. Jack Shepard, he is innocent until proven guilty. And also in this case, Mr. Shepard does not have to say anything to anybody unless he chooses to do so. So the statement that you stated earlier as he has the burden, he does not have the burden. The prosecution does. These affirmative defenses are only there for if Mr. Shepard chooses to make an argument against us, which he hasn't.
Well, it's when you say he hasn't chosen to do it, I take his position to be, I don't have to say anything. Just the way you just said, he doesn't have to say anything. But even though I choose to say nothing, in order to prove the crime, the government still has to show that in the course of the events that happened that night, I was given a chance to explain, and they haven't shown that. That's the argument I understand them to be making. I'm asking you to meet that argument. Why is that argument wrong? Why are they wrong to say it is an element of the offense for them to show the officer gave me a chance to explain, and they haven't done that?
Well, you see, Your Honor, according to the 14th Amendment, which explains due process, I must prove all of the elements of the crime beyond a shadow of a doubt, and the elements of the crime are as follows. That he must, that he was the person, he had the intent to consume alcohol, and he was also out on the streets, standing idly by or wandering about, or in general loitering. Nowhere in these three elements does it state that I have to prove that Mr. Jack Shepard was given a chance to explain himself. I can also choose to say that I do not need to necessarily explain that in order for me to prove my case.
All right.
Okay, Your Honors. In our case, the elements of the, sorry. Your Honor, the language contained in Virgin Islands Code 1191, subsection C, D, and E were correctly interpreted by the court as affirmative defenses. And the defendant did not have the burden to prove his innocence, but once the elements of the crime were proven, the defendant could use C, D, and E to offer additional information. Your Honors, the people have proven that the elements were properly proven to be sufficient elements of the crime. The defendant is indeed Mr. Jack Shepard. He was confirmed by an officer to be alone on the streets, and he also had the intent of consuming alcohol. On the contrary, would you, Your Honors, think it reasonable for a parent or guardian to send their 15-year-old child on the streets after 10 p.m., unaccompanied by an adult, to a party where alcohol was served with no experienced adult supervision? If the 15-year-old in the case Reed Maricopa County cannot go out on her own without adult supervision, then neither can Jack.
Mr. Christian, I'm going to go back 1 minute and give it one more shot on the question that's been asked, I think. You've indicated what the elements of the offense are that the people have to prove, but subsection D says that a suspect prior to arrest shall be given the opportunity to identify himself and explain. Why are the people excused in this case from proving that?
Well, Your Honor, as I've said earlier, the elements of the crime state that he was on the streets, that he was loitering on the streets, that he was the person, and also he had the intent to consume alcohol. Other than that, there is nowhere inside these three elements that says I have to prove subsection C, D, and E, as they are for the defendant to potentially create an argument against us if needed be. In conclusion, we request that you, Your Honors, affirm the lower court's decision to keep the conviction of Jack in issue number 2. Thank you, Your Honors.
Thank you very much, Attorney Christian.
All right. We'll give the judges a little chance to score here.
Everyone can take a nice deep breath. Yeah.
This is what these appellate court judges do all the time, I guess. Yeah.
Yeah, we keep these little sheets actually with us up there on the bench.
All right. Alrighty. While we're waiting, I see Judge Freeman is done. Judge Freeman, do you want to give the students any feedback? This is the opportunity for you to share your observations of the day.
I would be happy to. I thought everyone did a wonderful job. As I was sitting here listening to all of your arguments, I realized how much you had to learn in order to dive into this case. There are a lot of background principles about the Constitution and how a trial works and how an appeal works and standards of review and all of that, in addition to the facts of this case that you had to absorb without having the foundation of law school to teach you any of that. So I thought you all did remarkably, and you should all be incredibly proud of yourselves.
I have to agree. This was a first year. I write the law library, so if you all had a miserable time and wanted to resent anyone, that is on me. Rob isn't the cruel one in the two of us. But I had considered adding about 4 law review articles to it, and I thought, no, I don't want to be canceled this year. And I have held them out. And this is the first time that I ever was in here thinking, boy, there were at least 3 students who really could have used that theoretical, because you as the Moot justices pushed their questioning to the point that they genuinely didn't have the law sources to respond to some of the questions you asked. You know, it got so high level, and I've never seen arguments achieve that. So I really do have to agree that it was remarkable. So thank you very much for your service and your comments. Judge Jordan, I have to give you the award. A swimming pool full of beer. That beer that just cracked me right up today. And you delivered it with such a stoic look. It was one of the most entertaining moments of the day. Do you have any comments for the students?
Yeah, stay away from swimming pools like that. Don't be tempted. Just echoing Judge Freeman, what a really impressive group of young people you have there in the islands, and the effort that had to go into preparing for this is very substantial. I'm impressed with the obvious preparation that was done, and you know, some of these arguments we did try to press you on certain points, and I thought that there was a level of maturity in handling the questions, sometimes repetitive questions, sometimes questions that seemed pretty long, and people handled it well, real well. So kudos to you. You know, it's a competitive business, the law, but you all stood up to the competition and acquitted yourself well.
Yeah, I have to agree. I thought it was remarkable. Judge Brady.
Well, I would echo what Judge Freeman and Judge Jordan have said, that it's a very impressive group of students that we saw today. And of course, you've risen to the top of the competition, and your preparation over many weeks is very apparent. Your ability to discern the elements of statutory language and the crimes that are in play, as well as the plain language and some of the nuances in the case law. All of you were very, very impressive with your understanding and your presentations. I think it's probably a good thing that if Adam didn't say he was standing down as the person who's going to prepare the next challenge for the competition, but boy, oh boy, this was a tough one. Lots and lots of different elements that have to be considered, and lots of nuances within them. So I just echo congratulations to all of you. You're all winners. You've all done a very good job, and I wish you all the best as you continue your high school careers and beyond.
I have to agree, Judge Brady. We had Judge Barnard from the District Court of the Virgin Islands on our panel on St. Thomas, and he was just shy of 40 years, 38 years on the bench, and his comments were, he had seen far worse arguments in the district court. And I have to, after watching today, say I absolutely agree. I have been in the district court and I have observed, and boy, I think that these were arguments on the level of professional litigators. They were just remarkable. With that, Moot justices, please get your score sheets scanned and sent to us. And we are about to turn to our keynote speaker while we tally all the scores and get ready to announce the placements. Professor Jackson, could you, there we go. Dr. Jackson is a professor of law at the University of Wyoming College of Law, and he is the director of the University of Wyoming Prosecutorial Assistance Clinic. He is also the co-director of the Stealing Culture Project, which interrogates artistic cultural appropriation and analyzes criminal, state-sponsored, and cultural remedies for such actions. He is a globally recognized figure in this work. In addition to a JD, Dr. Jackson holds a doctorate in education and has done qualitative studies around structural racism in the educational experience. Dr. Jackson's core subject matter specialty is criminal procedure. Prior to his graduate and professional law teaching career, he practiced law as a former assistant U.S. attorney. Professor Jackson's doctorate is in philosophy from the University of Colorado. He received his Juris Doctorate in 1990 after having studied for a summer at the University of Madrid in 1988. Professor Jackson also received his Bachelor of Arts from the College of William and Mary in 1987. With that, I turn it over to Professor Jackson for his commentary today.
Attorney Thorpe, you are far too gracious. And if you can just give me a virtual or real thumbs up to let me know that you can hear me properly.
I absolutely can hear you just fine.
Excellent. Okay. For those of you watching, I am now starting a stopwatch so I do not overstay my welcome, because I have been in far too many events where somebody said, I'm just going to speak for a little while, and then they spoke forever. So I'm going to keep an eye on the watch myself just to make sure I don't overstay my welcome. To the students who are on here, I'm going to ask you to raise your virtual hand if you were a part of this event last year. Okay, I got some hands coming up. All right, let me scroll through my pages here. All right, there's some more hands. Good. Okay. All right, I'm glad to see that there are multiple people coming back, because that means, number one, that the event was something you found helpful in your development, and number two, that you weren't so disgusted with the event last year that you didn't walk away. And I say this in particularly because the speaker last year, Professor Atiba Ellis, is a very good friend of mine. I think of him as a brother from another mother kind of thing. And I get to see him fairly often throughout the year. And so I watched his keynote last year, and I saw how he was a lecturer. That's what he does. That's kind of his style, where I'm more of a this is a fireside chat kind of thing. So I want to approach this from that standpoint. So Attorney Thorpe is going to show you a picture real quick. There we go. All right. So I just want you all to take in this visual, right? Like, while you're sitting in front of a screen, I want you to close your eyes and imagine that you're in a nice circle around that fire, hearing the sounds of the ocean. This is just a fireside chat. We are not sitting in a room, some stuffy conference room or some stuffy auditorium, listening to a lecture. We're just sitting having a chat. All right, you can pull the picture down, Attorney Thorpe. I thank you very much. And so I want to use that as our framework. I don't want us to think about kind of being in an academic setting. I want you all to sit with me and just kind of talk for a while. So my plan is to talk to you for, I don't know, maybe half the time, maybe 2/3 of the time. But then I want you to talk to me. So I want to get some responses and thoughts and again, fireside chat. So we're in a conversation, and I want to get your opinions and your experiences. I want to hear a little bit more about you. I wish we were in the same space. I understand the benefits of doing this over Zoom, but I wish I could see you all and talk with you all and share space with you all. It's a different experience. So now that we're sitting by this fireside chat, and now that I got you to raise your virtual hand right away, so I know that you're actively listening and involved, I want you all, and you don't have to turn on the mic, just wherever you're sitting right now, all the 9th through 12th graders, I want you to say this with me. I am responsible. All right. I want you to feel it, and I want you to say it again. Say it so the person sitting next to you hears it, whoever might be right around in your vicinity hears it, and say it with that conviction. I am responsible. We're going to sit with that message and that thought for about the next 30 minutes to 60 minutes. We're really going to focus on that idea of what does it mean to say, I am responsible. And like I said, after we talk about it, hearing from me, I want to hear your comments, your suggestions, your experiences, your questions, whatever, about those 3 words, 3 simple words. I am responsible. So let me start off by saying thank you, both for the invitation to be in this space with you, because I am always honored to be in community with amazing young and developing leaders like you. I've been listening in for quite a while. I heard the questions that Moot Justice Jordan and Moot Justice Brady and Moot Justice Freeman were handing out to you all, and they were not easy. They were not simple. I've been in more trials and appellate hearings than I can count, and you all handled reality. You handled the real deal. I have much respect for you. So I know I am in the presence of amazing, young, and developing leaders, and I'm honored to be with you. I also want to thank you for your participation in this event. Why? Because if you look at the science, the average adult attention span is about 8.25 seconds. So maybe the average adult is able to stay semi-focused for the full length of a 30-second commercial. Why do I say a 30-second commercial? Think about what you see on televisions or playing on radios when folks are running for election. This is not you. You are responsible. Remember what I had you say. I am responsible. So I know you are responsible for yourself, for your team, for this event, and for your community. In doing all of this, you are exercising critical skills. You're exercising analytical skills. You are developing into our leaders for today and for tomorrow. You are becoming the best of the best. And this is not by some birthright. You can think back to colonial days and days back in the United Kingdom. This isn't by birthright. This is by practice. You all are engaged in a continual practice, just like practice for football, just like practice for basketball, just like practice for baseball or track, or for theater, or for singing, or for any range of musical instruments that you all might play. You've been practicing. And that's why we call what we do the practice of law. There is no perfection, only the pursuit. And what do we use to do the pursuit? We practice. So let me offer just a bit of my background to put my words into context, to help you understand my perspective and where I'm coming from when I talk to you today. You all enter every environment, every discussion with your own perspective, your own experiences. It's important that you recognize not only how you are entering, but also consider and respect how others enter, their experiences, their perspective. So what do I come into this dialogue with? Well, my background, I played football and ran track in college. Finished college during the summer after the end of my senior year. And the next week, I started law school. After law school, I was a judicial clerk for a state judge and then a federal court judge. And after I finished clerking, I became an assistant county attorney. An assistant county attorney in one of the wealthiest counties in the entire country, Fairfax County, Virginia. You could imagine the different types of crimes you see in that kind of environment. Next, I became an assistant United States attorney in Washington, D.C. You can also imagine the types of crimes you see in that kind of environment. During all this time, I realized there were issues that I wanted to think very deeply about. So I left the practice, being in trial, being in arguments every day, and I became an assistant dean at a law school. But even that didn't allow me to think deeply enough about issues that I cared about, that were near and dear to me. So I went back to school. After all of that, I went back to school, turned my PhD. I'm now the Winston Howard Distinguished Professor of Law at the University of Wyoming College of Law, right? Really long title. But I say all that to show it's a pretty good distance from a kid that just wanted to play football and run track, right? I say all this to emphasize what I want you to focus on today. Each step along the way should be carefully considered and consciously decided because you are responsible for each and every step you take. But each step is just that, a step. There's going to be another and another and another. So don't get frozen by any one decision. Because you know, there will be another decision coming up and another opportunity for another step. Your job is to focus on your goal. Write down your goal or your goals. Review your goal daily, weekly, monthly, annually. Remember the importance of these goals. Even in your competition today, they explicitly wrote out the goals. Why are we doing this? Why are you doing this? If you have the form page, you can look at page 204, and it lays out the Virgin Island Bar and Judiciary seek to increase community understanding, seek to increase citizens' awareness of the roles of a lawyer and judge, seek to promote the community's awareness of current issues in law, seek to promote the study of law, seek to develop and advance public speaking and advocacy skills, seek to improve community perceptions, and seek to provide financial education assistance. They took the time to write out their goals. By writing them out, they had a map. They had something that provided them with navigation. Have you written out yours? Have you reviewed your goals? Have you thought about how your goals are defining you? Have you thought about how your goals are defining your actions? In your hypothetical, what were Attorney General Jack McCoy's goals? How did his goals define him? How did his goals define his actions? How did his goals define how he did his job? With regards to his job, in Berger versus the United States, a 1935 case, the United States Supreme Court spoke through Justice Sutherland, who urged, quote, "The prosecutor is a representative, not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done." As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape, nor innocence suffer. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. That is an often quoted phrase, an often quoted paragraph. But what does it all mean? It means that a prosecutor has discretion. So let's spend some time talking about and thinking about discretion. What is discretion? Hopefully in your own mind, you're thinking about, this is how I would define discretion, because I want you to own how you think about it. I will offer to you that discretion is the power, and I'd highlight the word power. It is the power or right to decide or act according to one's own judgment or choice. How does this discretion look within the criminal justice system? So for most criminal cases, you've got 4 pretty consistent parties, right? You have the police, who probably have the most discretion. Probably pretty obvious to you, but we'll talk about it a little more in a second. But we're with the Virgin Islands Bar and Judiciary, so we need to think about with a law degree, and very, very, very few police officers, law enforcement have law degrees. The other 3 with law degrees are the prosecutor, defense counsel, and a judge. And in that situation, the prosecutor clearly has the most discretion. Once the police or law enforcement bring a case to the prosecutor decides, is this case even going to move forward? And if the answer is no, a judge may never even see the case. A defense counsel may never even see the case. It's gone before they ever have any ability to play a role. And if the case goes forward, the prosecutor is the one that's going to make the decision on what charges we're going forward on, not the police officer. The police officer might want murder. The prosecutor might say, no, at best it's involuntary manslaughter. That's discretion. That's the power to decide what this case is going to look like inside the criminal justice system. How much discretion does the prosecutor get? Well, just 4 months ago, in People of the Virgin Islands versus Cozier, your Superior Court of the Virgin Islands cited the Third Circuit and said, prosecutors enjoy a great amount of discretion in charging a defendant. Prosecutors have traditionally enjoyed discretion in deciding which of multiple charges against a defendant are going to be prosecuted, or whether they are all to be prosecuted at the same time. With that discretion, the prosecutor is responsible. Responsible to their community, responsible to the court, responsible to the system. As leaders, and remember, we've already established that you are both current and future leaders, you must think deeply about whether prosecutorial discretion is good, is bad, or is something in between. And to do that, you must be critical. You must be analytical. You must be leaders. Because either way, by vote or by appointment, the prosecutor is a representative of the community, a representative of the court, a representative of the system. So some of you might be looking at Attorney General Jack McCoy's actions and thinking, wow, discretion's kind of bad. Well, that discretion, that representation is under assault right now. In Mississippi, House Bill 1020 aims to create a new and separate court system. This system would allow state government officials to appoint judges and prosecutors. Let me say that again, state government officials to appoint judges and prosecutors, which encroaches on the power of local elected judges to hear the case and prosecutors to prosecute the case. The bill would also expand the Capitol Police's jurisdiction. And this is a police force that has come under scrutiny lately for aggressive tactics and multiple shootings, which has caused a lot of worry from local leaders about what all this could lead to. House Bill 1020 puts primarily white conservative officials in control of a criminal justice system in a city called Jackson, Mississippi, where 8 out of 10 residents are Black. What's the argument against it? The other side says the bill is needed to address court backlogs and systemic violence. In Missouri, House Bill 301 would allow the governor to control and strip locally elected prosecutors of their power. The bill would allow the governor to appoint a special prosecutor for 5 years if the number of homicide cases in any jurisdiction exceeds 35 per 100,000 people. The power that would be given to this special prosecutor allows that special prosecutor exclusive jurisdiction to prosecute murder, assault, robbery, hijacking, and assorted other violent crimes. Simultaneously, the state attorney general is attempting to move the city of St. Louis prosecutor from her office. The AG suggests neglect. The state prosecutor suggests something else. For our purposes today, finally in Georgia, Senate Bill 92 aims to create an oversight committee that can remove prosecutors from office. This has been criticized as a move by the Georgia GOP to remove woke policies. It's also removing prosecutorial discretion by criticizing those that choose not to pursue certain criminal charges. I'm going to stop at this, but the same language that you see in the Georgia bill, you can see in the Missouri bill. You can also see in Florida. You can also see in Indiana. You can also see in Pennsylvania, which is why I suggested to you, this is all under attack right now. And that is why, as leaders, you must think deeply about whether prosecutorial discretion is good, is bad, or is something in between. All this means that you must lead now. I'm going to give you, I know you've been working with hypotheticals for this entire competition, so I'm going to put another one to you right now because I just want you to think about how you would react to that. Now that we've had a deeper discussion about prosecutorial discretion and how you might exercise it, because I have every reason to believe that soon I'm going to be looking at a case record, or I'm going to look at the newspaper, and I'm going to see your names as the prosecutors. I'm going to see your names as the defense counsel. I'm going to see your names as the judges. So in preparing you for that soon, very near future, let me throw another hypothetical at you. I'm going to read this one to you, and it's from a law review from a professor, Jeanette Hopeful. And here's the scenario that we have. On March 2nd, Michael Girardi took Connie Babin out on their first date to the Port of Call restaurant in the French Quarter of New Orleans. After dinner, they were walking toward the car when 3 Black teenage boys walked toward them. One teenager approached Girardi, who yelled to Babin to run. She did, but turned around to see the teenager shoot Girardi in the face. 3 weeks later, Babin positively ID'd the 16-year-old Sharif Cousin as the gunman from the photographic lineup. The public pressure to convict was enormous. Most residents of New Orleans no doubt remember hearing of the crime. An innocent person shot in the face after leaving a very popular restaurant. Evokes the sentiment that it could have been any one of us. I want you to stop for a moment there and check what your feelings are, what your thoughts are. If you're handling this case, especially as the prosecutor, since we're talking about prosecutor discretion, where are you? What are you thinking? What are you feeling? What is your gut telling you at this moment? I want you to sit with that for just a second. All right, now let's add some more on to what I've given you. And I want you to continually think about, really check how you feel and what you're thinking. At trial, the prosecution's case consisted of Babin's positive identification and 2 tentative photographic identifications of Cousin. One by a cook who had seen 3 Black males loitering nearby about 30 seconds before the shooting, and the other by a member of a tour who saw 3 Black men running away after the shooting. The defense presented a powerful alibi consisting of a videotape of a basketball game showing Cousin playing basketball the night of the crime. 2 recreation department supervisors, Cousin's coach, and an opposing team player all testified that the game started and ended late. And the coach testified that he dropped Cousin at his home at 10:45 p.m. The shooting occurred well before then, and Cousin lived across town from the crime scene. Nonetheless, the jury convicted Sharif Cousin of first-degree murder and sentenced him to death. In 1996, he became the youngest member of Louisiana's death row population. All right, this is moment 2, where I want you to stop and just sit with yourself, what you're thinking, what you're feeling, what your gut telling you. And now let's add some more. In his zeal to convict Cousin, Roger Jordan, that's the prosecutor, did not inform the defense that on the night of the murder, Babin told the police that she did not get a good look at the gunman's face and probably would not be able to identify him. And that in an interview 3 days later, she said that she was not wearing her glasses or contact lenses on the night of the murder and could only see patterns and shapes. Sharif Cousin was fortunate enough to have the help of a tenacious, no-holds-barred, bridge-burning capital defense lawyer, Clive Stafford Smith. Because of his attorney's involvement, exculpatory evidence was uncovered, leading to the case's ultimate dismissal and a civil suit against that prosecutor, Roger Jordan. Roger Jordan, that prosecutor, was awarded absolute immunity, however, and the suit was dismissed. In 2004, the Louisiana Attorney Disciplinary Bar cleared Roger Jordan, that prosecutor, of misconduct in connection with the Cousins case. Scores of judges and lawyers, including defense attorneys and prosecutors, testified that Jordan was a professional and honest prosecutor. Now that you've had 4 different moments to kind of sit and think through, to feel all that occurred, I want you to realize how important it is that you engage all of those characteristics we just talked about. A level of critical analysis, right? A level of curiosity, that you take nothing for granted, that you think deeply before you jump to any conclusions, because again, you are our leaders today and in the future. I'm willing to bet that some of you are already doing this. You're already engaged as leaders in ways that I can't even imagine. But for those of you 9th through 12th graders who still need a nudge, you're like, I'm not old enough to be a leader. I'm not there yet. I'll get there soon enough. I want to give you a gentle nudge, just a gentle nudge, because I believe in you as a leader. And that nudge is based on what I'm about to tell you about my son. My son is 8 years old. He goes to a school where the kids in his building are preschool through 2nd grade. He is in 2nd grade. And I regularly remind him how before this school year, he always referred to the 2nd graders as the big kids. He is now the big kids, meaning all the younger kids, which they call the littles, are looking at him and his 2nd grade friends as the models of how to act, the models of how to look, the models of what to do. He can choose to ignore that reality, that the littles are looking at him, or he can say, I am responsible. responsible for modeling how the littles need to act, how the littles need to look, what the littles need to do. You all are 9th through 12th graders. At a bare minimum, the kids preschool through 8th grade are looking at you, even when you don't know they're looking. And for some of you, you can probably remember back before you got to 9th grade and remember how you looked at the older kids. So you have a choice. You can say that's their problem. Or you can say, I am responsible for helping define the future of my community. I am responsible for helping others reach their goals. I am responsible for helping the littles know that in just a few short years, they could be arguing in the 2033 Virgin Islands Bar and Judiciary's 39th annual moot court competition. What message did Attorney General Jack McCoy send to his community? What messages are our elected officials sending when they do not lead with, I am responsible? What messages are you getting from the leaders right in front of you today? All the attorneys and judges and justices that were part of your moots? From Attorney Kaczynski and Attorney Thorpe, who were key to making today happen at all, to Judge Wilma Lewis, who I saw led off the day this morning. Why do I bring up Judge Wilma Lewis? Because when I became an assistant United States attorney in Washington, D.C., guess who hired me? United States Attorney Wilma Lewis. She was a leader then. She is a leader now. She was somebody I looked up to and I wanted to serve under. She has exemplified that for years and years and years. So what message will you send if you lead with, I am responsible? Prosecutorial discretion, the exercise of power, will only work for your community and your career if you lead with, I am responsible. And with that, I want to open it up to questions, observations, thoughts from all of the 9th through 12th graders who see things that I can't fathom, who have experiences that I just don't have anymore. And so I'm begging you all to tell me, what have you seen? What have you experienced? What do you want the adults and the other 9th through 12th graders on here to know about what you've seen for others accepting responsibility, or that you've done yourself in accepting responsibility, so that everybody on this knows that they're not alone?
If you want to raise your hand electronically, or if there's someone who wants to just speak up, you can unmute and speak. No real regulation as to how you respond to that. I can also just go Socratic method and call out specific schools. Certainly after watching this, I can think of a few that I would want to ask the students. So by all means, jump in.
I thought about doing the Socratic too, because that's what I do in class. So if somebody does raise their hand, I've got them right on screen.
Yeah. Having no volunteers, I would like to ask the students at St. Croix Central if they have any response to that. St. Croix Central? They are not jumping on, I see. What about Antilles? Sulaine, do your students have any comments?
Adam, I have to admit, we were outside the room. What were you asking about?
Do you want to repeat your question?
So,
Yeah.
so I'm curious what your students have experienced and what their vision is, what their desire is when it comes to what is happening in their world, 9th through 12th, with regards to their responsibility. Are kids taking responsibility? Are they not taking responsibility? In what ways are they seeing it done or not happening? And what would they like to see?
You want to take a shot? I now have gun shy advocates all not willing to say anything. And I don't work with them outside of this time, so I can't answer for them.
So like Attorney Thorpe was suggesting in law school, which I know everybody in this event is going to head to law school very shortly, we use the Socratic method. So I don't get to, well, they get to raise their hand if they want to, but they also get to get called even if they don't want to. So I'm going to leave it to you to call on whichever student you think might provide a good answer for the entire group.
Aisha Kamani. I nominate Aisha Kamani.
There we go.
No luck, Sulaine?
No.
Okay, we won't force it then. I have to say that even without the feedback and interaction.
To do everything, but
Talk about the parents' responsibility.
No, this is about the kids, honestly.
Sorry about that.
NC Studio has a hand up.
Oh, okay. Let's unmute them then. NCC, yes.
Good afternoon.
Don't worry.
My name is Aiden Smith. I'm representing St. Croix and the Elementary School. Well, for our age group, we do a lot of stuff, especially the 11th grade class, from being the main proponent of our student government at events at school to planning a whole bunch of other events, from pizza sales to fundraisers to assisting our drama teacher in creating and presenting stuff. Even a few months ago, down to we had a concert at at Complex actually. Actually went really well. One of our students, Hazian Duran, she helped plan and execute a lot of the things, including the dress down to everything. So our students at Adventist School, we are involved with a lot of things that happen. Those are responsibilities.
It was Mr. Smith, right?
Yes, sir.
Mr. Smith, I love hearing what you just said. That is incredible to hear the way that you're involved with your school. And it also sounds like you're involved with folks who are not necessarily at your school. I hope a lot of that, I wasn't sure I caught the middle part, but I hope a lot of that has to do with the kids that are younger with you, right?
Our school, a lot of the members of our school in 11th grade were members of are part of our church called Pathfinders. We're like junior counselors, choir members, stuff like that in our churches. So those are other responsibilities that we do have.
I've heard wonderful things about the Pathfinders organization, and I'm so glad to hear it sounds like you're involved in so many things where you're showing that level of responsibility both for yourself, but displaying it as a marker for others that are coming up behind you. So I appreciate that. I love knowing that somebody who's in 11th grade is doing all that, because my kid is a few years behind you, but he's not that far behind.
Yeah, okay. I was going to say, I was doing the math. We have 2 10th graders and 4 9th graders in this year's competition who actually participated either in the district or championship. And that's in addition to the teams having non-participating members who are learning through this. So we have a lot of 11th and 12th graders taking the lead and setting an example. And I can't help but think that it's invaluable for these 9th and 10th graders to have watched And there are ninth graders competing today. There are ninth graders who actually advanced to the championship and are on here today. And so, I think that your remarks fit perfectly in this. We didn't talk a lot about executive power, and you really filled that gap, and it didn't come up in the arguments, and it often doesn't. That's not really a judicial analysis, but the statute itself put the focus on what the executive branch did. You know, did the police officer investigate? And if they didn't investigate, did the prosecutor really do its job and meet the burden? And if this legislature did this, does this do justice? Is reading this statute this way justice? And that circles back to what I said about wanting to, thinking and considering and expanding the law library, because from the very beginning, when affirmative defenses were a concept being discussed, it was challenges saying our Constitution is fundamentally different than what they have in the UK. And therefore, affirmative defenses are fundamentally incompatible. And they did not translate from the common law of the UK to the common law of the United States. And that all goes into what is the role? What is the presumption of innocence? And what is the burden of proof? And so I think you filled in the thought processes that the students were probably lacking when they read this problem and wanted to criticize the prosecutor and wanted to criticize the police officer. And so with that, I thank you very much. I do want to get to announcing scores, but Judge Lewis, if you're on, I want to wonder, do you still stand by your decision to hire Professor Jackson? Is she going to pop on at all? No, we'll wait for her if she does. With that, Judge Brady, you're welcome to turn your camera on, and DJ, you are more than welcome to stay online. I would like to reiterate a few things. Well, not a few things, but just one. I want to remind everyone what I started with at the beginning. Rob and I need to look at succession planning. I'm not necessarily a hard out after the next year, but Rob is now will have finished his 4th year of having wanted to be coaching and not being a co-chair. And his is going to be a hard out. He wants to coach, and I can't help, resent that. I would love for him to stay and continue. So we do want to encourage everyone. We're looking for assistant co-chairs, we're looking for coaches, we're looking for committee members. If you have any attorneys or paralegals who would like to volunteer, off-island attorneys, we have roles for you as well. Also, since we are here, if you are interested in donating to support the program, www.usvi.org/donations. You can go there to contribute. If we had every member of the Bar Association donate annually just $10, we would actually fund all of the scholarships for the program. Which takes me to what the students were actually competing for.
Judge Lewis is on, by the way.
Oh, okay, Judge Lewis, by all means.
Good afternoon again. So good to see you, and what an inspiring message that you brought. And I'm so proud of you. I was in and out, but I heard when you talked about my hiring you, and I was so proud to know that I hired someone like you. And the trajectory of your career has been amazing. So thank you for being here. Thank you for sharing with the students. One of the things that you said that I caught was the notion that even these students not only have to be responsible, but the notion that folks are always looking. That is something that I have found out in spades in my career. People are always looking, both people who are looking at you as a role model and those who are looking and who might be able to provide opportunities to you as you move forward. So I think it was a great message. The idea of being responsible, the idea of knowing that others are seeking to emulate you and what you do, and what that means and how you should act, that's a great message. So thank you for that. And it's great to see you.
Thank you so much. I hope you know what a role model you were. You did everything with so much grace and in a way that most others didn't, that I was always so honored to just, one, watch you, but then work for you. You have always exemplified everything that I always wanted to be and see and hope to emulate. So thank you for bringing me on board, and thank you for doing all that you do the way you do it.
Thank you so much. Thank you.
Oh, wow, that's awesome. All right, we will now get to the part that everyone wants. For the record, this is the part I like the least. I consider the program goals to be that we provide the students the opportunity to learn new skills in oral advocacy and analysis and debate so that they can engage in public speaking and present it and gain confidence by gaining a new skill and having a safe environment in which to try and fail successfully. And in what I watched today, every student accomplished that. All of the program goals have been 100% marked off, and you have ticked all the boxes. Unfortunately, my view of this is not the predominant view, and others prefer to have rankings and scorings. So we are about to announce individually, you will be recognized for the top 6 places. The best oralist will receive a scholarship of $1,250. The first runner-up will receive a scholarship of $925. The second runner-up will receive a scholarship of $750. The third runner-up will receive a scholarship of $250, and the fourth and fifth runners-up will receive a scholarship of $100 each. The team placements will be first through fourth, and varying. This is the fourth place, and it's the only one that the cat will fit on camera. The others get much bigger. The first place team will receive, to be divided among the members, $1,500. The second place will receive $1,050. Third place will receive $900, and fourth place will receive $675. And with that, I would turn it to my co-chair to announce what we've all been waiting for.
All right, everybody, good afternoon. Talk about here being a captive audience. Before I just start, I'm not going to belabor this. I just want to highlight the people that probably received the least credit. And I just want the students to thank again their coaches for putting in the time, because they couldn't have done it without the coaches. So please thank your coaches at the end of this or now, and then thank them again afterwards. So let's get started. I'm going to start with best oralist, or I'm going to start with the oralist going 5th runner-up and up. So 5th place, or 5th runner-up is Aisha Kamani from Antilles School. 4th runner-up, Carmindi Pickering from St. Croix Central High School. 3rd runner-up is Eden Smith from Seventh Day Adventist. 2nd runner-up is Wyatt Bracey from Good Hope Country Day School. 1st runner-up is Giovanni John Pierre from Charlotte Amalie High School. And the best oralist for the 2023 Virgin Islands Moot Court competition is Taisha Alfred from Good Hope Country Day School. So I'll give everybody an opportunity to applaud in their respective rooms. And an opportunity to thank their coaches again.
Yes, please thank your coaches. We could not be here without them.
All right, and for teams, 4th place is St. Croix Central High School Appellants Team Resilience, making the team of Carmindi Pickering and Hakeem Couture. In 3rd place is Antilles School Appellees of Angeline Narns and Aisha Kamani. And in 2nd place is Seventh Day Adventist Appellees of Eden Smith and Danny Phillip. And your 2023 Virgin Islands Moot Court champions are Good Hope Country Day School Appellees of Taisha Alfred and Wyatt Bracey.
Wow, congratulations, everyone. You should all be proud of yourselves. Well, that is another year over, everyone. Judge Lewis, you're free of us for another year until we bother you to do the welcome again next year.
Always my pleasure. Always my pleasure.
Thank you so much. Judge Brady, you get at least another 5 years off from having us contact you again. So, we will be in touch, and thank you so much. And Professor Jackson, thank you. We may call on you again, we may not, but I definitely hope to get you down here for some CLEs along with Professor Ellis. Maybe Judge Lewis and I could talk about the district court conference and getting some CLE panels put together.
Would love
Sounds
to.
Great. Sounds great.
All right. Have a great day, everyone, and congratulations, everyone. And thank you, coaches, for it all. You are the reason this program exists.
All right.
Thank you.